Hello, hello. That needs to move. How do I move that then? Anyway, it doesn't matter. Hello, beautiful people. Hope you're all well. I'm having a mate. I opened the wrong stream, so I was live. I genuinely was live. Well, I thought I was. Well, no, I was live, but I didn't know where, how. Anyway, it doesn't matter. The wrong stream, but I'm here now. Right stream. How's my audio? How is everything? How is everybody? Sarah P here. Welcome, Mary. Mary, quite contrary. Mary, lovely to see you. I cannot no longer put chat on the screen. Well, I think I can, but not. But I know it distracts people. The chat box. Here you go. Okay, no, it might be me. It might be me. Let me turn the chat box off. Um, Let me just. This is the only second time I've ever done this, so I have to just try and get used to it, right? Let me just see if I got the right everything properties. This is the one I want. Yep. Okay. It comes off spin wheel fine. This is weird for me, genuinely weird. If you saw what I look at, it's not the same as StreamYard. But anyway, let's have a look here. Who we've got? So, hi, Mary Viviano from New York. Hopefully, you're still here. I'm not sure if you are or not, but hello to you. Welcome, Sarah P. She is up and ready. She pissed the bed this morning. She must do. Here she is. Welcome, everyone. Thanks for joining. Please hit that like button. I see 7 people here, 4 likes or 5 likes. Um, please subscribe and please hit that notification bell. So welcome Mary there. Become a blue wench. If you want to support the channel, please become a blue wench. We all love blue wenches here. So please become a blue wench. Just literally press that join button or the link that Sarah has put in the chat, and you can do that. It means the world to me if you can be a blue wench. I think it's $4.99 or something a month. You get members only videos and access to our Discord as well. I think it's well worth the money, I think. John P's in the house. John. How we doing, John? Hope you're better. Um, Hi, Dylan. Hi, Sarah. That's better. Thank you, Sarah. Yes, I am here. Hello, Mary again. Um, this is different. So I'm on Streamlabs, so I don't get the whole what do you call it? I can't put chat on. If you know what I mean. I can't put like before I could put chat on the bottom. I can't do that anymore. I can't do that anymore. And it's weird. I don't have Streamlabs chat. I have the same chat as you guys now, so I can't do it. Um, let's try and pin this one then. From Sarah P. Can I even pin? Hang on. Let's go to this one then. No, wrong one. It's all I'm a newbie on this, so I'm trying to get used to it. I can pin. Oh, there we are. I can become a blue wench. I'll pin that one. So we are 7 minutes away from the stream actually happening. I will get the stream up ready because why not? Why not, innit? Why not? Let's get it ready. And I'm trying stuff out. I still haven't got the membership goal thing working yet. We've got 4 members so far. I'm doing it till the end of October. We have more than that, but do you know what I mean? Hi, Lou. Lou, did you see my trailer? Oh, has everyone seen my trailer? Hang on, let's play my trailer. Let's see if I can play my trailer here. I posted it. Please, on YouTube, can you please go and share my trailer? It's the Matt Moore trailer. Alright, what do I do now? I'm in the wrong place again. Here we are, I'm here. Right, so if I go in here, my channel, let's see if this works now. Videos. Pause it there for a second. Right. If I just put, we'll go to the actual thing in a second now. I'm just window capture. Let me make myself a little bit smaller. So this is the trailer for Wednesdays. Here we are anyway. You get the gist of it. You get the gist of it. I hope you all like it. Johnathan, hello John. Nice to see you, my friend. Um, but I'm excited. I'm excited for Wednesday. It's on Twitter. I've promoted it on Twitter. Hopefully, people can share it. It'll mean the world to me because I'd love to get people here. So you'll see some different faces. Very gisty. You've seen different faces. So we have for the next 8 weeks, we will have a talk with Sally. So she's joining us every week to co-host, along with our very favourite Dr. Hines. He'll be here every Wednesday as well. So the three of us will be doing this together, and we will have Lady Law every Wednesday at the end as well to um to recap it. She'll be working, but she'll be listening um, during work, and then she is going to come on then and give us a recap. Matthew obviously is going to be here for whenever. I'm not putting pressure on him whenever he can, but he will definitely be here when the final episode is. So that'll be cool. Hang on, let me just. Oh, the lawn crimes behind me. Trailer's great, thank you. No worries, Jonathan. Hey, Gisty. Who is Sally? Sally is new, so she's big on Twitch, but she's started to do stuff on YouTube now. She's more political than anything, but she wants to get her feet wet in trials, basically. So I'm ideal for her. She was looking for so she's been on Vices, Legal Vices. She's friends with Legal Vices, and she doesn't want to start doing trials on a huge channel like that. So I knew she was looking for a smaller channel. I reached out to her, spoke to her a few times on Twitter, and I reached out just on the off chance, and she jumped at it. She literally jumped at it. Lou, you'll have plenty of time to ask questions to her. When she's on, please ask her questions. Please, I don't know much about her except that she's very political. She's big on Twitch, big on Rumble, but she's very new to YouTube. And she's not very experienced when it comes to trials, but she loves true crime. She loves trials, and she wants to, dip a toe in the water with it. So thanks, Sarah. Hopefully, yeah, the trailer is good. Hopefully, we've also got some other special guests lined up that will be popping it in and out. Um, Depends on workloads and stuff like that. Solomon will be coming on. Not every week, but whenever he can, he'll be popping on, or he'll be in chat as well. So that's good. And yeah, there's a few others that might be lined up as well. So I'm just keeping it open ended. I don't want to announce people and then not to turn up and stuff. So I'm excited. I'm excited. Hopefully, you guys are excited as well. Um, we're also trendsetters. We are absolutely. So since I did the interview, apparently everybody wants an interview with him now. Um, he's going to be doing interviews with podcasts and stuff like that. And yeah, we're trail setters here. Everyone wants to copy us. So that's a good place to be, I suppose. Pisses me off, but it's a good place to be where everyone wants to copy me. So welcome, to our community where people copy us. So this trial, though, let's get in. That's enough about Matt Moore for now. I've sent in the trailer as well. We will go in. Where are we? I'm not used to Streamlabs. I'm still not used to this Streamlabs business. So you have to bear with me a little bit with it. They are coming back at 1:15, so they should be here. Because this judge is very, very good. Very, very good judge. So let me see. Yeah, the actual. So just so you know, if you want to go away and come back, the actual sentencing period starts in 45 minutes, basically. There's, I think they said that there's 15 people for the state going to give statements, and as of Friday, the judge was very insistent that the defendant gets. Um, I'll come to you now, Lou. I'll come to you. Okay, I'll answer it now. So, Lou, he literally was found guilty in about 40 minutes, if even less. So they went. The jury got it about say 10 to 5, right? They got the whole thing, say. So I'm guessing something like that. So by the time they walk in the back and obviously get all the documents there and stuff like that, essentially the stream came back on at 10 to 6, and that was normal because the judge said, "I want you all back by 6, um, because we want to know what you want to do, whether you want to stay on tonight, whether you want to come back tomorrow and stuff." And then Erin Hack said, "Oh, there's a verdict." I said, "No, no, there's no verdict. I mean, it's ridiculous. It can't be a verdict in this amount of time. There can't be, because you've got to get all the everyone there. Um, but yeah, it was a verdict. I couldn't believe it. Mary, the judge is not sentencing; it's the jury sentencing. So the defense, according on Friday, the defense have got 15 members to speak. The defendants had, I think, one or two, but the judge has now allowed, and I like this by the judge, right? He allowed that he asked the defendant, um, do you have everyone here that you want to speak? And he was like, well, no, not really, but I understand that some people we can't get him here. And the judge said, well, there's no reason why not to. So the judge has said that he will allow people from his side, from New York, to come over, or if they can't make it, they'll do it on screen, like whatever. So that was total shock to everyone on Friday. The judge allowed that, but I think it's good that he's allowed to have people speak on his behalf. This is what should have been happening in the Zachariah case. So that's up. So I'm not sure how many witnesses he's got either. It's not witnesses, but testaments. Um, So yeah, that's where we are with that one. Oh, it's here. Sorry, it's hiding from.
they support him
Hang on,
and love him and who they are with respect to their name and relationship with the defendant. Um,
no worries.
that's a lot of folks, Judge, for us to give. We have represented back over the weekend that the state has thrown out a different procedure. If they agree to this, we won't lodge an objection. This is all cumulative. Um, recognizing why, it is late notice. I'm not blaming the defense for that, the way this unfolded. However,
I mean, when you say wait unfolded, what do you mean by that?
well, Friday, the court required, it sounded as the counsel I know, these are witnesses from New York that he felt like couldn't testify because they couldn't afford or didn't have the ability to fly down here. So we put on the record, the state did that.
Can you all hear it?
We would agree whatever method the court's done that. The court has been over backwards and making sure.
I can't hear it. That's what I'm gonna put the extension on.
Those two or three folks can testify. Well, now there's 8. We have asked if they would call
Hang on, something's not right here. Hang on. Hang on. I've done something wrong here. Bear with me. I need to make sure that what have I done wrong here then? Because we can't hear it. What do I do? Oh, no wonder it's not bloody plugged in. Sorry, hang on. I do this every time. What did I plug in then? I need to check these things. Tell me, guys, tell me. I do this every bloody stream. Oh, also, where's Erin Hack when you want her? I got my crown. I got my crown. Right, I'm back. Let's go. I still haven't got my tutu though.
Present, because apparently they're all together.
No, they're not.
Okay, then I stand corrected. But the state who would make the same representation
Like
8
Sarah.
times, putting their relation in the record, that accomplishes one, all of their names being during the presentation. But nonetheless, if the court
Thanks,
does
Mary.
allow them, but 8 folks on Zoom, again, I'm not blaming the defense, but we've not had a chance to speak to them or propose them, obviously. We would ask that, first we would just put an objection on the record. Based on what they're telling us now, obviously they say different things that obviously can be overcome. Just for purposes of the record, I just want to put all on the record as that issue. That's where we are with respect to this folks. Second, Your Honor, I just want to put on the record, I know we had a little bit of email communication over the weekend. The state of Florida is abandoning the aggravating factor and engage in a commission of aggravating factor. That's a visit on the record.
Like the video, people. Like the video. Please.
We're doing that because we believe the aggravating factor, the first
Put the crown back on a bit.
prior
Let
violent
me.
felony. As to count 1, we can argue counts 2 and 3 apply. As to count 2, counts 1 and 3 can apply. So we're
I know, John.
we
I
it
know.
cleaner, takes away from those two aggravating factors merging, then requiring a merging instruction. For multiple purposes, we're abandoning the engage in the commission of aggravating factor moving forward. So we will have 6. Also, for the record, we did the thought over the weekend on the especially heinous, atrocious, and cruel. We're asking to keep that. We are going to pursue that and argue that. And I think the one other thing the court did ask us was which aggravating factors apply to which count. All apply to counts 1 and 2, both first-degree murders, with we believe the exception of HAC. We are not going to argue HAC to the unborn child. Our argument is strangulation.
Okay, time out. Let me make sure I get this right.
Yes, sir.
So, HAC, aggravated factor number 3, this only applies count 1, correct?
Yes, sir. Yes, sir. That's correct.
What I'm telling the jury is, I'm going to tell the jury, here's all the aggravated factors alleged by the state. Then I'm also telling them, following aggravated factors apply to counts 1 and 2 unless otherwise noted.
That's correct.
So, for example, HAC would be the first one where I'd say, tell them first-degree murder was especially heinous, atrocious, or cruel. This only applies to count 1. That's what I'll tell the jury. The verdict form will, of course, reflect that. So give me a second.
I am as well, dude.
Count 2 verdict form, taking out the heinous, atrocious, correct?
The state agrees. Yes, sir.
Okay.
Yeah, I'll be completely honest with you guys. I don't mind if you don't agree with me, but I could never, ever give the death penalty here. Because of what just Lou has just said, death penalty for no body murder conviction. I can't. That's just, I know from the UK, but that's my personal thing. I don't think I could.
Okay, so you may go. Continue.
Yes, sir. And then, so just for the record, so the
Yeah, okay,
first aggravating
Johnathan.
factor, the previously convicted of another felony involving the use of threat of violence of a person or arguments to both. The second one, the committed for the purpose of avoiding or preventing a lawful arrest. We're going to argue as to both. As we just said, HAC will be only as to count 1. The fourth, TCP, full calculated and premeditated aggravating factor, we're going to be arguing for both, and then have intentions to kill both. As the fifth one, the victim of the capital felony was a person less than 12. We are only arguing that for the second count, obviously, the unborn child. And lastly, we were arguing for both capital felony that was committed to someone who's particularly vulnerable and is in a position of familial or custodial authority over the victim. We can argue that as to both. So ultimately, in some, the third HAC and the fifth victim under 12 only apply to one respective victim. HAC only to the IS, and victim under 12 only to the unborn child.
So in total, it looks like there's going to be 5 aggravating factors alleged as to each victim.
That's correct.
Okay.
There's 6 total, but yes, there are 5 as to each. That's absolutely correct.
So the last one being vulnerable due to familiar or custodial relationship. As of Friday, you weren't sure that was going to both counts. Now the state is alleging them for both counts.
We have thought about it, Your Honor. Factually, witness believe it's all through the wire that was his child. So when he's caring for him, he's in his home. Also, our argument will be he's also custodial authority over her, his unborn child, as he thought. So yes, sir.
Okay. So in the final instructions, there's no need for me to tell the jury.
Oh, Shasha Bum.
Aggravating factors, correct?
Hi, Sharon.
Yes, sir. We are not asking for none of these that are left merge. There's no need to now.
Hope you're well, Sharon.
Murder, anything of that nature. So yes, sir, we believe it simplifies things, and the court has that correct.
Anything else you wanted to address?
A moment. I think the court wanted to talk about contemporaneous versus previous language.
Yeah. The reason why I included the contemporaneous language is that in instruction 7.10, I'm reading straight from it. Defendant was previously, and then in brackets, or contemporaneously convicted of another capital felony, a felony involving the use or threat of the use of violence to another person. In this case, he was contemporaneously convicted of the first-degree murder. It's not a prior sexual battery conviction that the state's relied upon. That's why I use that language. I understand how, if it's previous, it's certainly similar to the first aggravating factor under the statute regarding the prior conviction.
Yes, sir.
And so that's why I put contemporaneously, because it's provided in the standard instructions.
Yes, sir. Our only concern was that the actual statute itself doesn't say contemporaneously. However,
well, as of today, he's been previously convicted of it now.
yes, and that was going to be our argument that you convicted him Friday of those other 2 counts. So if the court wants to give that, I would want.
Hold on a second. So you want previously?
The state would ask to do previously or contemporaneously, so long as the defendant agrees and does not object. That's so.
Defense, give a position. The statute says previously. I'd rather stick to what the statute says. I'm not sure why the standard instruction includes language the statute does not include.
Well, and I was going to stick with the statute, Judge.
Okay. I'll just put was previously.
And would the court make sure the defendant himself agrees to that?
Agrees to the language in the statute?
Yes, sir. Because of the discussion we just put on the record regarding the alternative, he's not requesting the same. If he does, we would say the previously or contemporaneously, but if he's fine with or previously, the state is obviously.
It's a bit of a legal issue. I'm not sure you even have the legal knowledge to understand that.
That's.
Or understand the distinction on the statute.
He's fine with leaving it with just previously.
State
I
agrees.
think this is going to be tough.
I'm changing all the instructions and the verse forms.
I think this is going to be tough, guys.
But your argument is going to be that the prior conviction is the sexual battery.
Well, no, sir. Our argument is we have to count 1. They found him guilty of counts 2 and 3. So counts 2 and 3 sort of play in count 1.
Understood.
And then count 2, we're going to argue 1 and 3.
So you can argue the other murder as a prior felony under that aggravating factor?
Yes, sir, because they convicted him on Friday.
Okay. Makes you wonder why you wanted to proceed. Well, never mind. I'm not going to get into that. Okay. I made any changes on the
Hannah.
verdict forms and the standard instructions for both preliminary instructions and charging instructions, which I will send a copy to everyone as well once we finalize all this. I need to change the language for the last aggravating factor. What I can do is that the victim's name is going to be
Hiya, Hannah.
the instruction regarding vulnerability due to their familiar custodial authority. What I may do is just have it language for IS and say this applies to count 1, and then have another paragraph that says that for the unborn child that this applies to count 2.
Yes, sir. State agrees.
Sandra was gifted one, yes.
Judge, just for purposes of the record, I understand how the state is proceeding on the last aggravator, the familial.
Let's go, Sandra.
We would object to it as Mr. Quiles was not in
Hi,
a
Ace.
familial position over IS at the time. He's not her
Welcome,
father,
Ace.
he's not a caretaker or caregiver. I mean, she did go over to his residence, but he was not in a familial capacity to her.
Well, the statute says familiar or custodial.
Just over.
Thanks everyone for joining me. I'm still trying to get used to this Streamlabs business, so bear with me. Oh, diolch yn fawr. Okay. If I do that, I don't know what to think about this one because the whole. Right, Hannah, I'll explain it to you because I like Hannah, so we'll explain to Hannah. So they're still discussing a minute what the charge is going to be for the jury, what the instructions are going to be for the jury. Um, in half an hour, we're supposed to start testimony. So I think there's 15 on the state side, about 8 or 10 on the defense side, I believe. I could be wrong though. And that started in half an hour. So we still got half an hour. They're just going through the instructions for the jury for the penalty phase at the minute. Um, so we'll see. So that's where we are. We're just talking crap at the minute. But I don't know if I could give death penalty, guys. I don't know. Maybe because we're from the UK, I don't know. I need more than what we've been given. Um, Oh, the alternate corner gifted a membership. He is awesome. If you don't know the alternate corner, he's a very sexy guy. He's one of the best. So welcome Sandra44 back to the club, the Blue Wenches Club. Welcome back, Sandra. Lovely to see you. So yeah, here we are. And that's the recap basically. So just so people know, it's not the judge doing the sentence, it's the jury doing the sentence. Um, or I believe they're deciding if it's death penalty or not. After that, I don't know. They might do a recommendation then about level sentencing. I don't know to the judge. So here we go.
Objection, Your Honor.
Understood. He was also found guilty of sexual battery in a familiar or custodial relationship as well by a jury, so the jury can make that determination if they believe it's familiar or custodial or not for either IS in count 1 or the unborn child of IS in count 2. So I'll leave it up to the jury, but if you need to make a motion at some other time during the pendency of phase 2, obviously you're more than welcome to make those motions or arguments throughout the pendency of the second phase.
Yes, sir, Your Honor. We just, for purposes of the record, we want the objection noted for.
Oh, am I crying
Okay,
now?
and it hasn't gone to the jury yet, too, so.
Right.
Other than the defense witnesses, any other issues from the state's perspective?
Yes, sir, there's one more, just really for the record, maybe the court would decide to inquire. The defense did let us inquire Dr. Rohr, R-O-H-R-E-R, on Friday. We spent very brief evidence with her in this very courtroom and sort of gleaned from her what she would be testifying about. We were not asking for any rebuttal
No.
with respect to what we anticipate to say. However,
So in Florida, for the death penalty, they need 8 yeses for death penalty. That's 8 out of 12 saying yes to receive the death penalty in Florida. So if 8 of them say death penalty, he gets a death penalty. And that's what it is in now in Florida. Now, listening to what they're saying now, I think there might be a psychiatrist coming on, a doctor coming on to speak about whether he is sane. Lou would probably know the terms properly, but like if he is fit, or if he is mentally unstable or something, from what I'm hearing there. So I think that there'll be a doctor be questioned by the defense and the state as well.
she did, I asked her to sort of, in her testing, pull out some personality traits that she found in the defendant. She used terms like egotistical, self-centered, narcissistic.
So with John,
things
so
that
good.
I will listen across. I just want to make sure that I'm sure the defense has made their own decision about whether to follow her. I believe they are. So at the moment, but if they do, I just want to make sure the record's clear. We are listening to that. And that.
Is this information that was in her report or things that you gleaned from her?
Yes, sir.
Well, hold on a second. Let me finish the question. Just for the transcript. Are these issues or information that was gleaned in her written report or things that you got from her via deposition or through interview of her?
You know what, we were asking her to define terms in her report and asking her, and sort of summarizing her opinion that she wrote in her report, what types of conclusions that she determined regarding his personality traits. She started offering them. So while she doesn't write every single one of those, I think it's clear in the report, what does eventually define antisocial personality disorder. As we were delving into that, that's when she started describing the personality testing showed. So our position is across. We're going to elicit that. Just want to make sure that the defendant himself is one, soliciting that, due to the fact that they're calling it, they probably made their own decision. But that's just something we want to talk about.
Okay.
We are aware, Judge.
Understood. So nothing else from the state perspective, anything from the defense perspective?
The last thing, judges, I think the court may already know, we did, or maybe you don't, we gave them 2 victim impact statements. We are intending on calling SS and
Not the mom.
sir.
Okay. For whatever reason, I just wanted to clarify because as of Friday, it seemed to it'd be the mom and somebody else.
Yes, sir. That's the 2. So we did send that very late last night. We apologize. It was probably around the 10 o'clock hour. We actually had a victim advocate staff member working with the family trying to get them to get those needed. We finally got those done. We sent those last night. Been told this morning there's some objections. What I've asked before they're read is to send to us or highlight for us what they want. We'll find objectionable, maybe we'll agree without the need to discuss any further, but we just haven't seen that yet. To no fault of offense, we hard on those over. Family worked hard on those over the weekend. And we got them late last night.
Just to be clear, Dan, we only received one. There's only one on your attachment.
Were both documents in the same attachment potentially?
No, Judge.
No, one is clearly just SS.
So the record's clear, I'm not handing the photo, just again, for the glimpse. One's about 2.5 pages, and the other one's from SS, double spaced, about 4 pages.
The one from SS we have, the one from,
All it takes is,
we did not get that one, Judge.
Did she testify at trial?
she did not.
That's ID's mom?
Stepmom, Your Honor.
Stepmom, that's right.
Yes, sir, Your Honor.
Okay. I'm supposed to have a jury in front of us in about 20 minutes. How are we looking?
I'm looking through my email, and just for the record, we did receive an email from Mr. Skinner at 10:02 p.m. last night to Bob and I saying here is one, and it attached the one that we have had a chance to review and do have some objections to. I'm looking now, I'm looking in my spam. I do not have another email from him with this one, so having just received that, Judge, I would like the chance to review that. Obviously, it's going to take longer than I think 20 minutes to line item that.
Or if that didn't go to our mistake, I will send that, giving them a hard copy, I will go ahead and copy.
Who are the 8 people from New York you're trying to call off this list? 8 to 9, however it may be.
Yes, Judge, and just to confirm, I did speak with Paulette, who is the defendant's mother, or aunt, but in a mom type of position. She did email me this morning and let me know those who could for sure be present. As you're aware, on Friday when we found out about the Zoom, I just asked her to give me the list of people she thought would be appearing so that I could provide that to the state. I did do that, but as far as who will
Can I state something? I also want to make it clear. I didn't know it was not. I didn't know it would be an issue. I didn't know who the defense was calling in the penalty phase if the trial got that far. I know there was a witness list. I didn't really inquire beyond that. I didn't know people from out of state wanted to be present but could not be present, whether it be logistical or financial reasons. I had no knowledge of that until Friday. The state didn't object to Zoom. I made it happen with the courthouse information technology people. I didn't know it was an issue. And if it became an issue, I can't imagine the state would have objected. They didn't object Friday. But now that's why we're in the position we're in right now.
Yes, Judge, and I had no intention of making it seem as if it was the court's fault by any means.
Sure. I just wanted to make sure that was clear for the transcript if in case it's an issue on the back end that it was not an issue that I knew that needed to be addressed until Friday, until I inquired of Mr. Quiles.
Understood, Judge, and there may just have been some miscommunication there because when we talked about using Zoom throughout the trial, the court had made it clear to those who had been appearing via Zoom throughout the pre-trial hearings that Zoom would not be available, and I think that's when we kind of said, okay, if Zoom is not available,
Yes.
then we move.
It was not available.
Right.
It's not available for members of the public to come watch the proceeding. Obviously, we had issues now with people on Zoom making sign language to your client. I was not going to allow Zoom be present during the course of a trial. It's a public courtroom. People can come watch trial as much as they want. They can probably go watch a live stream if they want. But I was not going to have Zoom be present for members of the public to come watch the trial. That's not appropriate. And nor has the Supreme Court ever said that's appropriate. They've allowed it for pretrial proceedings, attorneys to appear. Never has it been made available. And I think I've been very kind's not the right word, but I've allowed Zoom at a lot of proceedings, particularly in this case, for victim's family too, defendant's family to come present when they normally would not be able to attend certain proceedings, and I understand that. But when it comes to evidentiary hearings, when I got a job to do for a trial, Zoom was never going to be on the table. Now, for people to attend a trial to testify, that's a whole different analysis, if you ask me. But understood. But nonetheless, who are the eight or 9 people you want to call from New York?
Yes, Judge. So I sent the list to the clerk a little earlier. From that list, my understanding is that today it will be Paulette Viorette who will be testifying in person, KB, Kenneth Berry on that list, in person, Curtis Hale in person, Ishana Pugh in person, and Karen Gaines in person. Or her name might be Karen Gaines McMillan, if I'm not mistaken.
Okay.
And then on Zoom, Judge, they have tried to limit those to just 3 of the 8 that were listed to accommodate what the state's request was as far as not wanting more than that.
I mean, I haven't ruled on that. They've made an objection. I don't know what these people are going to say. You guys work.
It works. So I try to play about with this. Number of memberships gained this session 3. It works, guys. It works. Let's freaking go. So Mass, congratulations. It bloody works. I can get rid of this now, then the October one. Member of gained this. Amazing.
Work it out on your own end of who you want to call and not call. That's fine. But I have not. I've chosen not to get involved on purpose because I don't know what these people are going to say.
Understood, Judge. As far as what 3 that would be via Zoom at the moment, if there's no objection, would be Vanessa Bracity. I may be saying that wrong, but it is spelled Braccetti, I'm sorry. Let me get the exact spelling for the record. I think, or was it provided to you? Okay, great. Destiny Quiles and Joseph Quiles.
And those 3 are in New York, I'm assuming.
Those 3 are all in New York, Judge, and they would be testifying on Zoom individually.
And they're available this afternoon?
They're available whenever we need them, Judge. I did tell them to make themselves available anytime after 10. I didn't give them an exact time. I said I would let them know as we progressed exactly what time they would need to be on. I did also let them know that they would not be sitting on Zoom all day, that we would open it when it was time for their testimony, so they're aware of that. And there was one other thing, Judge.
And Dr. Rohr's the only one not on this list, I'm assuming.
And Dr. Rohr, I apologize.
Yeah.
The only other thing, Judge, is that they... Sure. And just for the record, the state would like us to put their relation to Mr. Quiles. So Vanessa Rossetti is a long-term family friend who's like in a sister type of, they grew up together type of situation. Destiny Quiles is a cousin. Niece, I apologize, a niece. And then Joseph Quiles is his brother. And I believe they know the relation of the people who are in person because they've asked that.
Okay. And so those are the 3 you guys are calling this afternoon upon your own agreement after talking to the state about the number of people from New York.
If there is no objection from the state, we would like to call those 3 out of the 8 of the names that we provided.
The state not objecting with respect to 3 when it was just represented to us over the weekend that they were going to call 8 to say a very, very similar testimony, which we felt was cumulative. If they're only calling 3, there is no objection by the state so long as the defendant is satisfied with who the defense is calling.
And Judge, just to be clear as well, I did speak to them this weekend about having them appear in a way that they could express their support, but then not necessarily all testify to the same thing. And what they have agreed to do is to state their name who they're speaking on behalf of, because some of them are like, I'm speaking on behalf of my sister, my mother, and so as well, who would be here and present and say the same thing that I'm saying right now. We agreed that that would be the way we would handle it, instead of calling each and every one of those witnesses, just to avoid that very objection that we, of course, would not try to present duplicates of this exact same information or cumulative type of information. So as long as that's not objectionable, we would plan to proceed in that fashion. We have spoken with...
I'm sorry, my fault. Please continue.
We have spoken with Mr. Quiles about presenting these additional witnesses. He did want some of his family that lived and reside in New York to be able to appear, and so at this point in time, if there's no objection, then we would proceed in that manner.
And those are the three that, the people in New York that he mentioned 2 to 3 on Friday. Obviously, that number grew. Now it's shrunk to 3, and then those 3 are testifying on behalf of other people as well. That's to his satisfaction. That's what he wanted you guys to do.
Yes, Your Honor, I think that would satisfy, and frankly, Judge, those are the people who are available, and so I think there may have been one other person he wanted, but that person is not available to do it, so they plan to speak on behalf of the person that he planned to, or asked us to get.
Okay. Mr. Quiles, can you raise your right hand? Do you swear or affirm, tell the truth, the whole truth, nothing but the truth? All right, sir, you can put your hand down. You've heard the conversation this morning regarding these witnesses, the 5 to 6 people in person or so, and that includes the expert, Dr. Rohr, and then the people on Zoom. Is that with your satisfaction and agreement?
Sir.
Okay, those are the people that you want to have testify on your behalf, and those people are going to be testifying on behalf of other people as well from your family.
Correct.
Is that what you want? And your attorneys have talked to you all about this?
Yes, sir.
They've answered all your questions?
Yes, sir.
Anything else? Anything else from the defense on this issue?
As far as the witnesses, Judge, no.
Okay. All right. Thank you, sir. So then the only outstanding issue this time is the victim impact statements for review?
Yes, sir.
Okay, so obviously I have a jury arriving here any minute. What do you want me to tell them?
Judge, as far as the victim impact statements, Mr. Davis is going to try to review and line item the one. I'm going to try to do the other right now. We're going to work as quickly as we possibly can so that we can be ready to go. If there's no we'll provide that to the state. If they're okay with striking whatever we have, then we can move forward. If there's going to be some additional argument that needs to be made, then I think we should bring that to your attention after we've had a chance to look at it.
How long do you need to review everything?
We've already looked at the one, so I think he's just going to mark what we discussed already. This is like 2.5 pages, so I'm sure I can read and start marking in the next 10 minutes, 15 minutes max.
Okay. How about I'll come back out around 10 o'clock, which is what I told the jury anyways. At that point, maybe we'll have at least one statement should be, you would think, close to being completed, and then we'll see where we're at in the other one.
Yes, Judge.
I just want to let the jury have some idea of what we're dealing with. That way they're not sitting in a room waiting for us. Just so you guys know, my office made contact with the 4 alternates. They were told to be present. Actual conversation and verbal contact was made with all 4 of them, and they told my office that they would be here by 10 o'clock for the proceeding. So let's come back out at 10 o'clock. We'll see where we're at, and we'll go from there. I will share with you guys the preliminary instructions as well. It should be complete, and I'll be reading to the jury as is. We can deal with the final instructions and verdict forms as we get there, although I probably will go ahead and share everything with you guys. That way you have everything. The verdict form should be rather complete. It has the aggravators, the states listed. You guys can look at the final instructions. It has all the mitigators the defense is relying upon. And you can take a look at that. You weren't here when I told Mr. Davis this, Ms. Michelle, but I listed the mitigating circumstances as it was phrased in the pleading. I didn't really change anything up. Some of them seem to overlap a little bit with one another. Some of them have like the same beginning, but kind of go in a different direction. So I put it as is. I didn't want to mess with anything. If you guys want to combine them or separate them out, I'll leave that up to your discretion and how you guys want to proceed in that regard. Some of them mentioned, he was 15 when he dropped out of school or something and had a child, and they kind of all talk about the same thing, but then go on a different branch off that tree. And that may be on purpose. I'm just letting you know what I did so you guys can take a look at it.
Yes, Judge.
Okay, so we'll be in recess till 10 o'clock.
Thanks, Lou. Yeah, I was just gonna say, I got my crown on. Erin's missing it. My tutu is coming tomorrow. I got an extension, hopefully coming tomorrow as well for my computer laptop. Burger King, I know. Um, it does look like Burger King, doesn't it? So, I've got thank you, Jonathan. Thank you, sir. So this is Streamlabs. To prove its long legs. Itch. I'm starting to itch now. I don't know my beard. Oh, I'm my legs now. This is Streamlabs, so I'm trying to get used to Streamlabs. So I figured out now that I can put it at the top every new members per session, which is handy. But I can also put top donator, top member gifter, top, loads of stuff. So I'm glad that works. I've been fiddling about. But on Wednesdays, I'll be going back to Streamlabs because I don't want this fast when I got guests and stuff on. So, um, King Charles called for privatised military compared against countries in debt. That was up to I don't know. The only thing I find annoying with Streamlabs compared to StreamYard is you can't put chat up. Do you know what I mean? So if you're looking at it, I suppose if you're looking at it on the rewatch crew, you still got the chat there, so it's fine. It's fine. Anyway, who's here? We got Ace working hard. Ace is working hard. We got Jonathan in the chat, Hannah in the chat, Lou in the chat, Sarah pretending to work hard, doing effort all. We've got that's it. Mary. Are you here, Mary? Six, and there's more people than that here. Say hello, guys, if you want to. Don't worry if you don't want to, but I always love when people say hello, especially if I like you. So, and if anyone's got Twitter, please feel free to share my tweet about the. Thank you, Mary. Thank you, Mary. Please feel free to tweet about the Matthew Moore trial on Wednesday. More the merrier being here, hopefully. We've got Sally and Dr. Hines joining us. So I'm looking forward to that. God, don't start that, Lou. Can you imagine? All my friends would be, if my sister and my family saw this now, oh my God. Do you know what I mean? They'd be off here, Lou. King, the I don't care about it, but they would. Oof. I might do a Royal Family Day and wear this for each episode. That's what I might do, actually. I need to do a Royal Family one. But I'm not really into um, Royal Family, do you know what I mean? But I know a little bit about them, but I can certainly do some episodes and make some stuff up. Um, because people seem to be interested. So we'll do that. I'll wear my crown. Might have to get out one of those things, coats, armors, or whatever you call it. Oh, yeah, but I hope you all had a great weekend anyway. Oh, Royal Robe, that's the one. They were the most powerful family in the world. They have assets making them worth over 2.5. Are they 235 trillion? Oh, I didn't know that. Against the USA, best bet one day it's going to happen. Nah, I don't think it's going to happen. John, I don't think it's going to happen. Not with Prince Charles, anyway. With King Charles, sorry. Um, oh, jeez. He already did the line. I could find it. No, you're all good. You don't have to find anything for me. It's all good. I believe you, Jonathan. It's all good. All good, my friend. Nice to see you, Jonathan. Always love it to see Jonathan in the chat because I don't know what random crap he's going to say. It's fantastic. We're missing a few people, but that's fine. Um, hopefully they are able to join us at some point. So the family doesn't know. No, they got like, what was it? Make it a story about how the Royals stole Wales. I'd always. I should, shouldn't I? I should. Um, oh, what was I going to say there, man? Oh, I don't remember what I was going to say there. Yeah, I don't know. It wasn't that important, kind of been because I don't remember what it was. So I wonder if the jury going to be out. The jury will take longer to decide this than they did on the actual verdict. That's for sure. So, oop, legs down. Good. But also, some people we said they'll come back, come here for three. So people are Josie and stuff like that will probably join us later. See Taylor Swift last night. Taylor Swift, loving life in Kansas City with Travis Kelsey. Whoa, that went nuts. I just made a quick 40-second video and I got I think it was over 500 views. And so things like that, they're quite topical. So oh, I don't know. I'm a little bit on the fence with Streamlabs the way he looks because even for me the way he looks is different. So I don't know. Oh, do you know what? What am I doing? I can fast forward this as well. Sorry. Now we're live again. We're live now for the court. So, oh yeah, I was going to say the King Charles. So, you know, we all when we inherit money have to go through probate and you have to pay tax on it and stuff like that, capital tax. So he had, what was it? The Queen had 450 million pounds, which is probably around 650 million dollars, and King Charles inherited it all and didn't have to pay a penny of tax on it, which is absolutely wrong when you consider that for anybody else, we all have to pay taxes on it, inheritance tax. But no, we didn't have to pay anything. It's like 40% as well, inheritance tax. That money could have gone back into the country somewhere. I don't know, but whatever. Who am I to say anything? I don't. Whatever. Go back up below. Oh, Gigi liked it. Just remember, I got new merch now out, right? I got merch everywhere, but I got special merch out. Where is it? Just bear with me. Um, where is it? Here it is. Let me copy and paste it. Copy. So I do not like Charles. Awful it is to say. I hope short rain. No, I love it. I love the feistiness. I think William would be better. I think William would be better. I do. I do. Here we go. Right. Post this in here. Oh. So this is my fundraising T-shirt for everyone sold of these T-shirts. Um, on this particular T-shirt, I give $5 to the Zachariah Anderson Fund, and I give $5 to the Matthew Moore GoFundMe page. That's what I'm going to do it for every one sold. So if you think why it's a little bit more expensive, basically because I'm trying to get them $10 out of it. I don't think I make anything on it, or if I do, it's like $1 or $2 something. So and also look at the rest of the shop. There's other gears there as well if you fancy it. But yeah, that's just a slow promo there. Um, no, so he had it up, Lou, but he's taking it down. Um, I think he wants to make some changes to it, and then he's going to launch it again. So he might have it, but he did have one, and he's definitely going to have one again. So if you once I've got it, I'll just post it directly if people want to do it. Um, yeah, I know people would rather give directly. That's absolutely fine. I'm just trying to think of ways to try and raise some money for people, as a channel as well. Um, but if people prefer to give the money directly to Zachariah or to Matthew, absolutely. As I say, I don't make anything off those t-shirts. So, or if I do, it's like a $2 or something. So please feel free to donate other ways. But I was just trying to think of a way I could contribute a little bit, if people wanted to, because some people want something with it. So, but anyway, so we'll see, and that's why I'm not really promoting his book at the minute because his book's not there till next week. So, um, and obviously with a book, he's going to have to pay other people for that. He doesn't get to keep that 100% himself, whereas GoFundMe 100% his. Do you know what I mean? So, I'd rather promote, but I know he also wants the book to promote the story as well. So, but we'll see, we'll see. But even if people go and have a look at my merch store, even if you're not going to buy anything, that's absolutely fine. But if you've got any comments or any way to make it better, but the pricing of it, I've just left it up to them to do it. In the shop. I've not touched it, so it's up to them how much they charge. It's an external company. Doesn't cost me a penny. So if you don't buy anything, again, no skin off my nose. I don't make anything and I don't lose anything. So it's whereas before I had a store where I was paying £50. So if no one's buying, I was losing. So I lost probably a few hundred quid on that. But this one, not a bother.
No, let's go on the record,
Right.
19 CF 7518, State v. Johnathan Quiles. You have counsel of state defense, Mr. Quiles present. I do have all 16 members of the jury accounted for.
There's a noise there, so let me get the actual stream.
How much time do we need?
We were actually discussing it with the state as far as doing some of the redactions.
They're back.
We were going over.
Give me a time so I can let the jury know, because they're waiting on us at this point. And I think my feelings about having them wait on us is quite apparent at this point.
I think 5 minutes would accomplish what we're doing.
I was going to say, between the two, give us 10.
Can you let the jury know 10:30, please?
Oh my God.
Yes.
10:30.
If they want to walk around, that's fine as well. Just be back outside here that we can start at 10:30. I'll see you guys then.
Okay. 10:30. So we would be. I need to be better. I put myself there because I nearly missed that. Oh, I don't know what do we want to talk about then. I don't know what to talk about now. We've done all the promotion stuff, I think. So I don't have anything to promote. Thank you to those that came to watch the Matthew interview. I hope you enjoyed it. And I say he's going to be here every single week as well now, popping in. And the last episode he'll be here. Mary, what they're waiting on is that. Do you know what? I've no idea. There's some documents or something. Oh, I think it's to do with the um jury instructions or something. Do you know what? I don't really know. It's something the defense need to read anyway. Um, that the state gave them just after 10 o'clock last night. So they're just reading all that up, and then yeah, 10:30, 20 minutes now, they'll be back. So bit of a nuisance, but at the same time, it's important to get it right because this is again a death penalty case. So okay, thanks. Yeah, I mean he likes to start on time. He doesn't like messing about. He cares more about the jury and stuff than he does about the lawyers. He's like, I don't want the jury to be sat there half an hour, going time to walk or something if they want to. which is fair because he sat down all day. Harry's bald and has a small pecker. There was something the state updated. The defense didn't receive it. They had the old version. Defense needed a little time. There we are. It's the document. It's probably the charging document. Do you know what I mean? So, it's something I wasn't far off, or if I was off at all. So it's all gravy, baby. All gravy, baby. Like you Americans, gravy and biscuits. Boo, boo. I need to try it. Sarah P has given me she's given me a recipe. Hannah Elke, what a nice suggestion from Hannah. Where's everyone from? Well, I'm from West Wales. West Wales, I'm from. And I probably know where most people here are from. But yeah, put in chat where you're from so that it's nice for everyone to know where they're from. Hannah, we start with you. Come on, Hannah, tell us where you're from, and whereabouts in Sweden. Lovely, that is a lovely question. That's why I like the chat. Just entertain yourselves rather than having to listen to me. I love it. Dee 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 dee. I followed sex therapist with a trial. What's that? Do. Sex therapist. Oh, I think I know which one you mean. Oh, I know what you mean. The husband or boyfriend. Yeah, no, I was going to, but it's now going to verdict or whatever. I was going to, but I found another. I found this instead. So this is such a beautiful trial. I think I would highly doubt that that trial was better than this one. This was an incredible trial. So yeah, no, not covered it. I'm sure people have covered it though. I think Baker did. I think so. This one's great. Oh, Iggesund. Oh, that's lovely. Iggesund. It's nice. Where's everyone else from? Come on, guys. Hannah starting. Mary's from New York, New Jersey, or New York. I'm not sure. Oh, everyone's like gone quiet. Sarah P pretending to work. She's from College Station in Texas. New York, there we are. New York. Something, something, something about me happened to New York. Dee 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 happened to New York, New York. Sorry, I'm just trying to navigate through here. There was once a little boy. He said, "Thank you. What would you do?" He said. Okay, so we got that sorted. Fine. He said. Okay, so we got that sorted. Fine. Check. One more thing. You see, I feel like I'll check a lot more stuff now. With Streamlabs. You see, I feel like I'll check a lot more stuff now. With Streamlabs. Do you know what I'm going to do? Let's see if people get an ad. Oh no, it's Neko. Do you know what I'm going to do? Let's see if people get an ad. Hello? Oh no, it's Neko. Hello? Let's see if people get an ad. Hello? Oh no, it's Neko. Oh, hang on. Hello? Let's see if people get an ad. Should be fixed now. I had a tab open. Should be fixed now, Sarah. Should be, should be a fix. Right, don't skip it, guys. I'm gonna press for an ad. Let's see if it works. Whoa, 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 whoa. See me fiddling in the background here now, just trying to get. Okay, enough of that was the other member. So we had enough of that joined as well. That's who the third member was. That's fine. Ba-da-ba-da-ba-da-da-da. Do-do-do-do-do-do-do-do-do-do. Yeah, for whatever reason, no one's really sharing my Matthew Moore stuff. I don't know why that is. Do we think that I'm blacklisted or something? Do you know what you'll be covering next? Well, I do and I don't. So, Mary, every Wednesday I'll be covering the Matt Moore trial. So, from 11 o'clock Eastern time, your time, every Wednesday for the next 2 months, 7 or 8 weeks, we're doing the Matt Moore rewatch trial. So, be here for that. After that, no, I don't know. I don't know what trials are coming up, to be quite honest with you. They're normally last minute things. Um, but when I've got spare time, I'll either be streaming Judge Boyd because she's got a couple of trials I want to stream, or if not, I would just be doing some deep dives on like Karen Reed. So Monday to Friday, there's always something. I'm streaming something, Mary. And if there's a trial on, chances are I'm streaming one. And I might, if there's no trial Thursday, Friday, I might do a Judge Boyd one. So it depends today. There might be nothing today, so I might actually do Judge Boyd's one today. Tomorrow, sorry. Tomorrow, Thursday, Friday. I know she's just finished the trial, so I don't know. We'll see. But I also want to do a deep dive on Karen Reed as well to get more into that. And I believe Miss Morgan's gonna be joining me at one point to go through it. So I think I need to get a day where I just go through all the links and then get her to join me afterwards then on the following week. But some people don't like that sort of thing. So it's hard. Yeah, Hannah, what everyone's ignored you, Hannah, except for Mary and me. You see, this is what I have to deal with, Hannah. John's a farmer in the Midwest there somewhere. Ooh. Hang on then. Yeah, it is interesting, Mary. I think because we got Matthew coming on as well. Oh, I just messaged him. Shall I message him again? See if he's got. Oh, 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 oh. Dee, 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 dee. Oh, why is that gone like that? Da, da, da. Yeah. Where, Jonathan? Where are you from? Oh, here she comes. Here she comes. College Station, Texas, USA. Jesus. Is it busy today, Sarah? Busy today? Monday blues? My mother's room. Jonathan, be polite to Hannah. Be polite to Hannah, Jonathan. We really like Hannah. So we want Hannah to stay, Jonathan. And we want you to stay as well, Jonathan. Play nice. Jonathan's the weirdo that everyone needs in their chat. I just love it. Emails from the weekend. Jesus. Check you out. Check Sarah P out. Working hard. Ba 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 ba. Kentucky. Uh-oh. Kentucky Fried Chicken, and a Pizza Hut. McDonald's, McDonald's. Oh, ba 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 ba. Okay. Kentucky racing, isn't it? Is it a race? Map of the waterways on Ohio's absolute wreck. The whole state almost Johnathan, the Kentucky Mightman. And there's Kentucky races, isn't So I'm just checking stuff on YouTube as well. So I let people get entertained. There's a good question there that people can answer. And I know, like, obviously some of you are into the streams as well. Which one's this one? Trouble, trouble is, Hannah, I'm not European anymore. UK is no longer in the European Union. For shame. For shame. I wish we were. I'm a peeing. All right, John. Oh, there's another trial, right? That is two brothers charged with killing Akron teen Ethan Liming. It seems to have been going on for a while. 9 days ago. 6 days, 5, 4. 1, 2, 3, 4, 5 days so far. I don't think we're going to be able to catch up with that one. Lullabies. Yeah, I know. I wish we get back to it, Ohana. But when people say, "Oh, you're not part of Europe," I'm like, "Yeah, I know. I know." It does not. I'm not impressed. Dee 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 dee. Dee 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 dee. Dee 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 dee. Dee 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 dee. Bum, 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 bum. Okay. Yeah, I would love to be part of Europe again. I think it's one of our biggest mistakes leaving Europe, to be quite honest. Is that might be controversial, but that's my stance on it. But it's interesting because obviously my father and I think my mother voted out. Then both me and my sister voted in, stay. So I think there's a lot of generational stuff as well. Right, it should be back on in 5 minutes, guys. So Dee dee dee. Dee 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 dee. A few members in the chat, I can see for most of us, the politics. Well, that's probably why, Jonathan, I never discuss politics. Literally have all my vampire. Yeah, you're saying that, John. It's good they can have a peaceful conversation with people. I just find that every American I've met or know, they only argue about politics. So, which is a shame. Yeah, it's better not engaging, Jonathan. No, exactly. And I find it weird. Only politics and religion, those are the two things that everyone argues over. So just keep away from it. I always say to people, keep away from it. I don't want to chat about it. It's no point. It's no point losing friendships and stuff like that over. I welcome everyone here, no matter what your religion is, whatever your beliefs are, wherever. As long as you're polite in chat, that's all that matters. Because if not, I got two Rottweilers waiting for you. One's called Josie, and the other one's called Sarah P. They're ready to pounce. I'm going to put these back on so I can hear when the court's on. Hannah, believe me, I miss you. I miss Europe. The European Union funded my masters and everything, so I've got a lot to be grateful for. Like, don't get me wrong, not everything about the European Union or Europe is great. I get that. I get why people want it out. But there's a lot more good than there is bad in being part of Europe, in my opinion. And now we're talking about political stuff, which I said I wouldn't. So we'll end it there. It doesn't matter. I like the change of everything while I watch you. You see, I like having you here, Jonathan. I don't understand half the things you say, but that's good because it makes me laugh. You make me laugh, Jonathan. Right, let me tweet this out about. I think that I'm shadow banned again because no one's liking my tweets or anything. Dee, 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 dee. Share on tweet. Oh Jesus, on Twitter. We are family, and we are now live. Please. Okay, just do that. Okay, done. Right, send. So just put that on Twitter. Um, Jonathan, mainstream media is very divisive and don't tell the whole truth. I only watch independent media. See? Who let the dogs out? Ooh, 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 let the dogs out. Ooh, 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 ooh. Why, yeah, 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 yeah. So, we're probably gonna have members only Thursday night, I'm guessing. So, that'll be what happening Thursday night. Sorry, you can't make members only if it's after 5 o'clock central, can you? I was gonna do it like, don't know what I'm gonna. Might try and do it like three. Depends what we do. Might try and do it 4 o'clock, so we'll do an hour or hour and a half members only, so Sarah P can be there for it. I don't know what I'm gonna do. Um, maybe just do another car chase or something. Beep 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 beep. Haven't watched cable news in a long time. No, neither do I, guys. I don't watch it either here. Mm. Dee, 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 dee. Okay. Okay, I'm out of that one. So, oh, there's movement. So here we go. So was I opening when I saw the narrative swap in this? Let's see when I was channel hot swap. Yeah, my brother-in-law, he works for a media company. Well, he's like the head of communication stuff. And his advice always is to anybody, don't listen to just one type of mainstream media. Listen to like, or he used to be professor in college, teaching media and studies and stuff like that. And he'd always say, if you're going to read a newspaper, read them all. Don't just read one. If you genuinely want a wide ranging view, and then make your mind up. But the trouble is, we all do the same thing. We all go to just the one thing. I watch a lot of NTD and Epoch Times now. I don't know what that is, Jonathan. Shasha Boom! Shasha Boom is here. She was here earlier. How to become a member? Shasha Boom. You press. You press the dollar sign, and then you say, and you buy. Is it purchase membership or something? I'm not sure what it says because I've got mine already paid for. So you click the dollar sign and then you press join or something. Is it that? Or is it a join button? Here we go. Here she is. Here she is. Sarah P. She sorted it all out. She's done it. She understands more. So yeah, I think it's £4.99 per month. Shasha boom. Chudley Pip, hello. Hello. You've missed nothing. Basically, we're late because there's a change in the charging document. So we're supposed to start at 3 o'clock UK time, 11 o'clock Eastern time, but it's gonna be half past. So actually, we should be starting now. So obviously, this is the sentencing phase, and we believe there's about. I think there's a doctor, psychologist, going to be questioned about sanity of the defendant first and foremost. Then there's going to be lots of testimony, character references, and stuff like that from the defendant, and also family of the victims as well will be speaking, and then the jury will get the instructions then. It's right, so you see Sarah P posted it here. So Shasha Boom, press the link that Sarah sent you just now in chat. It's 1, 2, 3 clicks up. It should just be a join button. If you click that link, it should, unless if you're on a phone, that's different. If you're on a phone, it doesn't work, I don't think. Don't think it works, Shaz. I don't think he can. Can he join on the phone? I don't know if Shaz has got a phone or. Oh, there we are. So it's just the join button underneath the text. See, Jonathan. Do you see, Jonathan? You should be a mod. You see, this is why you should be a mod. So it's fine. It's still underneath where under on the right hand side of where you type, Shaz. I'm useless with stuff for this. Okay. She found it. Oh no, you know where it is. I see it now. Yes, there. So Pip, what's wrong? I'm not well, hun. Ended up in hospital with a. Oh no. Oh no. I know some people have had that. Tuddy Pip. Oh well. Tuddy Pip. So sorry to hear that. T's and P's, but absolutely, we're here for you. You know that. So sorry to hear that. Um, I don't know what to say, but it's horrible. I know it's horrible. Just remember, you got family here. We all love you, no matter what's happened. Um, oh, that's nice. Jonathan's going to remember to pray for you as well. We all have you in our thoughts as well. To Pip. Jeez, it's always the best ones, isn't it? So um, just remember, we love you. To Pip. Um, right, Shusha Boom. Sarah P and Jonathan and Hannah, explain to Shusha Boom how it works because I don't know myself. No, it's not super sticker. No, it should be a join thing. But I don't know on iPad. You see, I've not got an iPad. No, no super chat. No super chat. Don't worry about struggling. I don't know where it's on an iPad. You see, um, well, judges back. Does anyone know how it works on an iPad, guys? to join the membership.
I have counsel of state defense, Mr.
We'll help you out now,
Quiles
Chaz. Don't
present.
worry.
How are we at? How are we with the next statements?
Good news, Your Honor. We do have an agreement. And to make it simple, the state of Florida is asking to file a clean, original copy of both, one of Paula Dixon and the other of SS. And just for the record, it's Dixson is how she has it spelled in her victim impact statement. And then, Judge, we'd like to make this a court-only composite exhibit for the clerk to then file right behind it the exact same thing with the defendant's objections. One, the objections are noted in red, and on the other, the objections are noted in the highlighted yellow. What we've done, Your Honor, we'd like to file both sets of these to show, if needed, at a future date, the appellate court, what was objected to, and then the state has agreed to all the requested objections by the defense. So we have taken those out by providing a copy to each respective witness, blackened out of the exact same portions that were objected to, so then the record will reflect when they testify that what they'll read will actually match what has been objected to. So at this time, I'd like to file the first clean. It's one copy of both victim impact statements with no markings, and the second will be both victim impact statements with the defense requested objection, not a disagreement.
So are these being filed on the docket, or are these being taken for evidentiary purposes?
Just for purposes of the record to be filed with the clerk. We're not obviously asking them to go back with the jury with all the markings on them.
So I guess my question is, are they going to be filed to where you can go on the docket screen and see these statements, or are they being filed for identification purposes only to where they're essentially part of the evidence that will go to the appellate court?
Judge, just filed on the docket. Again, they're going to be reading this in open court, so we have no issues with it being filed on the docket.
Okay, so they're being filed on the docket.
Yes, sir. And then what the
Is there a better way to handle that?
Judge,
Maybe can they just be filed as for identification purposes for the appellate courts versus it being filed so there's public record on the docket now?
I have no objection to that if that's what the court requests, and there's no objection on the state.
Okay, so I can make them a court's exhibit. Obviously, if they're not my evidence, of course, but for purposes of just the evidentiary purposes, so they're not filed on the public domain, they can be made as court's exhibits 1 and 2. We all know what they are. Everyone's agreeing to what they are. It's just for purposes so they can be sent to the appellate court for review at a later date if that's necessary.
Yes, sir. The state agrees.
Defense agrees to that, Judge.
Okay, so we'll mark court exhibit 1 will be the ones that they're actually reading, and then a clean copy. Then count 2 will be, or court exhibit 2 will be the ones that have objections to it. Is that how you did it?
That's right.
Oh, I'm sorry. Is one court exhibit 1 is one witness, court exhibit 2 is the other witness?
Yes, sir.
Okay.
Court exhibit 1 is both victim impact statements, unredacted.
Okay.
So
Shaz, if you do it on your laptop, it's super easy on your laptop. It's there. It's just a join button. That's all there is. Join. And that's it.
the
Okay.
appellate court will have that on the record. And then the second court exhibit will be both victim impact statements with the defense requested objection.
Okay. You said it better than me.
Yes, sir.
And so to get to the end on this, the parties have agreed, or the state is conceding to the objections made by the defense on everything raised off both statements, and that'll be presented to the jury.
Yes, sir.
Okay. So at this point, are we ready to proceed?
Yes, sir.
You guys have seen the plenary instructions. I'll read to the jury with the state's aggravating factors and what's applying to counts 1 and 2. That's really the only thing that's necessary for me to insert in the plenary instructions compared to the final instructions.
Judge, we just have to renew our prior objection that we had raised earlier for purposes of the appellate court, stating specifically that we do not agree with the aggravator of the familial I believe it was number 6 was the aggravated.
Correct.
We are objecting to that, Judge.
Okay. I don't think I asked the state for any position on that. Do you want to state anything more so than what the record already has on it?
No, sir. I think the court pointed out in the record it's familial or custodial, being that he's in a relationship with her as her uncle, and with his belief that was his child and the motive for the killings. We believe this, particularly the facts, and I'll get into the facts and argument later today. But with all the things that I'm too time consuming now to go into, but with all the facts that bore out over the year and a half leading up to this, the state's position is that most certainly is a custodial relationship.
For scheduling purposes, I would probably get through openings and maybe the state's first 2 witnesses. The state will probably rest at that point. Probably take a lunch break then, and then I'll turn everything over to the defense, and then Zoom will be set up for you guys to use at your disposal.
Just so the court knows, our opening statement is brief. The defense has advised me that it's just 5 or 10 minutes, and the victim impact statements will be 15, 20 minutes, both reading them. So if the court wants to keep going, we're at the court's pleasure, but we will rest at that point.
Judge, after they arrest, we could probably get through Dr. Rohr before lunch.
Do I need to dismiss the jury for any motion practice after the state's case? Okay. Any reason why I can't bring the jury in?
No, Your Honor.
Defense?
They are.
All right, let's bring the jury in, please. Okay, that's fine.
Your Honor, the jurors are entering the court.
Thanks, Jonathan. Here you are, Shasha. Jonathan's giving you an explanation.
Members of the jury, welcome back. You guys may have a seat. Does everyone have their notepads? Okay. All right. Well, good morning, everybody. It's good to see everybody. Hope you had a nice weekend. We're going to go ahead and get started. I have some instructions to read to you guys before we get started. Members of the jury, the defendant has been found guilty of 2 counts of first-degree murder in a previous proceeding. The only issue before you now is to determine the appropriate penalty. The penalty for each of these crimes is either life in prison without the possibility of parole or the death penalty. Before proceeding further, it will be helpful if you understand how this proceeding will be conducted. The attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the attorneys say during opening statements is not evidence, and you are not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence. Witnesses may be called to testify under oath. If so, they will be examined and may be cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. This evidence, along with the evidence that you have heard during the guilt phase of the trial, is presented to you to determine whether the state has proved beyond a reasonable doubt the existence of the alleged aggravating factors. If so, you must weigh whether the proven aggravating factors are sufficient and whether the aggravating factors outweigh any mitigating circumstances the defendant proves by the greater weight of the evidence. Finally, you will decide whether the defendant should be sentenced to life in prison without the possibility of parole or to death. At the conclusion of the evidence and after argument of counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is the only circumstance recognized by Florida law that could result in a defendant receiving the death penalty. An aggravating factor increases the gravity of a crime or the harm to a victim beyond the harm inherent in every first-degree murder. You must unanimously agree that an aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your sentencing decision. The aggravating factors alleged by the state in this case are as follows. The following aggravating factors apply to both counts 1 and 2 unless otherwise noted. Johnathan Quiles was previously convicted of a felony involving the use or threat of violence to another person. The crime of sexual battery is a felony involving the use or threat of violence to another person. 2. The first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. 3. The first-degree murder was especially heinous, atrocious, or cruel. This aggravating factor only applies to count 1. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily tortious to IS. 4. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the crime of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. The unborn child of IS was a person less than 12 years of age. That's for number 5. This only applies to count 2. Number 6. IS was particularly vulnerable because Johnathan Quiles stood in a position of familial or custodial authority over IS. This applies to count 1. The unborn child of IS was particularly vulnerable because Johnathan Quiles stood in a position of familial or custodial authority over the unborn child of IS. This applies to count 2. Once the state has presented evidence of the existing of aggravating factors, victim impact evidence may be presented. Such evidence is only presented to demonstrate the victim's uniqueness as an individual and the loss to the community by the victim's death. However, victim impact evidence must not be considered by you as an aggravating factor. A mitigating circumstance can be anything that might indicate the death penalty is not appropriate for the defendant. It is not limited to the facts surrounding the crime. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may indicate the death penalty is not an appropriate sentence in this case. Whether a mitigating circumstance has been proven is an individual judgment by each juror. A mitigating circumstance need not be proven beyond a reasonable doubt, but must be proven by the greater weight of the evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law. After the final instructions are given, the alternate jurors will be released and you will begin your deliberations. You should not form any definite or fixed opinion until you have heard all the evidence, the argument of the lawyers, and my instructions on the law. Until that time, you should not discuss this case among yourselves. Your decision must be based solely on the evidence or lack of evidence and the law. During the penalty phase, the court will take breaks and you are permitted to separate and go about your personal affairs. During these breaks, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell them that you're on the jury and ask that person to stop. If that person persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during breaks, but even then you must not use your devices to find out information about the case or communicate with anyone about the case or the people and places involved. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each breaks, please double check to make sure your cell phone or device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. A contact phone number will be provided to you. The penalty phase must be tried by you only on the evidence presented in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, internet, any electronic device, or any other means at all to get information related to this case or the people and places involved. This implies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned or use the internet to look at maps or pictures to see any place discussed during the penalty phase. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. Do not let even the closest family members make comments to you or ask questions about the penalty phase. In this age of electronic communication, I want to stress again that just as you must not talk about this case face to face, you must not talk about the case by using an electronic device. You must not use phones, computers, or other devices to communicate. Do not send or accept any messages related to this case or about your jury service. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, and make inquiries on your own, I have no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence presented. Any independent investigation by a juror unfairly and improperly prevents the parties from having the opportunity that our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire process to start over.
Wow.
A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as jail time, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference regarding the existence of an aggravating factor or an appropriate sentence. And the fact that a defendant did not take the witness stand must not influence your sentencing decision in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure. It is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had the witness been permitted to answer. It may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will take. When such conferences occur, they will be conducted to consume as little of your time as is necessary. We'll begin with our opening statements, and State, you have the floor.
Wow.
Please support.
Yes, ma'am.
Can you imagine if there's a mistrial right now? Woo! Jesus, that would be a mess, wouldn't it?
Good morning, ladies and gentlemen of the jury. The state of Florida thanks you all for your time and attention that you have given the past 2 weeks, and including the verdicts. Johnathan Quiles is now a 2-time convicted murderer and a convicted sexual batterer. Each of you know the horrendous facts that occurred in this case back in December of 2018. Each of you know why the defendant killed IS. Each of you know why the defendant killed IS's unborn child. Each of you know how the defendant killed IS and her unborn child. You all know about the ongoing sexual abuse that the defendant did of IS in the late 2017 going through 2018. Each of you did justice. When you convicted the defendant beyond a reasonable doubt of premeditated murder of IS and the premeditated murder of IS's unborn child. Phase 2, though, ladies and gentlemen, is about fully holding the defendant accountable for each of his actions that led to why we are here today. State will rely on the evidence that you all heard during those 6 days in Phase 1. We will now commence Phase 2, which will be the weighing process. And Mr. Skinner discussed this during, if you can recall, 2 weeks ago during jury selection going into that second and third day. Now, the first thing that will be asked of each of you is if the state has proven beyond a reasonable doubt the alleged aggravating factor. Now, we have alleged 5 different ones for each murder. However, there are 4 in common that will be applicable to the premeditated murder of IS and her unborn child. And then there is a different one that will be applicable to IS, and a different one that will be applicable to only the unborn child of IS. Now, if each of you find unanimously, beyond a reasonable doubt, that at least one of these aggravated factors we have proven, then you can move on to the second step. And that second step is where you weigh and whether the aggravating factor is proven is sufficient. If you find that the aggravated factor is then sufficient, you then will move on to the third and final step, which is whether the aggravating factor outweighs any mitigating circumstance provided by the defense, and that has been proven by the greater weight of the evidence. Now, again, as the fact finder, as the juror, you can determine if that weight is great, medium, slight, or holds no weight. That is, again, your right, your choice as a fact finder, as a juror in this case. Now, an aggravating factor, it increases the gravity of the crime or the harm to the victim beyond the harm inherent in every first-degree murder.
So,
and again, you will hear victim impact evidence. However, this is only to demonstrate the victim's uniqueness as an individual and the loss to the community of the victim's death. However, victim impact evidence must not be considered by you when weighing each and every aggravated factor that the state of Florida has alleged. The aggravating factors, I'm just going to cite a couple of points and then move on, ladies and gentlemen. The first one is that Johnathan Quiles was previously convicted of a felony involving the use or threat of violence to another person. And keep in mind, the crime of sexual battery is a use or threat of violence to another person, just like each murder is. So if you all think about it, in count 3 of the indictment, previously, because we have heard that he was convicted of sexual battery. He was convicted of 2 counts of murder. So in thinking about IS, that previous felony, because the defendant is now a convicted 2-time murderer and sexual battery, you can use that sexual battery, or you all could use the murder of the unborn child of IS. 4, when weighing whether or not the murder of IS. Then when thinking about the unborn child of IS, you can weigh that again, count 3, the sexual battery, and also you can then also weigh the murder of IS for count 2. And just thinking again about SS witnessing the incident about a year ago at that 1503 16th Street, the DNA results from March of 2018 regarding the sexual battery, and the IS was staying the night with the defendant during the weekend of July 7th, 2018, and that she was pregnant over 5 months at that time. The long drives, as we had heard evidence from, we submit that you had heard evidence involving the Trout River location and the defendant's van. And again, lastly, the defendant's statements and confession to the wire, which is State's Evidence 66. Then about a year, the defendant had stated, or maybe less than a year, and it had been about a month prior to the last time the IS had sex, given the fact, too, that the sexual battery had occurred and had been occurring prior to December 19th and 20th of 2018. The next one for consideration that's alleged aggravating factor by the state of Florida. The first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. Well, again, we have heard that the defendant, even with the thought we submit that it was his child, it didn't even have to be his child for the defendant to have committed murder on the unborn child of IS or of the murder of IS. In fact, in State 66, in the wire, quote, as she had gave birth to that baby, I've been sitting right here with y'all. She was killed to avoid sexual battery charges, and the unborn child was killed to avoid sexual battery charges. Next alleged aggravating factor by the state of Florida was that the first-degree murder was especially heinous, especially atrocious, or especially cruel. So I like to point out, it's an or. State of Florida does not have to prove all 3 by a reasonable doubt, but we do have to prove one of those by a reasonable doubt. And Your Honor will go over what those definitions are again later today. And again, in thinking about those terms, what we heard during the evidence in Phase 1, again, the IS was 5 months pregnant between December 19th and 20th, 2018. The defendant stated that after he falsely lured her to his employment at Ace Pickup Parts, that they would run away. He strangled her, but he could not stomach it. Basically as a way to kill her, so he eventually shot her in the chest and the heart. And again, we had heard this from the confession of witness testimony of Joseph Quiles, the brother. Next, the alleged aggravating factor by the state of Florida that we intend to prove beyond a reasonable doubt. The first degree murder was committed in a cold, calculated, now this is an and, so we have to prove all three, premeditated manner, without any pretense of moral or legal justification. Again, in thinking about count 1 and 2, thinking about cold, we submit and recall the evidence to you all regarding what Naomi Mobley stated. After I.S. went missing, he slept like a baby. Also, too, in hearing from Joseph Quiles and what he had stated during his messaging with the defendant back in December of 2018, he talked about the defendant's selfishness as well. Calculated that the defendant planned the murder of I.S. and her unborn child for months, as we heard from Joseph Quiles during the evidence of Phase 1. Again, about the lure to his work false pretenses. Turning off the phone location of the defendant. I.S. turning off her phone location data. Having I.S. in a remote area of Ace Pickup Park. Not having video surveillance located at that place at Ace Pickup Park. The defendant having access to vehicles, a firearm, a forklift, the knowledge of the container and how it would go weekly, getting duct tape, having bags, and then afterwards going to the gun range. The defendant knew in August, as we heard again through evidence through Phase 1, that I.S. was pregnant based upon those Snapchat messages in State's Evidence 63 and 64 as early as August of 2018. I.S. did not want an abortion. We also heard from the evidence during the case that her family members did not want her to have an abortion. Ms. Mobley had stated she found out on December 3rd, 2018. Ms. Naomi Mobley stated that the rest of the family found out on December 6, 2018 during her testimony. And we all know that the pregnancy was confirmed by Dr. Achu on December 13, 2018. The pressure was on the defendant. We also heard from Naomi Mobley regarding his actions, his nervousness, fidgety, something was bothering him, and that he knew the consequences, as stated in The Wire as well. Sitting right here with y'all, again, as she had given birth to that child. So we submit the evidence will show that we have proven cold, calculated, and premeditated. The unborn child of I.S. was a person less than 12 years of age. This is only applicable and alleged to count 2 involving the unborn child of I.S. You've heard testimony again that she was 5 months pregnant on 12/13/18 by Dr. Achu. You have seen a picture of I.S., which was States 23, where she was pregnant. And you all have also seen States Evidence 24, which is a picture of the sonogram that Dr. Achu performed. That, in fact, we feel comfortable that you all will find beyond a reasonable doubt that we have proven this aggravating factor that I.S.'s unborn child was less than 12 years of age on December 19th through 20th, 2018. Lastly, I.S. and her unborn child of I.S. was particularly vulnerable because Johnathan Quiles stood in a familial or custodial authority over I.S. or I.S.'s unborn child of I.S. So first, in just thinking about I.S., I would submit and bring your attention to count 3 of the indictment during Phase 1. One of the elements that the state of Florida had to prove beyond a reasonable doubt was in fact that Johnathan Quiles was in a familial or custodial authority over IS. You all have already found that to be beyond a reasonable doubt. You all have already heard testimony by multiple state witnesses that the defendant was in fact her uncle. IS was over the home. He would teach her how to drive, teach her how to swim, and that Naomi Quiles, the aunt, would not be there, and Miss Kim Mobley would be at work. Now, in regards to the unborn child of IS, I would submit and bring your attention to the testimony provided in the Snapchat messages and then combined with the testimony of Naomi Mobley. When the fact is, well, again, and coupled with the information that we already know, that the defendant discussed about eating and making sure that she got enough food for the baby, as we had read in those Snapchat messages, as Ms. Mobley had indicated, the defendant was doing the same thing for IS as the defendant was doing for Naomi Mobley, because she was also pregnant at the same time. So, ladies and gentlemen, at the conclusion of Phase 2, the state will have proven beyond a reasonable doubt each aggravating factor that we have alleged. We will ask you all to then find that the weight, that they are, again, substantial, and that the weight of the mitigating circumstances that the defense will provide will not outweigh each aggravating factor beyond a reasonable doubt, and will ask you all to render a vote of death. Thank you all for your time and attention.
It's quite interesting with the poll, because I've always thought about it. So 2 of you think you'd rather have life in prison with no parole, and 3 people think the death penalty. You'd rather have it, just get it, because you've probably got to wait 5 to 10 years, just get it out the way. It depends if you've got family, I suppose. Because do you really want to sit in prison every single day, going through the same routine, day in, day out, no life? Was it half an hour call every week? Not being able to see anybody. I don't know. So it's interesting.
Bring forward several of his family members,
Oh,
as well as a psychologist, Dr. Jennifer Rohr. You will hear from his family that Johnathan Quiles was raised by his mother almost exclusively, as his father was not in his life. You will also, we believe the testimony you're going to hear today is that until you found him guilty, he had no prior criminal, any other criminal offenses. Johnathan Quiles was 33 at the time of this incident, of which you found him guilty of. Prior to that, he did use drugs and alcohol, mainly marijuana, but when he was a younger child, of which he was engaged in another sexual relationship at a young age, and as such, he quit school at a young age at 15. Since that time, he had 5 children. Up until his arrest, he was raising those children, taking care of all of them, and worked very hard. You're going to hear from both his aunts, his uncles, and his family members as to the type of person Johnathan Quiles is and will continue to be. Now, the state has brought up the aggravators. Again, ladies and gentlemen, you must find him or find those aggravators unanimously. In going through our mitigators that we intend to present, you only need to find a mitigator will outweigh their aggravator in order to find for life in prison. And each one of you can hold that individually. This is not a collective group. You can find your mitigators outweigh their aggravators, And in doing so, you can stand by and hold your abiding belief that death is not the only option. In doing so, the mitigators, again, more of which you will hear through the course of the day, we believe you're going to hear that since his arrest, that Johnathan Quiles has become a trustee at the jail, which is unheard of for somebody who has been accused of a crime of this nature. Not only is he a trustee, he has taken up religion. He reads the Bible to other inmates. He does and has provided to the elderly and the infirmed in the jail and takes care of them. And we believe that the testimony you're going to hear from Dr. Rohr is that although you have found him guilty of this, he can flourish in a controlled setting and provide to those others as such. That, in and of itself, we believe, as you hear these mitigating factors, can and should outweigh the death penalty. Life is always an option. He can be a productive member in a controlled setting and in this facility and provide to others who need assistance. Johnathan Quiles,
I hate this guy.
although he is in jail, has no cognitive or neuropsychological deficits. You've heard from his brother who testified here today through the course of the trial. You will hear from him again today as to why you should consider sparing his life and giving him life. The same person who testified in the guilt phase will testify again here in the penalty phase. Again, you will hear that Johnathan Quiles does have a loving relationship with his 5 children. And again, he's a dedicated and hard worker, and that since his arrest, he has no disciplinary reports. He has not gone out and sought more problems, more trouble. He is not fighting in the jail or creating or committing new crimes. That is, again, significant in and of itself. For somebody who's alleged to have committed a crime of murder and sexual battery, he is not going out seeking out new crimes or committing new crimes. At the end of the day, again, ladies and gentlemen, you are the trier of fact. Listen to the aggravators, listen to the mitigators, and keep in mind, one mitigator alone can outweigh their aggravators in your contemplation of sparing Johnathan Quiles' life. And at the conclusion of our testimony, we hope and believe that you come back with that of life in prison. Thank you.
Thank you, Mr. Davis. State, you can call your first witness.
Here on the state, we first call Paula Dixon.
Okay, so this is going to get...
Ms. French, I'm going to read the jury an instruction once Ms. Dixon's sworn in.
Yes, sir, Your Honor.
So, I listened to some testimony here.
Ms. Dixon, good morning to you, ma'am. Just come over here to your right. Watch yourself as you come forth. If you need a glass of water or something, let us know.
So polite.
We're able to certainly get you a glass of water. You can address the microphone as you deem necessary, okay?
Okay, thank you.
All right. Yes, ma'am. Members of the jury, I mentioned this to you in my preliminary instructions to you. I'm going to read it again, given the witness. The state's now going to present and victim impact evidence to you. Such evidence is only presented to demonstrate the victim's uniqueness as an individual and the loss to the community by the victim's death. However, victim impact evidence must not be considered by you as an aggravating factor. Ms. French, you may inquire.
Thank you, Your Honor. Good morning.
Good morning.
Please introduce yourself to the jury
My name is Paula Dixon.
and spell your...
No, I don't. No. I just tend to just get off camera and just go to the toilet. It's not far from here, so. Oh, that, right. Okay, sorry, like that you mean. I thought in here you meant. I have been, yeah, I do. Sometimes. Sometimes, yeah.
Your last name, please.
Dixson.
And ma'am, are you related to IS?
Yes, I am.
And how?
I'm her aunt.
And are you Kim Mobley's sister?
Yes.
And Ms. Dixon, did you provide a victim impact evidence statement?
Yes, I did.
And would you please read verbatim your victim impact statement, ma'am? And take your time.
Absolutely. Your Honorable Court, my name is Paula Dixon, and to the family it was no secret that I was Ayanna Sawyer's favorite aunt. I remember the day she was born like it was yesterday. I received a call advising me that my sister had gone into labor. My husband and I gathered our children and met my mom and my sister at the hospital. After hours of labor, Ayanna Michelle Sawyer made her grand entrance into the world, and it was love at first sight. My princess Yanabu was the perfect baby. Her smile was so contagious. This was my sister's first child, so she did everything by the book. I literally watched her embrace her new role as a mother. We had our first birthday party at my house, which I will never forget. I said, Yaya, what do you want to eat? She pointed to the plate and said, beans. We pulled out the smash cake, and she sat on my lap as I fed her. My sister came up with the bright idea to push her face in the cake, which I simply refused to do. Instead, I took her hand and stuck it in the cake. She turned to me, held out her hand, and said, it's dirty. It tickled me something serious. Shortly thereafter, Maya was born. My sister couldn't wait for her daughters to finally meet. My two nieces were inseparable from that moment on. My mother raised us to always be there for your sisters, and I can see that my sister was ensuring that our next generation would do the same. In years to come, she would gain 2 additional brothers. Being the oldest, she became a natural-born leader. She would teach her younger siblings how to read, write, do math, and a plethora of other things. She utilized the leadership skills that she gained at home to pursue other endeavors at school. She was an honor roll student, a crossing guard, and a great friend, to name a few things. She was the definition of, if I can believe it, I can achieve it. She never let a challenge stop her because she knew she could do or be anything she put her mind to. At an early age, we saw that she strived to be the very best and that she always wanted to be a top performer. As a family, we encouraged her to never settle for less because we knew she was destined for greatness. She began receiving scholarships when she was in elementary school, and by the time she entered middle school, she was in honors classes. She began doing extracurricular activities such as playing the violin and joining the step team. As she entered high school, she began taking college courses and was on track to graduate early. She loved to dance and had the craziest sense of humor. One time she called out to one of her brothers, telling him that she needed help. He came running in to see what was wrong, and as soon as he hit the kitchen floor, boom, he slipped and fell on the dishwashing liquor that she put all over the floor. She got a good laugh off of that one. This is just one of the many jokes she played on her siblings. She was the best big sister and very big on family. She was truly her mom's little mini-me. Her siblings looked up to her. As time went on, she became a big cousin. The babies just loved her. My nephew was so crazy about her. One time she was sitting at the top of the stairs, and he began climbing up the stairs to get to her. He made it about halfway and said, "Ya." I guess it made her heart melt because when she went down the stairs to pick him up, She was such a diva and a true fashionista. I started getting her lotions and fragrances from Victoria's Secrets, and she immediately fell in love with the pink line. She knew that for her birthdays and Christmas, she was getting something pertaining to pink. The smile on her face when she opened her gifts was priceless. She loved to eat. We would have family gatherings regularly, from seafood Saturday to Sunday dinner. Thanksgiving was one of her favorite holidays. I started a tradition letting the kids spend the night so they could help prepare the meal. She loved being around family. Her smile lit up any room that she entered, and she was such a joy to be around. She was our princess, and she wore the title well. As time passed, we received shocking news that she was pregnant. I was so excited to be a great aunt, and I could not wait to find out what she was having. It was almost Christmas time, so I made a big Sunday dinner, and everyone came to my house to paint nutcrackers. I guess the baby liked the greens because she started moving around, and I said, uh-oh, the baby's gonna like my cooking. Never in a million years did I imagine this would be the last time that I saw her. The following Wednesday, I received word that she didn't come home from school. I can never put into words the feeling of panic that came over me. From that moment on, our lives would never be the same. We called and texted her for weeks with no response. After a while, we received the news that no one wanted to hear. She was gone and never coming back. We had to tell our children that she was gone while holding back our tears as we wiped theirs away. My poor sister had to keep herself together because she had 3 other kids looking to her for comfort. Their sister was gone. I can only imagine how my niece felt having to look at an empty bed day in and day out. My poor nephew struggled to cope with the fact that she was never coming back. I watched my sister stand still for almost 5 years. Her baby and grandbaby were gone without a trace. All the sleepless nights, the tears, the pain of not being able to give them a proper homegoing, the family dysfunction. This tore our family apart. I had to sit back and watch my sister try to make it from one second to the next. There were no words of comfort we could offer. All we could do was be there. I had to take time off from work to try to get my mind right. Sometimes all I could do was cry. I had to hold on to my faith because that was my baby. I will never forget the many nights that I had to comfort my child. We were at an all-time low. I watched my family completely fall apart over the years. There were so many ups and downs. This loss left a hole in our hearts that can never be filled. How do we move forward as a family? We kept our faith and awaited our day in court. I sat in the courtroom every day and watched my family testify one by one. My heart broke all over again. It was not all for nothing. Justice was served. But how do we pick up the pieces knowing what we know now? We will never truly heal. How can we? Grace and mercy has carried us thus far, and we must hold on to his word. There are so many things we will never be able to do. We will never be able to meet Hazel, never get to see our princess as a mother. We will never see her go off to college. We will never see her get married. We will never see how great she would have truly been. We will never get to see her live. Now we are left with memories, a bunch of what ifs. We must live the remainder of our lives with a bunch of regrets, because we can never turn back the hands of time. We must live with a constant reminder that our princess is gone. We must live with the guilt of knowing that even though we were our sister's keeper, she is no longer with us. That's a burden I wouldn't wish on my worst enemy. We must now figure out how to proceed as a family going forward. How do we heal? How do we trust? How do we live given all that we've learned? The only answer I could come up with is by the grace of God. I know that my God is a faithful God. He will never leave us or forsake us, and he will never put more on us than we can bear. Justice is just the beginning of our healing process. We must now learn how to live with the unimaginable loss that we have suffered. I know our princess is still with us every time we see a rainbow, pink skies, or a red cardinal. We know she is there. I thank God for the 16 years that he allowed us to be in her presence. The world will never know how great she really was or could have been. She will live in our hearts forever. I like to think of her as an angel that my God called home. He needed her more than we did. The flesh wants us to hold on forever, but that's human nature. To my young boo, I love you unconditionally. You will take it from us too soon, but we will continue to honor your memory until we meet again. You are loved, and we miss you so much. If he brings you to it, he will bring you through it. I love you unconditionally. I don't know how, but we will get through this. Long live Princess Yaya and Princess Hazel. Thank you.
Nothing further, Your Honor.
No questions, Your Honor.
That's tough.
I forgot.
Yes, ma'am.
Thank you.
I was genuine, Johnathan, you're right. Wow. What do you say to that?
State.
Yes, sir, Your Honor. The state would like to next call SS.
So I think we don't get to see it, do we? It is so tragic, Anna. I agree. Welcome back, Anna.
Ma'am, good morning. Watch your step. If you need a glass of water, let Mr. Gray know. He'll certainly accommodate you.
So right here.
State main quiet, you're ready.
You just please reintroduce yourself to the jury.
Samaya Sawyer.
And are you the sister of Ayanna Sawyer?
Yes.
And did you provide a victim impact evidence statement?
Yes.
And Ms. Sawyer, will you please read it verbatim to the jury?
Yes. From now until the day I perish, there will always be an element of my life that will be permanently missing. That element is Ayanna Sawyer. Our lives were so intertwined, everywhere we went, we were asked if we were twins. In fact, you would rarely see one Sawyer sister without the other. However, now you will never see me or my sister together. Ayanna was my older little sister. She was so childish she could make you laugh at the most inappropriate times. But that's what made her so special. She was the beam of sunlight that could peek through a hurricane. We could be grounded all weekend, and yet she would still make it feel like it was a normal day. Ayanna was extremely intelligent. She wanted to be a pediatrician. We planned on going to college and becoming physicians together. We planned our lives around each other so much, we even decided that each of us would live on opposite sides of the Riverwalk with apartments facing each other. Unfortunately now, I am completing those same milestones by myself, with every accomplishment bringing great sadness. For every congratulations, the thought that I should not be my mother's first child to graduate, attend college, or move into an apartment crosses my mind. It's extremely difficult to step into my childhood bedroom and see one bed where there used to be two. Every loving memory that I have of my sister has always been overshadowed by the fact that memories will be all that I can carry with me in life. I'm always saddened by the fact that I will never be able to hear her voice, argue over whose shirt is whose, know her daughter Hazel, or see the beautiful woman and mother she would have become. After the announcement of my sister's disappearance and death, school became another place of torment for me. Every day, people I have never met, who I have never seen before, would approach me and ask if that dead girl was my sister. There would be times where I would randomly have to leave school to go downtown to the police station. There were so many occasions where there was little to no notice, and most instances I would be there late into the night. Still, even that did not compare to the misery I endured within those school walls. There would be days where I could not fathom the thought of walking through school doors. On those days, I would sit in the car until the end of the school day and just cry. However, when the 2 o'clock bell rang, I had to compose myself as if I was not in disarray, so my younger brother did not see the mental instability the situation has forced upon me. As I now have to be their source of comfort, just as Ayana was for me. On numerous occasions, the dismissal process from school would be a battle in itself, as media stations would linger to report their stories on my sister's disappearance. Throughout the time Ayana has been gone, day by day, individuals have questioned my mother's parenting. It's very difficult as a teenager to see those who have only read about my mother's question how she raised my siblings and I. Might I add, my mother was and is still an exceptional mother. I remember nights seeing my mother crying on her closet floor, blaming herself for Ayana's devastating loss. There is nothing that I can do ever to lift that burden from my mother, but assure her that it was not her hands that caused Ayana to no longer walk this earth with us. As if it was yesterday, there will always be an image ingrained in my mind of my mother walking through the front door with bloodshot eyes. That was the night my brothers and I were informed of Ayana's passing. Seeing my mother never agree to make sure that her children could grieve will forever weigh heavy on my heart. As I think about how my family has changed forever, I think about how my fiance would never meet the sister I speak so highly of. My sister would not be my bridesmaid at my wedding, or the fact that our future children will never be able to play together. My family will forever have an empty space that can never be filled by anything or anyone. Some nights I have vivid dreams of my sister, as if it was a normal day that we would spend together. But then I am forced to open my eyes and realize that it will only ever be a dream. All I can ever do is cry and wait for the day I will see her again. Then there are other nights when nightmares are endless. The disappearance of my sister has caused me a great deal of mental instability. I just can't understand how someone who is loved and caring life herself can be thrown away as if they were trash, as if they meant absolutely nothing to anyone. Ayana was loved. Hazel was loved. Ayana was my compass whenever I felt lost. She was my best friend. There was a point where I could not fathom going through life without her, but I know she would not want me to be anything less than great in life. There's not a day where I don't miss her or cannot stop replaying her smile in my mind. What I would give to have just one more day with her. Even if we were arguing throughout the entire day, I would be extremely grateful. I never took into consideration the phrase, you never know what you have until it's gone. Until I was informed that Ayana will forever be gone, as it was then that I learned that half of me will forever be gone. Though she will never have a resting place, her loving memories will forever rest within my heart.
No further questions, Your Honor.
Nothing from the defense.
Good to see you again.
Thank you.
Anything further from the state?
No, Your Honor, state rest.
All girl is right. Oh, and they show her. Just an update for you guys. I'm going to put it on Twitter now. So I just spoken to Matthew Moore. Spoke to him. That's what we're trying to do right now. He's super excited for Wednesday. But also, I said earlier on, I've got a T-shirt on sale for fundraising, and obviously it's £10 to him. Sorry, $5 to him, $5 to Zachariah Anderson's fund, and he just asked that we do not donate to him. And so this is a T-shirt I'm speaking about that he wants to hold whole amount of money to go to Zach because he doesn't want it. He'd rather the money go to Zach, so that he can um get his appeal sorted. How cool is that? How cool is that that he's doing that? I think that's very unselfish of him, and he's like, no, I'll do anything for Zach. Let me know what I need to do. Please give my portion of money to Zach. Um, and I'll do anything you want me, or anything you want Solomon to do. If Solomon wants me to do anything, let me know. Such a cool dude. Such a cool dude. I hope you're all here to try and support him um on Wednesday. I'll say his book online is out now, but his book hard book copy, like, or soft book copy, will be out in a week's time. So hopefully we can all try and buy that. But I thought I'd say that. Not that maybe you're interested in it, but that's the story. That's what I've been planning right now. So great of him. Like I've not sold a T-shirt yet, so I was like, well, I mean, $0 of zero is nothing, but still, thoughts that counts.
Members of the jury, I'm going to take a 10-minute break real quick. We'll have an idea of what direction we're going thereafter. It's 11:40. Any longer? Okay, we'll come back at around 11:55. We'll go from there. All right, the jury's outside our presence. You guys may have a seat. I still have counsel for the state defense. Mr. Quiles present. You just want a break?
We're ready to go. We just were going to ask for a 5-minute, but I think a little bit longer. That's no problem at all. But we're ready to go. Dr. Roars, and I'm prepared to be called.
It's already almost 12 o'clock. How long is Dr. Roar going to be? Just so I know for the jury's sake. I'm happy to go ahead and give the jury a lunch break now and just tell them, go ahead and go to lunch. See you back at 12:45. Just so you guys know, my plan would be at this point, have you finish your case. If I'm assuming you can finish it this afternoon, we'll see how long it takes, and then just do closings tomorrow morning.
Wow.
And Judge, just from our perspective, we would be prepared to do everything today. I do not expect that it would take all afternoon to get through those character witnesses. I think if we could get Dr. Rohr done this morning before they go to lunch, and then when they come back from lunch, I don't expect that those other witnesses would take longer than an hour and a half in total. I just don't expect it to be there that long.
Okay, I don't want to send the jury out to lunch at 1 o'clock, though. That's my only, I didn't tell them to be prepared for a late lunch. 1 o'clock is on the latter end. I'd rather just send them home now, or send them away for their lunch break now, and just this 5-10 minute breaks encompassed in their lunch break, and we'll go forward this afternoon. Does the doctor have a conflict that's going to create a timing issue?
No, not at all, Judge. It's just we don't expect it to be lengthy.
How
Bob estimates that his direct would be at max 30 minutes, and I know that the state might have a little bit to say, but I don't expect it to be longer than our direct by any means.
I'm fine with that, the court's proposed schedule. Just give them their lunch break now.
I mean, they heard some powerful testimony. Let me give them a break.
Of course.
That may be the wisest thing to do. It's 11:45. I'll have the staff let them know that they'll have till 12:45 for lunch. So if that's 12:45, let's say Dr. Rohr's an hour, that's 1:45. You think we're closing by 4?
Judge, I would be shocked if we were not done well before that. I think that we'd be perfectly fine to do closings today. I've spoken to the state about the length of theirs. I think both of our closings together would be an hour, maybe slightly longer for the state, depending on what he said. But so I think we could get it all done today, Judge.
All right, I'll make a judgment call I'll make a judgment call this afternoon. I don't want them closing and being charged at 4:30, 4:45.
Understood, Judge.
That's my preference. They may have a different preference, but.
The state will be prepared for closings as well.
Okay.
Yeah, whatever the court wants, Judge, we'll comply. We're ready for today. If we need to do it, and there's plenty of time, we're prepared to move forward.
Okay, and what I'll do is I'll have courthouse IT. So number one, please let the jury know they have till 12:45 for lunch.
12:45.
And then I'll have courthouse IT in here setting up the courtroom for Zoom purposes for your witnesses this afternoon. Just so you know, there's a camera on the evidence cart. That will essentially be your camera. The clerk will go over there, swear them in. That monitor, what you see on the evidence cart, will be on all the devices in the courtroom, and the audio will be hooked up. So essentially, they're still using the audio in the courtroom, just like you do in first appearance court or like you do in a typical courtroom with Zoom nowadays. They recommended that would be the easiest process, and you have the Zoom ID, and I can control that up here as well.
Yes, Judge, and I've already provided the Zoom ID to the witnesses, the 3 witnesses that will be appearing via Zoom. And we did test, not on that Zoom number, of course, but on another, their devices. I've gone through that with them, so I'm hoping we have no issues today whatsoever. But we
Okay, just give them a time that they can Zoom in, and we'll leave it up to you to make that time work, and I'll work if it fits in with your schedule or you want to move things around, whatever you want to do.
Yes, Judge, now that we know the schedule as far as lunch, I will call them and make sure that we know that during this break here that they're available and try and get them on this afternoon.
Okay. Anything else we need to handle outside lunch? If we are going to closings today, I ask you to look at the final instructions. The one question I had stated is that part of the final instructions include if they put it in a lack of record, I think he has a possession of marijuana charge. I'm not sure if you want that to rebut the lack of record, if that's worth it to you. Please take a look at that and let me know the state's desire. Everything else in the final instruction should be rather absent the mitigating circumstance, which I read, which I asked you to go over again to make sure that's the list in the order you want it. You don't want to combine anything or separate anything further out. Just take a look at it. I did it the way you guys proposed, since I figured that's why you put it in the pleading that way. Just take a look at that, and we can discuss that. Maybe get here at 12:35, and we'll discuss those issues.
Yes, Judge, I think there's a way to consolidate just a little bit so it's a little clearer and not repetitive for several of them. So we'll do that over this break and make sure we have that to you. So we do plan to give you something additional from what you
do it over the break, or what I would ask you to do maybe easier is copy and paste those mitigating circumstances into a separate Word document, work off that Word document, and then maybe email it back to me over the break. Email it to me back over the break, and we'll take a look at it.
Yes, Judge, we'll do that.
All right. See you guys at 12:35.
Thank you, Judge.
Okay. So there's a bit of a break now. That's the one I created. Hang on, just created. I made a mess up earlier on, you see. I started the wrong stream. So just trying to fix it. I am. Because that's who I am. Hang on. Right, what are these? What are you guys saying? Hello, Anne. Bore dan. Oh, afternoon for us, isn't it? Hello, Anne. Yes, afternoon. Proud da for me and Emma. And it's becoming afternoon nearly in Eastern as well. So New York, Mary, nearly afternoon. I thought you were going to go and pressure wash your grandparents there for a second. I wouldn't put past me, Jonathan. Wouldn't put it past you, son. Go and pressure wash the grandparents. Right, I need to. Josie, I'm trying to tag people in here. Solomon, Sarah P. See if she's bloody going to do anything on Twits for me. Sarah P. tagging you in. Free Zachariah Anderson. Zachariah Anderson. Chloe. No. Free Zach. Trying to get as many people as possible on this. Free Zach. Free Zach. Then I will be with you. Free Zach. That's pretty cool of him, though. Only if it proves himself. I think that's really cool of them to do that. For Matt to give his donation to Zach. Anyone else? Let's do Marge as well then. I can't. Oh, okay. So I think I've got most people in there. Right, what we doing then? Right, hang on, let's just put the Matthew Moore here. That's optional profits from the t-shirt. T-shirt. Sales given to the Zach Free Zach Fund. So that is 10 for Zach. Resale. Please come support Matthew on his store. So on Wednesday, link here. That's fine. Post. Let's post. Let's post. Posted. I get tagged in all sorts. Writer's Cup schedule. Don't want that. That's fine. Day Portnoy, that is fine. Right, so what are we up to? I think it's break time. So go take this. So, I need to message Erin back. She messaged me. Sorry. See, so popular. It's unbelievable. Yeah. Down people's throats. I don't know. I just want to know. Ba ba ba. Happy Erin Hack, happy anniversary. Anniversary today to you and hubby. Yeah, it's nice. Okay. Just need to get that. Slow and steady wins the race. So I'll stay on for a little bit. 11:45 they said, isn't it? So that's 5:45 my time. That's fine. So yeah, I'll have to go and get something to eat, but I'll leave it for now. Leave it for us now. How are you, Anne? Hope you're well anyway. Hope everyone's well. I just want to take the crown off because Erin Hack's not here. She can't be here today. But we'll wear her again. Another point. I think I've done enough of it today. We're nearly 3 hours in and I've wore it for most of the stream, so I'm the best around. Dee-dee-dee-dee-dee-dee-dee. So what I did this morning, was like a bloody idiot. I streamed the wrong stream, didn't I? So my Matthew Moore one on Wednesday, I've put the links out to everybody. It's no longer the same one. Idiot. Did the wrong one. Oh my days. What am I doing? Anyway, the court's back in 45 minutes. Go and grab yourselves some food, drinks, whatever you need. A pee like Johnathan. I love the fact that he said something about his father pisses all over the seat. Love it. Love it. Oh, I can imagine how you women would react to that. Oh, got to love it, be it. It's all good. Ah, lovely, Anne. Lovely to hear you're all good. That's what we like to hear around here, that everyone is good. We like to hear. Oh, yeah. Monday blues, isn't it? I always feel Monday's my least favourite day of the week. If you told me to take either day off on a Monday or a Friday, I'd take it on a Monday. I should do that. I should take Mondays off. I prefer to take Mondays off than Fridays off because I dread Mondays. I hate Mondays. So knowing that you start work on Tuesday, I don't know, something quite nice about that 4 day week, like. And then knowing that come Friday when everyone else is going off, going, hey, got a day off Friday. I'm like, cool, it's Friday. Everyone's off. So no one's here to do any work. So I technically got a day off in work. Oi, oi. So that's the way I look at it anyway. That's the way I like it. Who sings this? That's the way I like it. Dun, 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 dun. Oh, that's the way I like it. That's the way I like it. I don't know who sings it though. Is it Backstreet Boys? We've got. Oh, so what I did over the weekend was I made American pancakes. Lovely jubbly. They were lovely. Had maple syrup with them. Gorgeous. Had it Saturday evening and Sunday evening. It was so nice. Made a fresh batch for both. Loved it. I gotta be honest. I love American food though anyway, except for the white gravy stuff, which I need to try. Sarah P's given me a recipe, which I need to try it. To have chicken and white gravy or country gravy, whichever you guys say. So yeah, got the recipe. Just need to make it. Considering the fact that I did this stream and I'd never tried tacos, I've already tried tacos. Liked it, loved it. It's part of my now when I buy stuff from Morrison's from the store. I buy tacos now as well. There's people here busy in work, so that's why chat's quiet. People are like Ace and stuff are busy working. Um, I think people like Sarah P probably sleeping a little bit. Monday to. I'm seeing Josie today. Don't know what she's up to. Hope she's okay. I'm sure she is. Bum, ba-dum, ba-da-da-da. That's the way I can't believe no one knows that song. Jonathan's gone to power wash his grandparents. They poop. So yeah. But now's the time for a break, guys. If you need a break, just go. I'll stay on for another quarter of an hour or so, and then probably go for a bit of food myself because we got 45 minutes before the call comes back. So plenty of time for people to do whatever they need to do. Um, because I don't want to stop it and start another try. Do you know what I mean? I'm just like another stream. I'll just keep going with this stream now. Do you know what I mean? Might as well. Same with the Matt Moore. I'm just doing one stream. I'm not gonna play about and skip stuff in it. Skip it. Skippy, skippy, skippy. Skip. Ugh. But it is quieter today. I don't understand the chat today. And also, we should be joined by Lady Law. You know Lady Law, my favourite. So we should be joined by her Wednesday. But she did a caveat. Get something yummy to eat. Yeah, I don't know what to have, and I don't know what to have, you see. I don't feel like eating that much. It's too early. It's like 5 o'clock here, so it's early. Do you know what I mean? That's the problem. You see, if I get food now, which I will, but then by about 10 o'clock tonight, I'm gonna be like, oh, I need some munchies. I need some. Do you know what I mean? But needs must. So Lady Law was joining us for a recap on Wednesday, but she's got a massive caveat. Massive caveat. She might be a granny again. So her daughter is in. I think she's due either. I think she's due on Wednesday or tomorrow or Wednesday. She's due her daughter, so she's going to be grandmother. So if the baby's born on Wednesday, obviously she won't be with us, which I'm like absolutely fine. She's going through some exciting stuff. She's got a new job, and she's got she can tell you all that herself. I'm not sure what she wants to tell you, in all. But she tweeted out she's got a new job. I hope she did anyway, because if she didn't, then she's gonna kill me. Um, but no, I think she did. And yeah, I won't say where or what or how or how for now, but that's up to her. But yeah, and so lovely, isn't it? So she's got two grandchildren already, third on the way. She's had it. Her ex-husband had a massive heart attack the other day. Um, then what are you talking about? What are you on about? Are you not listening, Sarah P? Are you not listening to me? Is that the problem? Um, Lady Law's son had to have an emergency operation a couple of days ago as well. So she's been through through the wars. Like I was talking about Lady Law, that she might not be able to make it tomorrow, Wednesday night, for the Matthew Moore recap session because she's going to be a granny on Wednesday. So if the baby comes on Wednesday or Tuesday, then I'm taking the piss out of you. I know you have to work. I'm only joking. I'm literally ever say sorry to me because I know I'm joking. So she will make it Wednesday except for when the baby comes or if the baby comes. I think if the baby comes Tuesday, she'll still be there on Wednesday. She said, but we'll see. There's no massive rush. There's plenty of the times anyway. Oh, but as you all know, she's a proper gilf. So yeah, quite young. But lovely, lovely. And I've got the MILF coming on before long, as I say. Got Ms. Morgan. If you've not met Miss Morgan before, she's a very attractive young lady from well, I'm not New Jersey area, Pennsylvania area. She's like bordering on both, So I've done some stuff by Brian Kohlberger with her already. I'm gonna do the Karen Reed stuff with her. Probably not the first episode with her, because I'm gonna just go do some of the links, some of the documents on the first episode, and then get her in. And that's another one I love, Ms. Morgan. So if you've not met her, you're in for a treat. Not only is she absolutely gorgeous, she's also highly intelligent. She's basically similar to Lady Law. Um, and just happens that they're very pretty as well, which is amazing. But I love them because they say as it is, and that's all I want from everybody in this channel. Say it as it is. Say it as it is. Sometimes I say it as it is, but too much. I like to tell the truth, and I like to say it as it is, but sometimes people don't like that. So I try and keep it back a little bit. But when it comes to trials and stuff, I always tell, say as it is. But I'm always open to suggestions and stuff as well. Ba-da-ba-da-ba. So yeah, I think we've got some exciting stuff going on. I'm not sure what the next actual trial is going to be, but it certainly will be. It will be a trial because Judge Boyd has just finished up a trial, and I know there's another one that we could be doing. So because I'm not sure how far this is going to happen, this trial, because he's on about doing closings tomorrow. I was like, I thought we could be done today. I thought they could be charged today, not like I understand this is, delicate. It's a death penalty case. And, you don't want to give it, he's right, you don't want to give it to him about 4:30, 4:45, and then come back like 10 minutes later going, yeah, 8 of us have said death penalty. That's not what you want. You want fresh pair of eyes, everyone to be awake, and having sat there throughout all of that, testimony, you're probably not going to be fresh awake. You're probably going to be like, whoa, that was intense. So, yeah. So maybe, he just gives it to them tomorrow morning. And if that's the case, excuse me, if that's the case, we're here. We're here in the morning for it. If he's doing it tonight, then I won't be here for it. I've got a gym first thing in the morning, so I won't be here like really, really late tonight watching it. But I'll stream it in the morning instead then, so you don't have to worry. Whatever happens, I'll be streaming it. Um, anyone new coming back in, please like and subscribe. I'll do the mod work. It's sometimes if you want a job done, you just do it yourself. It's easier, do you know what I mean? So, please like and subscribe. Look at Sarah; she's probably what? Oh, motherfucker! Um, but just a statement for the mods. Like obviously the mods do work as well. So shout out to the mods. Thank you to Sarah P. I'm not sure what Josie is today, but I'm sure she's busy with meetings and stuff. But shout out to them because they do work whilst they're here. And I'm not the easiest person to deal with. I think I am easy, but still, I'm not. I like to take the piss out of them. So they take a lot of abuse from me in a friendly banter way. But appreciate them every single day for coming here. But there are times like this where I just got to do it myself because they're lazy as fuck. But no, please like and subscribe if you haven't done so. Really appreciate that. Um, do a bit of blagging. Obviously, if you're not a member, please consider being a member. You can become a member. I believe it's $4.99 and pounds. Just press that join button. You become a member. It helps me out immensely. It basically pays my wages, so pays my internet, pays my bills basically. So there's that. So and also you're part of Blue Wenches. What do you get as a Blue Wench? Well, you get abuse every day when you're on in the chat from me. You also get members only streams, which normally are on Thursdays, and we'll do one this Thursday. And you also get access to Discord, which is absolutely crap at the minute. I won't lie. If I was just membership was just about Discord, I wouldn't buy it because it's absolutely rubbish. However, our members only stuff I think is good. I think I do a lot for the members only videos, but that's up to you to decide. It's up to you. I don't put it. Some people can't afford it. Please, you don't missing out on that much either. So do not worry. So there's that. Obviously, you've posted about the got a merch site now, so obviously the merch is all there. The link to the fundraising t-shirts there. So $10 of that profit will go to Zach's fund. If we sell any, I've not sold any yet, so we might not sell any. But if we don't, doesn't cost me anything, doesn't cost you anything, and it's a thought that counts. Some people would prefer to give Zach the direct money directly, which I fully appreciate and understand. But I'm trying to offer something that you get something out of it as well. You get a free T-shirt, I get free marketing, and Zach gets $10, and then that company gets the rest. Whoever the company are, Spring or whatever they're called. Um, so yeah. Um, and obviously I've got loads of other merch and stuff as well. Uh, consider joining our family. There we are, Sarah. There she is. So this is good. She's done this now. So you can. The first link is to join the membership only stuff. Or the second link is so if you press the second link, I believe. Let me test it out myself just in case. How cool is this, right? How cool is this, right? So the first link takes you to, I believe, where the membership stuff is. And second one then is for PayPal. Now this PayPal takes, it does take 9 or 10%, but it's much better than super chats and stuff because they take about between everything about 65%, which is a pain in the ass. Oh, I was gonna. Why is this not working then? Top tipper is me because I am the best. Tipping myself. So basically, I tip myself and I lose money. I can't type. Oh, there she is. Sarah P's on the ball now. She's going for it now. And the second, obviously, post is about Matthew Moore. Oh, is that the right link, Sarah? Now, let me. It is as well. Look at her. She's a great one. I'm gonna like that one now then, because I messed up the other one. Here she is. Guess who's back? Back again. Luna's back. Tell a friend. Guess who's back? Guess who's back? Guess who's back? Luna's back. Hey, Luna. Luna, my darling. How are you? Hope you're well. Um, we need to bloody get these links to Luna. Freaking nightmare she is. Still hasn't fixed her bloody account yet, so she can't be a member. There's always one, isn't there? And Luna is our one. So I don't blame her. It's all good. It's all good. But yeah, the second one, why won't this type then? Hang on, if I go somewhere else and try to type it then, will that work better? No, that works. Fine. Oh, okay, that's why. So if I do this now then, right, look how cool this is, right? Look how cool this is. Hang on, it's coming now. So oh no, I'm good, thanks, Loons. Hang on, I just need to, do this, and then send this. So this is the second link that Sarah put up for the PayPal. So instead of doing super chats and all that, you can do this. And what happens then? Hang on. Oh, I gotta do this way. That's why. Oops, I did it the wrong way. Hang on. So you can pay by PayPal or credit or debit card, credit card. So look at this coming now. Hang on. Hang on. Look at it on the screen. Alternate corner donated six. I didn't. Did I? I did it £5. Look at that. That's cool, isn't it? So instead of super chat, do that one, and it comes up on screen. Yeah, it's great. So basically, I do that, you see, Anne, because that means I get to keep about 90% of it, or maybe 80% of it. Whereas after it gets converted, whereas super chats and all that stuff to YouTube, I get about 35% of it. They take so much. It's unbelievable. So that's the best way. Now, there's also PayPal directly, which some people prefer, and stay anonymous, which is absolutely fine with me. I get to keep 100% of that, but it doesn't flash on screen then, you see. So, but the main thing is joining the community. I'm trying to get Luna to join this community. She's been a day one now nearly, and oh, this girl, she wants me to send her like pictures of myself topless and dick pics and everything just to become a member. Unbelievable, this girl is. Unbelievable. I would though. If she asked, I probably would though. So anyway, Hope you all are well. Um, Sarah P is very happy. Bang bang, Niners gang. She's happy on Thursday. Luna, Luna, Luna. I love Luna. Luna's my love. She's like my crush, so I didn't. Oh yeah, I tipped myself $6.11. It's £5. I will forget that. But that's cool, isn't it? And if people missed it and go, oh, I missed it, I can just go like this. There we are. I can just go, hey, there we are. So you can see it in case you missed it. Um, anyway. Oh no, says there six. No, I only tipped myself once, not twice. Jesus. So here we are. Um, as I say, I'll stay on to about 1:30 now. Then I'll be back. I'll give myself a quarter of an hour break, and then come back on. They're back on a 1:45. So I'll leave this. No, I won't leave this. So when I go to break, you see, I can just do this. How cool is that? Or this one. That's the benefit of this. That's the only, I think, benefit really for this. Perfect. Yes, it's good. Okay, we get out of that. We've gained, oh yeah, 3 members today. Yeah, gained 3 members. Nifeth, that was one, and then Mars and Sandra, I gave 2 out to them. That's what the only thing I don't like with YouTube with their membership gifting is you can't gift it to anyone. That is random. Do you know what I mean? I don't like that because people that might never come to this channel gets a membership. And it's like, what's the point? You don't watch it at all. That's my only. I'd rather people that watch it. I get it, but I'd rather people that watch it get it first. After that, I don't care. But so then I got to think about what I had for dinner. I had Cheerios for breakfast. I had toast with banana for lunch. I don't know. I don't fancy anything. Well, I do fancy some stuff. Oi, oi, but I don't fancy food. So we'll see. Don't know. I only got a quarter of an hour as well. Well, I don't. I got more than that if I want to, but um, right. You know what? I think I'm going to take a break now and come back at 1:45. That gives me a little bit of time because I know you're all worried about blood clots and all that, so I can stand up and go for a bit of a walk then. So that's what I'll do. So because no one's chatting either, so that makes it perfect timing. So with that, I will be back at 1:45. It's 20 past now, wherever you're at. 20 past, and I'll be back at 1:45 when the court's back, and I will, yeah. So I'll be back at 1:45. Love you. See you in a bit. Enjoy your break, and you, Mary. See you in a bit.
Back on the record. 518. I have Counsel of State Defense, Mr. Quiles present. I wanted to talk about the jury instructions. Was made from either side. So what you'll see is I don't think the instruction for defendant is applicable for this phase of the proceeding. Instructions I read to you phase. So I just need to Anybody have anything to say?
As we defer to the defense,
Just give me 1 second.
Sure.
Defense agrees that 6 and 7 can be removed. Wait.
How about 8, 9, 8, 9? Is it applicable to this phase of the proceeding?
defense wants it in, we'll agree. If they want it out, we'll also. I agree with you. It's just a statement. The next several witnesses were deposed. The other issue, Judge, too, is, as you've heard us say in essence, we're all our aggravating factors.
Well, and I think the instructions say it refers back to other instructions.
It's fine with the state to leave it if it's
Accomplice and informant testimony.
we agree that should.
So you're just taking some out.
ones, but I don't know if that, just for time's sake, I know that I don't want the jury waiting on us unless you want to wait and do this.
Why don't you
Number 23. Well, number 28.
It's probably about it.
Yes, Judge, I think that's it.
Okay, I'll take a look at that. I believe I looked at the ones that you mentioned, and they all seem to be kind of encompassing other ones as well. I'll defer to you guys, but maybe at the next break we'll talk about this so we can get the jury going at this point.
Yes, Judge, we're ready.
Is there anything else that we need to discuss?
No, Your Honor.
Has Zoom been set up?
Yes, Judge, just for the record, they came in, we pulled Zoom up, we actually had one of our witnesses who happened to be on, we tested with her. I did not test with the other witnesses, but we were able to figure out the kinks. I think we won't have any issue with that as long as everyone gets on fine.
Okay. You guys ready to bring the jury in then?
Yes, sir.
Judge, just for purposes of the record, after speaking with our client, Matt, and we want it on the record, the reason we asked for a short break is several of the jurors seem to be crying or getting choked up, as well as, and forgive me, Your Honor, but you look like you were getting pretty choked up during one of the witness statements yourself.
I think I held it together quite well, given what was said in court.
And I understand. I'm just saying that's why we asked for a short break.
Understood. And that's why I wanted to give the jury a short break after that testimony, but the defense wanted to go right into their case, which is why I went right into the case, given the hour, because I kind of contemplated something occurring of that nature, given what we anticipated hearing in victim impact evidence. But nonetheless, I think it worked out just fine the way it worked out.
Yes, sir.
Otherwise, we ready to bring the jury in?
We are.
Yes, sir.
Let's bring the jury in, please.
Your Honor, the jury's re-entering the court.
I'll be back now.
Members of the jury, welcome back. You guys may have a seat, of course. I'm now going to look to the defense for their case. Mr. Davis, Ms. Michelle, you may call your first witness.
Dr. Jennifer Rohr.
Dr. Rohr, please. Good morning, good afternoon, doctor. Come on forward to be sworn in by the clerk.
You solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God. I do.
Good afternoon, doctor. Let's watch your step as you come forward to your right. Need a glass of water, let us know. We'll do our best to accommodate you.
Thank you.
That said, Mr. Davis, you may inquire. You're ready.
Thank you, Your Honor. Good afternoon, ma'am.
Good afternoon.
Would you state your name for the court?
Jennifer Rohr, R-O-H-R-E-R.
Where are you employed?
I'm self-employed as a clinical and forensic psychologist in the states of Florida and Virginia.
Okay. And can you tell the court what your educational background is, please?
Sure. My highest degree obtained is a PhD in clinical psychology from Kent State University, followed by a pre-doctoral internship in forensic psychology at Florida State Hospital, followed by a postdoctoral residency in forensic psychology at Georgia Regional Hospital in Savannah.
Okay. And after you completed your education, where were you employed after that?
Many places. I started off as a forensic psychologist at South Carolina Department of Juvenile Justice, doing post-adjudication evaluations of juveniles. I also worked at Dorothea Dix State Hospital, which is one of the oldest forensic hospitals in the United States.
I'm just saying hello, Daddy Dave. Daddy Dave, hello. New daddy in Alliance Thursday for first place. You were lucky Sunday, Daddy. You were lucky, Dave. Um, Baby J. You can't hear me still. You can hear me now because I've unmuted myself. Surely. Hopefully. But Sarah, please tell me they could freaking hear me. Because the delay, you see, so I'm hoping it's a delay. But you were lucky Sunday, Dave. Baby J did not play that well. Great granddaddy. Thanks, Sarah. Great granddaddy. Well, great granddaddy, you need to sort yourself out, great granddaddy. You need to sort your membership out. You need to get a membership. This is my dinner. Sweet and sour chicken and white rice. I know some people will say I should have brown rice, but that's all I had. Lucky's winning the ugly. Yes, you're right. You're right. But I didn't notice you without your green on. So your green's gone, Dave. Not good. We'll have to get your membership. Right. A win is a win. Bang bang, Niners gang. Bang bang, Niners gang. Right, let's get back into it. I'm going to switch my camera off now once I eat.
United States also as a forensic psychologist. Moved to Washington, D.C., where I worked for D.C. Superior Court as a forensic psychologist. Also taught at George Washington University in their forensic psychology program, and also developed and ran a forensic psychology program as department chair at the Chicago School of Professional Psychology. During that time, I also assisted with the Alexandria Police Department, teaching police officers how to interact with people with mental illness. I then relocated to Florida in 2016 and have been in private practice since that time.
Okay. And how many times have you testified in court?
About 300.
Okay. And have you also worked on other cases of this nature, capital cases and homicides?
I have, yes.
How many of those?
Maybe between 50 and 75.
And how often do you render an expert opinion?
In court or just for an evaluation?
In evaluations, how many have you done?
I've conducted over 7,000 evaluations in the course of my career.
And how many opinions have you rendered in court?
Well, about 300 when I've testified.
Judge, I'd offer Dr. Rohr as an expert in psychology.
There's been no objection, so continue.
Okay. Thank you. All right, ma'am, did you have an occasion to go or occasions to go and meet with Johnathan Quiles?
I did.
Okay. And as going over there and meeting with Mr. Quiles, what is part of your process as far as going through and preparing an evaluation and psychological eval?
Sure. So I review all the available legal documents with which I'm provided. I met with Mr. Quiles a total of 3 times for about 4 hours at the jail. I collected background information from him in terms of family, educational, employment, mental health, substance use, and criminal history. I also conducted a mental status examination to identify or observe any possible signs of mental illness or intellectual disability or psychiatric impairment. We also did some psychological testing. I administered a brief IQ test and also a personality assessment inventory. And then I wrote up a report after speaking with his aunt.
Okay. Now, in going through this, some of the factors that you take into consideration, I know you said you went over all the police reports and evaluation, or police reports and all of the evidence that was provided to you as best you could. Now, after speaking with his aunt, what were some of the factors that you came to use in doing this?
Are you asking the factors that I felt most relevant in the case?
Yes.
Yes. So based on his self-report and speaking with his aunt, I learned that he had been raised in a high-crime, poverty area of New York, that his mother suffered from mental illness and also, I'm sorry, his wife, I apologize, his wife suffered from mental illness and substance abuse. His mother passed away in 2010 from bone cancer. I think that her death was extremely challenging and hard for him. They were very close, and he described himself as a mama's boy. I learned from his aunt, and Mr. Quiles confirmed that his dad was largely absent from his life, and when he was present, he was a negative influence. I believe Mr. Quiles referred to him as a schemester. I believe his dad had a pretty extensive criminal background from what I understand. And then also he reported a history of childhood physical abuse by one of his mother's former boyfriends.
Okay. Did he also self-report drug use?
He did. He told me that he began using marijuana, it was at age 11, and had used alcohol regularly since age 13 or 14. He did suggest that the alcohol abuse was encouraged by his family, that it was normative in his family to be drinking a lot.
Okay. And also, as part of your assessment, can you tell the court when or what his school and education was?
Sure. He withdrew from the 7th grade following the birth of his first child. And that was the highest grade he attained. So he completed the 6th grade.
Okay. And did he become gainfully employed after that?
He did. By all accounts, he's maintained employment and has been successful at all of the jobs that he's been at. Lastly, at the junkyard.
Okay. And did he tell you some of the jobs that he held?
He did. He said not only did he work at the junkyard, but he had previously also worked in construction, maintenance, and as a truck driver.
And as part of your assessment, you said you did an IQ test. What were the results of that?
He obtained a full-scale IQ of 90, which falls in the average range.
Okay. and despite not having completed any school?
That's correct.
All right. Well, I shouldn't say any school, but moderate school. He didn't get through the high school.
Correct.
Okay. Now, in addition,
Yes, Sarah, he did. She did say that. He did. She did. What is 7th grade? How old's that in the US? Jesus.
to that, as part of your assessment, and going over to the jail, what were some of the things that struck you as significant in meeting with him and going over his records?
Each time I went to the jail and signed in, I spoke with the officers, both in public reception, which is the entrance to the jail, and also up on the floor, on the 5th floor where he's been housed each time I've seen him. Every time I've gone there, numerous officers have told me he's been a model inmate, which is very surprising. They actually assigned him to be an alternate trustee, which again is highly unusual given the nature of his charges at the time. Even during lockdown, when the other inmates were locked in their cells and weren't allowed to come out, Mr. Quiles was given the opportunity to even clean the jail, even in the restricted areas where there were no cameras. To my knowledge, he never abused that privilege, and that suggests some level of trust by the correction officers that they could trust him to be around the jail, around phones, around possible contraband. And to my knowledge, he never took advantage of that because, to my knowledge, he has no disciplinary records, DRs. I also learned that he often read the Bible to those inmates who could not read, and that he helped care for some of the more vulnerable inmates at the jail.
Okay, and as far as when you say more of the vulnerable, can you expand on that as far as what you mean?
I was told that he had assisted some of the elderly inmates and also just less vulnerable, those that probably could not protect themselves from the more aggressive inmates in the jail.
Okay. Now, in your years of doing this, is that pretty, I mean, I know you use the word rare, but I mean, in your years, have you ever seen someone with a charge of this nature working as a trustee?
I have not. I was very shocked when he told me, and I did verify it because I was so surprised by that fact.
Okay. And how many years of that, of you doing this have you been, or how many years have you been doing this?
Since 2005.
Okay. So 18 years?
About, yes.
Now, besides that, in speaking with his family, what were some of the other notable things that stood out as far as Mr. Quiles?
I spoke with his aunt. She described him as extremely generous with his time and assistance, always willing to help others. She described him as a very good father, a very hard worker, said that he would do anything to help anyone in the past and would continue to do so. She also noted that she felt, in her opinion, that a lot of his problems early on were due to the absence of his father. She indicated that they had reconciled somewhat prior to his arrest in this case, but she did feel that that was an absence in his life, that his father was not present.
Okay. Now, as part of your assessment, what is your overall thoughts of how he could be productive as an inmate if it were considered to be life?
I mean, I think he has shown over the past 5 years in the Duval County Jail that he hasn't violated the trust that the correction officers have given him as an alternate trustee. He's had no disciplinary action or reports. He has helped other inmates, particularly the elderly and the vulnerable. I feel as if in a structured environment, He could be as productive as one can be in a prison setting.
Okay, so you, as you stated, in a structured environment, so in a setting such as that of, at the state prison, then he could be a productive member as an inmate
Yes,
and be able to assist others,
I do believe that, yes.
okay? And to be clear, life is that. He has no opportunity of parole or anything else, correct?
Correct.
All right. And is there anything else that, in your review of his records and everything that you've gone through, that you feel would be notable for this court to consider and for this jury?
I don't think so. I think we've touched on everything that was part of my evaluation.
All right. Judge, if I may have a second with counsel. Just briefly, ma'am, in going over your assessment, you did what's called a PAI, a personality assessment inventory.
That's correct.
What is that for the court?
It's a personality test. It's probably the second most widely used personality test in the entire world. It assesses both personality characteristics, but also any type of psychopathology, so any types of mental health concerns ranging from depression to schizophrenia to insomnia to anxiety to substance use disorders. And then it also looks at those personality traits and how one interacts with the world and the people around them.
And as part of your assessment, what are your findings?
Based on the testing results, his testing results were valid, meaning he was genuine and honest in responding to the questions. His results did suggest a personality style or personality characteristics consistent with an antisocial attitude or tendency.
Which means what, if you don't mind, in layman's terms?
Sure. So his results are consistent with an antisocial personality disorder. Antisocial personality disorder is a condition in which one's personality characteristics or traits are often maladaptive or unhealthy and impair functioning in a certain way. In this particular personality disorder, the antisocial, it's typically violating the rights of others. It could include criminal behavior, but it doesn't always need to be criminal behavior. It could be manipulation. There could be some arrogance, some entitlement, deceitfulness, if I didn't say that already. But we often think about it going along with criminal behavior.
Okay. And for lack of better words, narcissism?
Yes, narcissism.
Anything else?
The testing revealed conflictual interpersonal relationships, a lot of problems with interpersonal relationships based on the testing.
When you say that, can you give an example, please?
Sure. Again, this is based on testing, but based on the testing, which again was valid, it suggested that a lot of his relationships have a lot of conflict. He may be impulsive, egocentric, angry, may lash out at others in the context of those interpersonal relationships, may be very impulsive when he lashes out, feeling that he has been slighted in some way.
Okay. And as a result of that, most of his relationships don't last a long period of time. Would that be accurate?
I'm sorry, could you ask that again?
Do most of his relationships only last for a short period of time? Or conflict in the relationships?
I mean, based on the testing, his relationships, whether they're short or long, tend to be characterized by high conflict.
All right. Nothing else, Your Honor.
Please, Court. Good afternoon, ma'am.
Good afternoon.
Just a few follow-up questions for you. Ma'am, now you saw the defendant on 3 occasions. Is that what you testified to?
Correct.
Yes, ma'am. And doctor, did you see him on June 28, 2023?
Correct.
June 29, 2023?
Correct.
And July 21, 2023?
Correct.
So you first saw him approximately 90 days ago. Is that correct?
Yes, that's correct.
And you'd never seen him prior to June 28, 2023?
No, I have not.
Hadn't talked to any correctional officers about him all the way back to 2019, 2020, 2021, or 2022?
No, never.
The only ones you talked to were during the 90 days or so that you met him?
Yes, when I went in to check in and see Mr. Quiles.
Okay. And in fact, you authored your report on August 23rd, 2023, right?
Yes, that's correct.
And if your last visit was July 21 of 2023, that means you really only were at the jail talking to correctional officers between June 28 and July 21 of 2023, correct?
Yes.
So about 30 days of a sample size is your testimony with respect to who you talked to over there?
Well, those are the times I spoke with the officers.
Sure. You looked at records as well.
I'm sorry?
You looked at records as well, correct?
I did, yes.
Okay. Now, your 3 visits also included a total of about 4 hours you sat down with him?
That's correct.
Did you listen to the 2-hour wire that the jury heard where he was corresponding with 2 other inmates?
Unfortunately, no.
You never heard any of that?
I did not.
Now, you told us you interviewed one other family member, and that was an aunt. Is that correct, ma'am?
Yes, sir.
You didn't talk to any other family members?
No, he asked me to speak to his aunt.
All right, that's where I was going next. Did he only ask you to speak to his aunt?
Yes.
Now, ma'am, you also kind of went over some of the testing that you did. Did he tell you as part of your testing or in your interview process that he had 5 different children?
Yes, he did.
All right. And did he say that those marriages failed due to his infidelity?
He said the first one failed due to infidelity on his part.
All right. And he also told you he left school after the 7th grade during his 7th grade year, correct?
Withdrew from the 7th, correct.
All right. And he did that because he had his first child?
That's what he said, yes.
Now, you agree you did not diagnose him with any kind of mental illness? Do you agree with that?
So technically personality disorders are classified as mental illnesses according to the American Psychological Association, but they are distinct from mental illnesses that we think of like a bipolar disorder or a schizophrenia or a depression.
Okay.
They're different. They're qualitatively different.
Isn't antisocial personality disorder basically characterized by disregard of other people?
Yes.
That was your diagnosis of him?
I actually diagnosed him with a mixed or an unspecified personality disorder because I saw features of both antisocial and narcissistic personality disorder. So the 2 of them combined.
Now, but you also saw no history, either in records or in your interviews with him, of any kind of depression?
No.
Suicidal etiology?
No.
And did you inquire of him about whether he entered a substance abuse program at age 15?
I did.
What did he say about that?
He told me that he voluntarily admitted himself to a 2-year substance abuse treatment program at age 15 to get away from his family, his neighborhood, just to get away.
All right. Now, Doctor, do you agree the defendant is fully oriented?
Yes, absolutely.
You agree he's friendly,
Yes,
engaging?
yes,
He has the thought processes that are coherent and relevant?
he does.
He's not distracted by any kind of internal stimuli?
Correct.
He's not delusional, correct?
He is not.
You believe he is adequate with respect to attention and concentration issues?
Yes,
He has no memory issues, correct?
correct.
No intellectual disabilities of any kind?
No.
In fact, you've described him as being average, correct? With
Yes.
respect to his testing.
Yes,
Now, you chose in your testing to give this PAI, that's a personality assessment test?
it is.
All right. Is that where you glean the personalities that you described at the end of your direct examination?
Are you referring to the diagnoses?
Yes, ma'am.
The diagnoses are based in part on testing, but also on one's history and also current presentation.
Well, one of those you said was, quote, conflictual interpersonal relationships, end quote.
Yes.
That's how you described them.
Well, yes, that was based on the testing.
Okay, and what does that mean?
Conflictual relationships,
Yes, ma'am.
one having trouble in interpersonal relationships. It could mean a variety of things. The testing, and I did mention this briefly a couple minutes ago, according to psychological testing, his conflictual relationships are because, in my opinion, because of his maladaptive personality traits of being hostile and impulsive and egocentric, entitled.
So that includes interpersonal relationships with significant others,
Sure.
not just immediate family members like his father or his mother.
Yes.
Any relationship.
I would say most, if not all. Yes.
All right, and I think if I heard you correctly, you described him as impulsive. Is that correct?
Yes.
Self-centered?
Yes.
Hostile?
Can be. Yes.
And also, I think you testified that he lashes out impulsively against one who slights him. Is that correct?
Based on testing, yes.
You described him as egocentric.
Yes.
Hostile?
Can be.
I think you said angry as well.
I did.
Now, does the testing show you that he externalizes blame? And if so, will you explain that?
I don't know if that was specific in the testing, but that kind of falls under antisocial personality disorder. Typically, those with that personality disorder and the other personality disorder, narcissism, they tend to externalize blame, project blame. It's someone else's fault.
All right, now that was my next question. That's somebody who describes situations as not his own fault, not of his own doing.
Correct.
And that's how you describe the defendant.
He does externalize blame, yes.
One moment, Your Honor. Nothing further, Your Honor. Thank you.
Just briefly, Dr. Rohr, now, despite those issues that you just went over with the state, as well as with myself earlier, Johnathan Quiles can be a productive member as an inmate if he were to be considered for life, correct?
I believe so. I believe he has shown that by what I've learned about his behavior at the jail, and again, no disciplinary action. Now, whether his behavior in the jail is altruistic, meaning he truly wants to help others, or whether he's satisfying his own narcissism, I don't think that matters. I do think he's demonstrated for 5 years in the Duval County Jail that he can go without getting into trouble, breaking their trust, breaking the law, getting new charges. So yes, I do think he can conform his behavior despite what motivation that might be.
Okay, and to be clear, have you ever seen someone with these type of charges be a trustee?
I have not, no.
No further questions, Your Honor.
Doctor, good to see you, ma'am.
Thank you, Your Honor.
The rest of your day.
You too.
Mr. Davis, Ms. Michelle, you can call your next witness.
Your Honor, we can next call Kishana Pugh.
Officer Hill, can we get Kishana Pugh, please?
Oh, I keep muting it. And it's different to StreamYard. Mother. It's only small button, I can't see it. I was just saying, I don't think I could go death penalty. I don't think I could. I think I'd have to go, life without the possibility of parole.
Right this way, ma'am.
Ms. Pugh, good afternoon to you, ma'am. Just watch your step as you come forward. If you need a glass of water or something, let us know. Mr. Gray and his staff can certainly help you out in that regard, okay?
Okay.
Slide forward.
And you can adjust the microphone to help you project your voice as well. And with that said, Ms. Michelle, you may inquire. You're ready.
Love.
Thank you, Your Honor.
How much of a gentleman is that? Do you know what I mean? Pushing the chair. Sarah, does your husband still push the chair in for every dinner and stuff? Or when you go out, does he like, oh, hang on, my lovely, and he gets you the chair open, pushes it in for you, and do you know what I mean, pours the water for you and your wine. I bet he's a gentleman. Sarah.
Good afternoon, or was it after? Yes, it is. Good afternoon.
Good afternoon.
If you could please start by introducing yourself to the jury, please.
My name is Kishana Pugh, but I'm also here to speak on behalf of my husband, David Pugh.
All right, and Ms. Pugh, Mrs. Pugh, how are you related to Johnathan Quiles?
Johnathan is my husband's cousin, first cousin.
No way, Mary. Whip him in shape, Mary. Whip him.
And how long have you known Mr. Quiles?
About 12, 13 years.
And how often during that time period would you say you've interacted with Mr. Quiles?
I would say maybe every couple months or so, every few months. Now recently, my husband talks to him every day almost.
And what type of interactions would you all have? I mean, like in what settings?
I'm sorry.
Church. When he first got to Jacksonville, we invited him to church, and he would go to church with us. And also for family events, he would invite us over. He would cook for us and things like that.
Can you share with the jury a little bit of Mr. Quiles' background that you're aware of? And I know you're speaking also on behalf of your husband, David Pugh, so if there's something that you want to offer from his perspective as well, you may do that.
Sure. So from my perspective, Johnathan he's like been the only member of my book club. I want to say he's the only person that actually likes to read with me and things like that. We've shared books and stuff like that. But my husband, he's been almost like a big brother to my husband. He always gives.
Sarah, that's fantastic, Sarah. I'm so pleased to hear that, Sarah. Good lad. I'm really happy to hear that. What a gentleman. I love that, especially when you're mad at each other. That's fantastic. Really chuffed for that. Hey, Anthony. Come on, Cymru. Come on, boys back. Hell of a win, Anthony. If people don't know what we're talking about, Wales won a group match against Australia last night. Come on, Cymru. So, hell of a win there, Anthony. Hell of a win. Hey, Croeso, welcome back, Anthony. Lovely to see you, boy.
He's helped us when it came to our renovation of our bathroom. Like, we showed him the inside. He came up with a whole plan of how we should do that. He would also help out at the church a lot. I know he built like the sound booth at our church. He did a lot of handyman work and things like that.
All right. Can you share with the jury what you know about Mr. Quiles as a person?
As a person, he's always been like this bubbly person. He's always, every time I see him, he has a smile on his face. He's laughing about something. He's always been such a happy person.
Okay. And what does he mean to you for your life and as well? I know you're speaking on behalf of your husband, so you may give his perspective as well.
What he means to
you as a person.
I mean, he means a lot. I see that he brings so much joy to my husband. My husband, he's always excited to talk to him or tell him about his day or what's going on. He's been a person of release for my husband. So I feel like he's a very important person in our lives.
And what other information would you like the jury to know as they weigh this evidence that you're providing to them?
The only thing my husband just wanted me to mention is that he loves his cousin very much, and that as a man of God, he believes in redemption, and he believes that everyone should have a chance at redemption.
Is there anything further you would like to offer to the jury at this time?
No, that'll be all.
Nothing further for this witness, Judge.
No questions from the state.
Ms. Pugh, good to see you, ma'am.
Thank you.
Have a good rest of your day.
Judge, if I could have just one moment to check outside who's next. We were going to do Zoom now, but I need to let them know that. Is that okay, Judge, if I just
Of course.
step out really quickly? Thank you.
No, of course. Okay. Members of the jury, just so you guys are aware, we have a few witnesses who may testify via Zoom. We have set it all up. It should work seamlessly.
Sarah.
But we have people en route to have it set up because they don't trust me to do so. So that may take a couple minutes. I may give you.
Sarah, I imagine you're such a bitch, but I love it. I love that fiery, like, you're welcome. Oh, I love that. I'd always hold the door, even if I see someone walk in, I'm always, oh, I'll just wait. I hold it. It's, manners. Manners. If I go, like, with my mother anywhere, I always open my mother's door. I always open the door, going in, going out, open it, wait for it to go in, get a seatbelt on, and I close it. I think you elders, especially your mother, your wife, your girlfriend, wherever, you should always be respectful, in my opinion.
Witnesses, while we're waiting on the Zoom to be set up, if we could call Mr. Curtis Hale.
Curtis Hale, please.
Yeah, Sarah's an absolute bitch. I know she is. I fucking love it. Love these women that are feisty as fuck.
You solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Mr. Hale, good morning. Good afternoon to you, sir. Come over here to your right.
Right here, Mr. Hale.
Need a glass of water, let us know. We can do our best to accommodate you, of course.
Have a seat, sir.
And with that said, Ms. Michelle, you may inquire. You're ready.
Thank you, Your Honor. Good afternoon. If you could please start by introducing yourself to the jury.
My name is Curtis Hale, H-A-L-E, and I live in Arlington.
Thank you, sir. Can you start by telling us how you know Mr. Johnathan Quiles?
I met Johnathan in Arlington. He was working on a vehicle in my neighborhood, and that's how I got to know him to begin with. And then we become real close friends after that. And he's a good handyman. He helped me with an awful lot of stuff around my house, around some apartments I have, and he even rented from me for a period of time.
Thank you. So how long would you say you've known Mr. Quiles?
Probably about 8 years altogether. About 3 years, about 8 years I've been knowing him.
And you said that you met him while he was fixing a vehicle. Was that when you guys were neighbors?
Yes.
And during that time period, did you get occasions or have occasions to spend time with him?
Oh, yes. Spent a lot of time with him. He helped me build a storage building, and did an awful lot for me, and I know he did a lot for the church they went to. He's told me about the different projects they did with that and everything. I was real proud of him, to have a friend that did work like that, to try to help people out.
And you mentioned that he also rented from you.
Yes,
Did he also work for you at any point in time?
Not directly work for me, just help me out with different stuff. Like I said, he was a good handyman. He'd help me paint, put something together, fix my vehicle, or something, work on my truck. He's just real knowledgeable, and he was just a happy-go-lucky guy all the time, all the dealings I've had with him.
Yes, sir. And can you tell us what he means to you personally in your life?
Well, he's just been a real good friend of mine, and I just think the world of him, I mean, that's I talk with him occasionally, and just think a lot of him, like he was my son almost,
Thank you, sir. Is there any other information you want to offer to the jury as they deliberate and weigh the evidence that you're presenting?
I'm sorry, I couldn't hear you.
Is there anything else you want the jury to know today?
Just that I think that he's a fantastic person, in my life, Tom. All the dealings I've had with him have been positive. I've never had any negative dealings with him in any way, shape, or form. He can create a lot of stuff. He's just a sharp individual, I think.
Thank you, sir. Nothing further.
State.
A question, Your Honor.
Mr. Hale, good to see you, sir.
That's all.
Yes, sir. Have a good rest of your day.
Thank you.
Like that.
Ms. Michelle, you can call your next witness.
The other
Yes, Your
side
Honor.
should.
We could next call Karen Gaines McMillan.
So I like that. Just let them get statements on. Let's not, what can you ask that kind of guy? Do you really know him? What do you think about him now?
Yeah, go for it. Are they getting Miss Gaines? Mr. Gaines, come on forward, ma'am.
solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God.
Ma'am, good afternoon to you.
Good afternoon.
Just watch your step as you come forward. If you need a glass of water, Mr. Gray and the staff will certainly accommodate you.
Thank you.
And with that said, Mr. Davis, you may inquire. You're ready.
Thank you, Your Honor. Good afternoon, ma'am. Would you state your name for our jury, please?
My name is Karen Gaines.
All right. And where do you reside, ma'am?
I reside in Orange Park.
Okay. And how do you know Johnathan Quiles?
I know Johnathan Quiles through my best friend,
Which is who?
which is his aunt,
And who's that, please?
Paulette.
Okay. And how long have you known Johnathan?
I've known Johnathan since he's moved here. I'm not exactly sure how many years he's been here. However, I want to say maybe around 13 years.
Okay. And in the time that you've known him, how often do you interact with Johnathan?
I interacted with him mostly through family gatherings.
Being what kind of gatherings?
Cookouts, holidays, just, if we just get together and decide to do something.
Okay. And what does Johnathan come to mean to you?
Johnathan, he means a lot to me. He's a very caring person. When I went through a hard time, with the divorce, and he was very encouraging to me, and I was really distraught. So he, he would help me. He would just say stuff like, read this in the Bible and that you're a good person and God will bless you and it's that person's loss and not yours. So he was very encouraging during that time.
Did he help you in any way during the course of those times if you needed it?
No, I didn't need any help with anything, just encouragement.
Okay. So he was there for your emotional support as needed?
Yes.
Okay. And is there anything else you'd like the court to know about your time or what you know of Johnathan?
Okay. I recall a time when they lived off of MLK and they had he had set up a nice campground in their backyard, and he had the neighborhood kids and my godson. We dropped my godson off over there, and he did an overnight stay for the children, and they just had a great time. He taught them how to box. They roasted marshmallows on the campfire, and he did this mostly by himself.
Okay. So you know him as a very caring and loving person?
Yes.
Okay. Is there anything else you'd like the court to know?
Just in general, I admired the fact that, when he participated in church, he was, whatever his pastor asked him to do, he was willing and able to do it. And if he didn't know how, he would Google it or look it up on YouTube to figure out how to repair something, fix something. So it really didn't matter what it was. He was just willing to do it.
And did you know him as a hardworking person?
Very hardworking, yes.
To the best of your knowledge, he provided for his family and children?
Yes, he did. His daughter was amazing. She really loved her dad. She loved her dad a lot.
Is there anything else, ma'am?
Well, I had a lot to say, but I can't remember at the moment. But yes.
I don't have anything further, Your Honor.
No cross, Your Honor. Thank you.
Ms. Gaines, good to see you, ma'am. Have a good rest of your day.
Thank you.
Defense, you have another witness ready?
Yes, Your Honor. As they're setting that up, I would call, we have one other witness in person, then we can switch to Zoom. Since
Okay.
that seems to be ready. We can call KB.
Said KB as in boy?
Yes, Your Honor.
Passive aggressive, like his mother. Dogs take after the mothers, they say. Hey, hey, hey. Hey, hey, hey. Hey, 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 hey. Oh, KB. Who's K? Is KB from Barstool Sports?
You solemnly swear affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, sir, come over here to your right. Watch your step as you come forward.
Oh, geez, here we go.
If you need a glass of water, let us know. Mr. Gray and the staff will certainly accommodate you. And you can use that microphone to help project your voice out to the rest of the courtroom.
Water if you need it.
With that said, Mr. Davis, you may inquire. You're ready.
Thank you, Your Honor. Good afternoon, sir. Would you state your name for the record, please?
Kenneth Berry.
Okay, and where do you live, Mr. Berry? Where do you live? Area of town?
On Merrill Road.
Okay, so the Arlington area?
Yes.
All right. And how do you know Johnathan Quiles?
He's my cousin, but he's like my brother.
How do you get here like that? That's impressive.
I've known him all my life.
All your life?
All my life.
Okay. And for those of us that don't know you that well, how old are you, sir?
18.
All right. And Sir, when you say you've known him all your life,
Thanks, Sarah.
can you tell the court and the jury, how has he been there for you?
As far as I can remember, he's always been there. Like, there's never been a time where he was not involved. He was always involved with everything that we did. Like, if my mom needed him, he would be there, like, with 10 minutes tops. You know, he was always like that.
Okay.
Yeah.
Now, over the years, when you were in junior high and high school, if you needed something, was he there for you?
Yeah.
Okay.
Well, definitely.
Providing rides to and from places?
Yeah. Well,
Did you participate in sports?
yeah.
Did he take you to and from sports?
He did for a certain point. Yeah, he did.
All right. I see you smiling and getting happy about that. Does that bring back good memories for you?
It does. I'm not gonna lie. It does.
All right. Was he there to support you in the sporting events that he did and the things that you participated in?
Yes, sir. He did. He was. Yeah. He was very involved in my sport. Actually, when I first started playing sports, he was one of the people that were like most adamant about coming. Let me be there. Give me the schedule, and I'm gonna be there. And he made almost every game.
Okay. Specifically, what sports?
Around like when I first started playing basketball, he came, but like mainly around like soccer, things like that. When I first started playing soccer, he was like bring me to and from games. He came, and then when I first started playing basketball, he brought.
I'm just impressed with it. I'm very impressed with his hair. I just, how do you get that hair? Do you know what I mean? Let alone the colour. How the hell do you get that hair? That's amazing. I I can't stop looking at his hair. I'm amazed. Get a perm. Oh, I'm not sure about that. That's just like I like it. I like it.
He brought me to a couple of games, but
Now I wouldn't want that on a woman, right? I'll be honest with you. But on a man, I think I wasn't sure, but now I quite like it.
he came to some of those.
Did he also encourage you to make sure you made good grades in school?
Yeah, he said that was the first thing. Basketball and sports was one thing, but school could take you a long way. That's what he used to tell me.
Okay. And specifically, did he tell you to make sure that you got an education because he didn't have one?
Yeah, he made emphasis on the fact that due to his mistakes, he always told me learn from this because I was there. So because of that, he's always put emphasis on education in school.
And was he also encouraging you to make sure that you could go to college?
Yeah, he told me college is a must. He was one of the main people that told me that college is a must. Like you have to go to college because and graduate from college as well.
Okay. Is there anything else you'd like to tell the court about your uncle as far as in addition to the support and things that he helped support you in?
Yeah, he's really just a jack of all trades. He was all he could any spots that you could fit him in, he would fit and strive in it. But other than that, he was like very, very simple, very, like he loves his kids. He loves everybody he comes in contact with. You know what I'm saying?
How many kids does he have?
I believe he has around like 4, 5, around. Yeah.
Was he active in his children's lives?
Yes, very, very active in his children's life. He made sure of that.
Did he encourage them the same way he encouraged you?
Yes, whenever his kids would come over and I would be around, he would always have us in the same little thing, and he would just talk to us saying, I'm saying, this is what you should do, this is what you shouldn't do. Make sure you never do this, always strive to do, good, yeah.
Was his focus on making sure that they were a better person?
Yes, he always aimed to make other people around him better.
May I have a second, Your Honor?
Of course.
Is there anything else you'd like to tell the court about Mr. Quiles?
That's about it.
Nothing further, Your Honor.
Any cross from the state?
No questions from the state.
Sir,
Yeah.
good to see you. Have a good
I
rest of
know,
your day.
Sarah. I know.
I wonder if I could just check Zoom to see who's on, and then I can tell you who's next.
What I'll do is, let me give the jury a 10-minute break real
Sure.
quick, and, sir, you're free to go. Go for it. Members of the jury, we're going to make sure Zoom is set up, just so you guys, I'm not sure what you guys see on your screen right now, just so you know that the camera angle that you're seeing is on the evidence cart facing.
Skip that. They're on break now. It's weird because they're all like how great he was and everything. It's like, man, where did it all go wrong? Do you mean if he's all this legit guy, where did it go wrong? Um, I asked on the poll. The poll seems to be quite well now. It's gone more people are saying that you'd rather have 15 people, 75% saying life in prison with no parole, and 25% saying death penalty you'd rather have. Yeah. And yes, the line I have a tendency to be passive aggressive, no one best. Don't worry, I love it. That's a great quality. I love that quality in women, even in men. I love that. Uh, I'm like I'm quite not aggressive, but I'm quite passive aggressive. Like if someone pisses me off, they'll know they pissed me off. Same as you. If even if I hold the door, so we said about holding the door. If I hold the door for someone, like you just said, I would do something, and especially if they run in from somewhere they don't say anything and be like, "Oh, yeah, no issues. That's not a problem, mate." I'm quite like that as well. I don't. I'm quite fiery, and then I just go fine again. And I'm the same on Twitter. I don't like bullshit. I think I'm a pretty straight up kind of guy. You kind of know where you stand with me. Um, I'm I'd say I'm probably one of the most honest people you know. But I don't know many people that are more honest than me. Might not like what I gotta say, but I say it because then there's no receipts on anything. Some of the stuff I do say is dumb though, but you just gotta live by it. Sometimes learn from your mistakes. I'd rather do that than bitch people behind their back and stuff like most people tend to do. So, you know, it is what it is. Backing down to people, and so you went from backing down to actually wanting to fight. Yeah, I'm not sure that yeah, there's probably a handful of times I've been ready to fight, but I always try and anything to avoid a fight. I don't think it's proactive, but I suppose it depends in the situation. Um, really noticed something was different when I get step 4 days. Destroying your apartment. Well, that's going to happen though, isn't it? You had a severe life-changing knock to your brain, to your head. Do you know what I mean? So that's only natural, Jonathan. Uh, okay, that'll do you again. But it's easy enough to look back and laugh now, but obviously something that you've suffered through. Do you know what I mean? I've had similar as well. So 300 test your AC and your pedals. Jeez. Oh, I'm on the back. So these are going to be all on Zoom now. Baby, have my hand. Help me all the way. Help me to the flame. I'll stand by you. I'll stand by you. Like there's nothing about you. I'll stand by you. I'll stand by you. I'll stand. Ba 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 ba. Right. So it's a quote on me before anyone starts on me to go. Oh no, it's not. It's no. Yeah, it is a quote. Let's get ready, ready. Let's get ready, ready. Let's get ready to rumble. Side. Let's get ready, ready. Let's get ready, ready. Let's get ready to rumble. Side. Right, we're just waiting for that. They're going to be on Skype, so we'll have to wait a second for them to get going. Da da da. Dee 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 dee.
I'm sorry, I had the audio muted there for a second. My apologies.
No worries, it's fine, Judge. We
And
like
Judge, is
you.
it okay if I let her in now, or do you want me to wait to do that?
Go ahead and let her in.
Okay,
That's
thank
fine.
you, Judge.
Let's see how this works then.
Your Honor, the jury's re-entering the court.
All right, members of the jury, welcome back. You guys may have a seat. And we're going to continue with the defense case, and the defense is calling a witness who's present on Zoom. And so you should be able to see on the monitors in front of you. With that said, Ms. Michelle, the defense can call its next witness.
Yes, Your Honor, thank you. If I could next call Vanessa Brassetti.
Can you raise your right hand, please?
All right, that's what
Do you
me.
solemnly
That's them.
swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
Ma'am, if you could please start by introducing yourself to the jury. And Ms. Brassetti, how do you know Johnathan Quiles? And what's the relationship between your mother and Mr. Quiles' mother? And Ms. Brassetti, where do you currently
hang on.
reside?
I'll just check law and crime. Yeah, it's a good point though, John. What the f...
What can you provide to the jury as it relates to Mr. Quiles' background? his upbringing that you were there for? Yeah, any information you want the jury to know about his background and upbringing.
Edge. Right, so this is it. I'm back to law and crime now. Um, we can't hear her. We can hear the court, but not her. There's no subtitles. Awesome. So, da 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 da. We don't know what she is saying. Ba da ba da ba. I've never seen another ad and can still see dislike count. Yeah, someone's disliked my videos today. This stream, 2 people disliked it, I believe.
Thank you. And what other information would you like the jury to know?
I get it every stream, nearly, Jonathan. People don't like me, Jonathan. 0 dislikes. This one's got, well, my one's got 2.
So much. Is there anything else that you needed to add or that you wanted to add before we let you go? Thank you so much. Nothing further.
Any questions about the state?
Yeah, I am. As the owner, you can see yes. Oh, who? No, can't.
Ma'am,
No.
thank you for being here today.
You can't see who dislikes them, no.
I'm going to log you off or put you in the waiting room. So you can log off, though.
I only get,
And Miss Michelle, you can call your next witness.
I could see
you,
the
Judge.
dashboard saying how many
I
likes,
can
how many
next call
dislikes.
Destiny
But not who.
Quiles.
But I think you can hazard a guess after this weekend who they are.
Ma'am, will you raise your right hand, please?
Ba, ba. Let's see if
Her
this
audio's
one's
not
better.
connected.
Okay. 1 second, Judge.
Hopefully, Judge.
Maybe you can send her a chat.
Oh, wait, there we are. Can you hear us? Yeah. Right, there we are.
Ma'am, will you raise your right hand, please? You solemnly swear or affirm the testimony you give will be
Yes,
the
I
truth, the
do,
whole
honey.
truth, and nothing but the truth,
Oh,
so help you God.
sugar. I
Thank
do,
you so
Jonathan.
much. If you could please start by introducing yourself to the jury. And Ms. Quiles, how are you related to Mr. Quiles, Johnathan Quiles?
We can't hear anything.
And I was going to ask,
What a letdown.
sorry about that. Thank you. And who is your father to Mr. Quiles?
Who's your daddy? Hang on.
Thank you. Ma'am, can you tell us how long you've known Mr. Quiles? And can you tell us what Mr. Quiles means to you? And ma'am, I forgot to ask you this at the beginning, but where do you currently reside?
It's a members only, Jonathan. So you're a member. So just go into that. That's a link for it. Just remember, if you're not a member, you can't go into Discord. You need to let me know who you are and I'll let you in. And then once your membership runs out, I kick you out until you get a new membership. So, so you're a member, so you can go in there. I'm not sure how long you're still a member for, Jonathan, but get in there for now.
And is that where you are currently? You said your father is Joseph Quiles?
Yes.
Okay. Can you tell us anything you would like the jury to know about Mr. Quiles in your upbringing and his background?
It's a bit of a disappointing end. Nah, it's all good, David. Hey, Dave, you wouldn't be
Thank you. Is there
welcome.
anything else you wanted the jury to
You're
know
not
or
a
share with
member
the jury at
anymore.
this time?
Not a member anymore, Dave. Jeez, right, let's try and fast forward this a little bit then.
Sir, will you raise your right hand, please?
Mr. Pugh, can you hear her? Yes. All right, just pay attention to you.
Sarah Pete, you're supposed to be a bloody mod in mine. Jesus, hey, I have no clue in there. I'm just the only one participating, I think.
Your screen and look at Madam Clerk. She's going to swear you in before your questioning begins.
Will you raise your right hand, please? Do you solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. If you could please introduce yourself to the jury.
See?
And Mr. Pugh, where are you currently located?
Oh, Amy. Amy. Hi, Amy.
Sir, if you could please provide how you're related to Mr.
Right.
Quiles.
I can do it now for you guys.
I'm sorry, you
will.
said you're his cousin? Okay. Have you known him your whole life?
Welcome, Amy. You're in.
Can you tell us about
Now,
your
Ramston.
occasions to be around Mr. Quiles? Yeah, how often would you be around Mr. Quiles?
Where the hell are you,
Yes, throughout the
Jonathan?
time that you've known him.
Hey, John, you're in as well.
And Mr. Pugh, what do you know of Mr. Quiles that you'd like to share with the jury today?
I need to check some people out, actually.
What do you know about Mr. Quiles' background that you can share with the jury today? That's all right. What would you like to share with the jury about what Mr. Quiles has been to you in your life?
Hi, Amy, by the way. Yeah, put some doggy pics. Everyone loves doggy pics. I know, I know, Dave, I know.
Is there anything else you would like to share with the jury before you go?
No, ma'am.
All right, thank you so much for your time. Nothing further, Judge.
State, any questions?
No, Your Honor.
Sir, thank you for being here today.
Thank you.
You can log off. I'm going to put you in the waiting room so you can log off from there. Judge, that concludes the witnesses that I have on Zoom, and we have one other witness in person, Judge.
Okay, you can call your next witness.
Thank you, Judge. I'm just going to close this out. Is that all right? Or just so that it's not?
If you're done with it, I'm done with it.
Thank you, Judge.
Okay. How do you make ketchup then, Jonathan?
Judge, we can next call Paula Buret.
This could get a little bit fun now with Jonathan in there.
Paulette Buret.
Let's start kicking out some of the non-members now. Let's have a look. Jonathan, your membership's running out in 3 or 4 days. 4 days, I think.
Do you solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Right this way, ma'am.
Ma'am, good afternoon to you. Just watch your step as you come forward. You need a glass of water. Let us know. Mr. Gray will certainly help you out in that regard.
Thank you.
That said, Ms. Michelle, you may inquire. You're ready.
Thank you, Your Honor. Ma'am, can you hear me?
Yes.
Okay, great. Thank you. If you could start by just introducing yourself to the jury, please.
My name is Paulette Biguet.
And Ms. Violette, can you please tell us how you know Mr. Johnathan Quiles?
Johnathan is my nephew/son.
And ma'am, you've known him his whole life?
His whole life.
And can you tell me how what the relation is as far as you being his aunt? Who are you related to in his family?
I am his mother's youngest sister, his late mother.
Okay. Ma'am, can you tell us a little bit about Mr. Quiles' relationship with his mom first?
Oh my God.
Hang on.
They had such a special bond. He loved her. He was crazy about his mother. He loved everything about his mother.
I didn't think
his
that
mother
out.
was an amazing woman to him.
Jonathan.
What about his relationship with his father?
That was rocky. For a long time, it was rocky. There was a lot of sadness there. But when he got older, he forgave him. They worked on a relationship together, and everything was okay. Nothing further after that. They just mend whatever was broken, and he visited them. He stood with them a couple of months, I believe, and then he went back home.
Okay. As far as their relationship currently, let me start with his mom first. You mentioned his late mother.
Mm-hmm.
Tell me about when she passed or that situation.
She had cancer.
Okay. And when did she pass?
She passed 13 years ago in December.
And how did Mr. Quiles take that?
Oh, that was really hard for him. Him and his mother were inseparable. He was her caretaker.
I'm so sorry.
I'm
Go ahead.
sorry.
Go ahead. You were saying
he was her caretaker.
And did they live together during that time period?
I believe he was living with her at her first diagnosis, and then he took care of her, and then later she was supposed to be in remission, so he tried to do his own thing, but she was really never in remission. She was diagnosed incorrectly, so then he had to come back and take care of her.
And then during that time, was he the sole caretaker of his mother when she was ill?
Yes.
Okay. And you said that it was rough after she passed?
It was rough.
During that time period, what was his relationship like with his brother?
I don't know if their relationship was, I want to say was distant. I'll just say that it was distant. I don't remember them being close at that time.
Have you ever known them to be close while growing up?
Not necessarily growing up. I think their closeness came about recently, and I guess maturity brought them back together, and they were able to mend some things and hold on to a good relationship.
Earlier in life, did you know Mr. Quiles and his brother to have like a conflictual type of relationship?
Yes.
Can you tell me about, I guess you told me a little bit about his reconciliation with his father. How do you feel that relationship has affected Mr. Quiles?
John is very forgiving, and when he made the decision to forgive his father, it was pure. And he did forgive him. They worked on a relationship, and like I said, he came and lived with them for a couple of months, and then he went back home. So I'm not sure if they have a relationship right now.
Right. What else can you tell us about John's upbringing, his background?
John had a great upbringing. As you all know, my sister was a single parent. She worked really hard to provide him the things that he needed. She was adamant about education. She had 3 degrees before she passed. He chose not to go to school, and we know why. But there was nothing she wouldn't do for him, or for Joseph, for that matter, for both of her kids. But her and John had a special bond, a really special bond.
And during their upbringing, did John's mother work quite a bit?
She did. She went to school and she worked.
As far as you mentioned about his education, that he chose not to go, and that was, I'm just using your words. Tell us about what you know of his education.
He did up to the 7th grade. Learning was not a disadvantage for him. He was very smart. He just did not want to go to school. There was nothing that he couldn't do. He comprehended well. He self-educated himself in a lot of things. So it wasn't that, I don't know if he just couldn't handle, or he chose to work for his little children that he had at that time, but he was a really brilliant young man at a young age.
And so tell us about his family. You said that he had children at a young age.
He did have children at a young age. He had a boy and a girl. They were back to back. I think they're like a year and a half apart. I believe his first child was born at 15 or 16. And he worked really hard to provide for them.
And as far as his other children that came later, what do you know about his relationship like as a father to them?
He's a great father to them. He's always been a great father to his kids.
And does he maintain, as best he can, a relationship with them to this day?
Yes.
Can you tell us a little bit about you and Mr. Quiles' relationship?
Say that again, I'm sorry.
Your relationship with Mr. Quiles.
We instantly bond at birth. When he was born, he was no longer my sister's child. That was my child. We had a special bond when he was born. I took him everywhere I went. We did everything together. As he got older, I moved. I was married to a military man that traveled a lot, so I wasn't with him as often, but he'd come every duty station we went to spend time with us. When his mother died, I had promised to do my best as a mother figure for him. And when he made the choice to move over here, I was really excited because I would have him all the time. He moved here. He found himself a church home. He gave himself to the Lord. And he enjoyed life. And he's always been a positive person in my life. I've never seen him handle things in a negative way. There's never a moment if I'm sad or I'm down. He always say things to just lift me up And he did that for his mother. Even though his mother's cancer was incurable, he always kept her spirits high.
What do you know about Mr. Quiles' work history and kind of his background, employment background?
Mr. Quiles can do anything he put his mind to. He can work on cars, he can be a carpenter, he can be a mechanic. There's nothing that he could not teach himself to do. And he always had work. He can find work easily because he was so skillful.
Can you tell us a little bit about what your relationship has been like and what you know of him since he's been incarcerated?
Even being here for 5 years, I've never seen him sad. I've never seen him cry. He's always so uplifting. I'm the crybaby. I'll cry on the phone with him. I'm sad, I'm upset, I'm angry. And he's like, Mom, it's going to be okay. I promise you it's going to be okay. And he never loses hope, ever.
Can you tell us a little bit about, I know you have kids, correct?
I do. I have
Heard
4.
from a few of them today.
Yes.
All right. Can you tell us a little bit about the family dynamics as far as your family and with Mr. Quiles?
Yes. John always says he's the firstborn, so he makes my children really jealous. So he'll say, that's my mom. No, that's my mom. I'm the firstborn. You know, silly things like that. But they all get along as if they were all natural brothers. They all get along. He impacted my 2 younger kids. He taught them a lot of stuff. My youngest son couldn't ride his bike for years. And John came one time, and my son's never stopped riding his bike. But no one could teach him how to ride his bike but John. So he's impacted my children in such a positive way. He was their go-to person. He would build go-karts and teach them how to ride the go-karts, showing them what angles to turn, what not to do, just a lot of fun stuff. And he would educate them that education is the most important thing.
Can you share us a little bit about what Mr. Quiles means to you personally?
He's my everything. He's my light at the end of the tunnel. I go to him for everything. He always has special words for me. He always tells me, no matter what I'm going through, God is going to see me through everything. There's nothing that I can't overcome. And I look forward to hearing his voice every day. He is my connection to my late sister. My sister and him have a special bond, and I see that through him all the time. And when I see him, I see my sister. And I look forward to speaking to him every day, every opportunity that I get.
Can you tell us any other information you would like to provide to the jury today before we let you go?
Yes. I just wish everybody knew John like I knew John. John is such a warm, loving person. Everybody that comes across John have a special bond with him. He just has a natural love for people. And I just wish everybody was able to see that in him, because he's an amazing young man.
Can I have just a moment?
See, Sasha, oh, you've probably gone now. Sorry, I'm trying to do a million other things.
The questions, Your Honor.
Ma'am, good to see you today. Thank you for your testimony.
Yeah, she's from New York, Dave. So
Any additional
his,
witnesses?
No, Your Honor. That's what he has.
most of his family are from
Members of
New
the
York.
jury, give me 15 minutes. I need to finalize some instructions with the attorneys, and then we'll go to closing arguments. It's no secret at this point, after closing arguments, I'll be able to dismiss the 4 alternate jurors. That's not a secret I can keep anymore. I'll see you back at 2:35-ish, and we'll go from there. Please remember, don't discuss the case among yourselves or each other, and we'll go from there. Oh, I'm sorry, hold on one second. I failed to let you know this. So when we go to the closing argument phase, the first 12 that are serving, that's when we got to take your devices from you. So if you need to contact loved ones, let them know. Just like as I told you last Thursday, we will be here as long as you guys want us to be here tonight to deliberate. We don't know when that decision will come. If you want to break when it come back tomorrow morning, like we talked about Thursday, we will do that as well. I'll give you further instructions. I'm mostly letting you know that if you have to contact a spouse, family, friend, whoever, to let them know you may be out of pocket for a while tonight, this is probably the chance for you to do so.
I do like how I could freely move my camera though. This box and go, hey. I've been very impressed with this judge. Best judge by far I've seen. Judge, what are you doing hiding your face?
The jury's outside our presence. I still have counsel of state defense, Mr. Quiles, present. I want to finalize these jury instructions. So, Ms. Michelle, I did look at 10, 16, 23, and 28 that you mentioned. They all do seem to be redundant. I tend to agree with you. I kind of did a
15 minutes. 15 minutes, Mary. So they're just going for a quick break, and then they're coming back. 15 minutes.
Keyword search. And the other things that are mentioned in those 4 circumstances are also mentioned otherwise. So if you guys are okay with it, I'll delete 10. I'll delete those 4 aggravating factors off the final jury instructions. And just for the record's clear, the defense agrees what I'm deleting is already encompassed in the other mitigating circumstances alleged in the instructions.
Correct, Your Honor, and that's why we suggested those to the court to be removed, because we do see them in other ones, and they are overlapping to other ones as well. So, yes, we agree.
Okay, so they are deleted. Other than that, the jury instructions seem to be in rather fine form. I do have in jury instruction, the verdict forms as well. I can go upstairs and I'll print copies of everything. Is there anything that either party wants to add regarding the instructions? Any objection to how the aggravating factors are listed, mitigating circumstances, or the additional instructions of how I phrase it for weighing the evidence, rules for deliberation, verdict, and submitting the case to the jury?
Acceptable to the state, Your Honor.
And while the defense is looking at that, I noticed that you guys didn't call Joseph Quiles. I'm assuming that was a decision the defense made.
Yeah, he was having trouble getting on, and so instead of trying to wait and figure that out, Judge, we did not call him. We made that decision yesterday.
Is he able to get on at all?
I know that when I asked them, I had already told them, they said that it was fine not to call him, so we will not be calling him, Judge.
When you said they, who's they?
The family that have been in contact with him to try and see if he would be getting onto Zoom.
Okay.
And we did discuss that with our client.
Okay.
We did let him know, and that's fine.
All right. Now, obviously, Mr. Quiles didn't testify in this penalty phase, just like he didn't do in the guilt phase. I don't see the necessity to inquire again of him in that regard, unless the defense thinks that's necessary. Obviously, if we, depending on what the next steps are, he always has a chance to address the sentence in court at the appropriate time, if that's what he decides to do.
Yes, Judge, that's fine. He knows he's not testifying, obviously, now, but we've discussed the option later with him as well. We don't expect that to be the case, but...
So he's agreeing not to testify at this phase as well?
Correct.
Okay, and you guys have talked to him about all that?
Yes, we have, Judge.
Okay, you've answered all his questions?
Yes, Judge.
Okay. So I'll let you look at the verdict for... I'm sorry, go ahead. Talk to your client if you need to.
Yes, Judge. I'm going to let Mr. Davis address the one issue that we had with the instructions. This may not be one at all, and then I'll find out what he wants.
To look up what tamal is, I've never heard of it. Oh, Ah, 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 ah. Mary, he is the best.
Judge, we're just
Simply the
affirming everything
best.
that I just said, as far as testimony and
Better
specifically about not
than
calling his
home.
brother, just making sure that all of that was as I represented to the court.
And he's in agreement with that.
He is.
Okay. All right, we'll move forward with the jury instructions.
Shut down the door. Ba-da-ba-da-ba-ba-ba. Ba-da-ba-da-ba-da-da. Simply the best.
Are there any objections to any of it from the defense at this point?
No, Your Honor, we were just looking up one other thing, but for now, there's nothing else to add.
So in total, you guys are in agreement with the jury instructions as prepared and as will be read to the jury verbatim. Otherwise, I know you raised an objection to the 6th aggravating factor regarding familiar or custodial relationship.
Correct, and there was one other that we had discussed, but at this point, Judge, we don't have any other objections other than the ones that have already been raised.
Well, do you want to raise the thing that you guys are discussing so I'm aware of it?
Well, Judge, just in going over.
None of these. Oh, thanks, Mary. You're the only one. No one else likes it. You normally tell me to shut up, Mary.
For purposes of the record, we would review all our previous objections and arguments without any further argument, just to preserve those for purposes of the record, Your Honor. That's number one. Number two, we're looking into, brought to our attention, requesting for a mercy instruction, and I'm looking for it. I don't know as though I'm able to do so.
Are they, Dave?
The standard instructions talk about that.
I'm not.
It's on page 8 of 15.
Which teams are they? I haven't seen that.
To see if there was anything else that could be expanded upon that. That's what I was looking for specifically, to see if there's any additional language under the jury instructions or the rules that could be added. And that's what I was looking for.
Okay. I mean, it is included in here. It may not be as explicit as the defense request. These were just amended, I think, earlier this month.
Exactly.
Nothing stops you from arguing that, though, based off the law that I'm reading to the jury.
Right. And that's what we were looking for, just to make sure that we cover all our bases on that, Judge.
Okay. But nothing you're proposing at this point.
Nothing that I think we can propose that isn't already there.
Okay. And how about the verdict forms for count 1 and for count 2?
I'm sorry. We didn't see anything to object on that, Your Honor.
The only difference is, I think, in count 1, I have the HAC, the aggravating factor. Count 2 does not. Count 2 has the victim was less than 12. Count 1 does not. And both have the last aggravating factor. The victim was particularly vulnerable for 2 different reasons. So there's 5 aggravating factors alleged as to each victim. What I'll do is I'll go upstairs, I'll print everything, I'll come back out and we can commence closing arguments unless there's something else from the attorneys that I need to handle.
Not from the defense.
Not from the state, Your Honor.
Okay, give me 5 minutes, I'll come back out.
Sir, Your Honor.
Bills, Dolphins, Falcons, Jags. Jags. Jesus, Dave. Jags were horrible. Horrible on the weekend. I thought they should have beaten the Texans. They were horrible. Dolphins were fantastic. Bills seem to be getting back in the groove now. Falcons, they took a bit of a hit, but they'll be fine. But Jags, wow, Jags, they were my favourites to win Their league, their conference, not anymore. Our Cowboys as well, the Cardinals. Jeez, Cardinals played well, mind. I was impressed by the Cardinals. Do you know what? The Cardinals, though, Dave, I don't like Kyler Murray. I don't like him. But, no. Oh, yes, Vikings, no, good. 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 Chicago as well. Oh, my God, Dave. I mean, it's Lions or Green Bay who wins your conference. And I would put money on Lions. Chicago are just a mess. The Vikings are a mess, but the Vikings will be fine, but they're not superstar. Jefferson hurt, yeah, no, that's not good, is it? New York Jets, mate, they are awful with Zach. You know, they need Daddy there. Now that Daddy's not there, Daddy Rogers isn't there. They're stuffed. Who else we got? Ba-da-ba. Bang, bang, Niners gang. Bang, bang, Niners gang. Niners look good. How can the Niners, I always say this for Niners, I they gave up so much for Trey Lance, but landed with the last pick in the draft, with Brock Purdy. How lucky are they? Mr. Was it Mr. Invincible or not? Mr. Whatever his name is. How lucky are they? They missed so much on Trey Lance. Like, wow. They had a pick of anybody basically missed. Wow. I think they wanted Mac Jones. They should have gone for Mac Jones. Mr. Relevant, I know. But look how much you gave up for Trey Lance. Knowing now what you know. Do you know what I mean? Mr. Relevant. Dave, that's a bummer though. 149 yards. Wow, that's a bummer. Yes, they are. But I do think Darnold's okay. I think Darnold, if he was injured for a couple of games, I think Darnold would be fine. I think if he's out for the rest of the season, I think Darnold. But then, Kyle Shanahan plays it simple. He's like robotic. He wants his QBs to be robotic. So I think he's probably training Darnold to be robotic right now, to not make mistakes and to just like probably give the ball to Christian McCaffrey, just run, run. Do you know what I mean? So I think he'd be fine. The Niners will be fine, I think. Jimmy's not doing well in Vegas. Raiders were not doing well. I didn't watch the game actually because I went to bed, but I watched a little bit of it. I heard a little bit about it. Um, I know they paid too much for Lance. The problem is that Lance never really got to play. Most of the time, he didn't stand a chance once Purdy came out and did what he did. I know. I still think he was the wrong pick for you guys, though. Anyway, I think Mac Jones would have been better. I think Mac Jones would have been. Mac Jones is Purdy, essentially. Um, so I think Mac Jones would have been a fantastic fit for you guys. And you could have got him at 11. But hey, they did what they felt was right. And I think if they'd gone for anyone but Lance, I think you'd all be crying. But I suppose he's coming along okay. Darnold will be fine. Darnold will be fine, Sarah. He's not had any coaches. If you think about it, he had Adam Gaze and what's his name, Todd Bowles. Todd Bowles first year, Adam Gase then for 2 years, got let off. Then Matt Rule for a year, and now he's actually got unoffensive guru in Kyle Shanahan, so he'll be fine. I'm not saying he's gonna be great, but he'll be good. Um, he just hasn't had the right coaching. He's probably been one of the unluckiest quarterbacks out there. Another one, Josh Rosen. The chosen Rosen. What's happened to him? Gone. He had rough. This is how harsh it is, though, isn't it? 1 year in Arizona, gets chopped, and that's it. Gone. See you later. Miami for a couple of years, and that's it. Ends up in San Francisco. No, sorry, what goes to Tampa Bay, practice squad, and then leaves there to go to San Francisco, and then plays a little bit of a game, and that's it. Seattle's looking good. Seattle is looking good in 3 games with 150. Oh, Dave, that's not good. DraftKings. Oh, that's a good bet though. Seattle's the only team. Yeah, Seattle looks good. Pete Carroll looks. How is he 70 odd? He looks like he's like 50. Well, he looks younger than me. Do you know what I mean? In the sense of he's fitter than me. So I don't know. They're gonna be fine. I mean, Denver. Oh my! I think Denver's gonna be fine. They have to be fine. There's too much talent in Denver. But what a whopping they got on Sunday against the Dolphins. Um, who else is there? No, they did well. Yeah, Denver. I don't like Denver. I don't like Russell Wilson. You see, so Sean Payton's a bit arrogant. I like Sean Payton. He's a good coach, but he was a little bit arrogant, I think. Which you need to be in fairness. You have to be a bit arrogant. But I don't like Russell Wilson. So I respect what he's done for the game, but last season, wow, and even this season so far. For 20, you make 100, and I may have took that bet. Yeah, I know. It's easy enough to look back on it. It was a good bet, Dave. I mean, just unlucky. Very good bet. 1 yard away. Jonathan, oh my God, I finally make it. Pay for bringing Quidditch to Hogwarts Legacy. Jonathan, you're sorted now, mate. You're sorted. Ba-da-da-da-da-da-da-da. I think everyone's like, what's going on? What's going on? We lost most of our viewers. What's going on? What's going on with you? Ooh, oh my God, Oregon. Bo Nix. Oof. But I will say this though, Shador Sanders played well. He played. Can you imagine? Like I think people saying, "Oh, Bo Nix came out as a star." Yeah, he did. But I think Shador Sanders came out looking very good as well. He did have an offensive line, and he had great numbers, and I thought he did well. I thought he played well for what he had. Sacked 7 times. I'd be interested to see if the roles are reversed. Yeah. I thought it'd be closer. I'll be honest with you. I did think it'd be closer. But then Travis Hunter was out, so maybe. Yeah, no, I know what you meant. I know what you meant. I don't know. I don't know. I thought it'd be closer than what it was. I knew that Oregon would win, and if you were to tell me over or under 21, I would have said over 21 probably. Oh, Jonathan, you don't ask a man about his bets. Yeah, I think Travis Hunter being out played a part. I think the O line is just um Sarah. I think the O line is just too weak. They've not gelled yet. Do you know what I mean? They've only been together for a couple of months properly, if you think about it. I think next year they'll be a better team. I think they need 3 years. But Shador's going to be gone. I think he's going to stay for one more year. Travis will stay for 1 more year. Obviously, he has to. But they need a better O-line and they need a better defense, you know. I think they can be proud. They were 1-11 last year, so they're 3-1. They're going to be 3-2 after Saturday. They're probably going to get an arse whooping again on Saturday. But that's about it. They're going to be whipped by USC, you know. So that's going to be an interesting game. Is do Oregon play USC? When do they play? Because that'll be a cracking game, I think, Dave. Oh, but he's doing well. I mean, look, Bo was when he was with Auburn, everyone's talking about him a flop. He can't make the NFL. I was surprised he went to Oregon because I thought you had a quarterback already, but he left or something, didn't he? And I thought he's quite good or whatever. Oh no, he didn't leave. He just didn't win the spot. Um, I wasn't sure if he could start for Oregon. And Washington, Washington's a team, man. They're the team to beat at the minute. And yeah, I've got to be saying Bo Nix's still well. I'm not sure if he'll be a first rounder in the draft, but I think he'll be second rounder definitely. Day two, people will take a punt on him, but I'm not sure if he's going to be day one. I don't know. There's too many people like Caleb Williams, Drake from North Carolina.
All right, let's go back on the record. 19 CF 7518. I have Counsel of State Defense, Mr. Quiles, present. So I have copies of the verdict forms for counts 1 and 2, 3 pages each, and then jury instructions. Anything else we need to handle before we bring the jury in? First from the state. Defense.
Your Honor.
All right, let's bring the jury back in, please.
Yeah, I agree, Dave. Well, certainly top 7, anyway.
Your Honor, the jury's re-entering the court.
Members of the jury, welcome back. You guys may have a seat, of course. Members of the jury, both the state and the defense have now rested their respective cases for this phase. The attorneys will now present their final arguments to you. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. State, you have the floor.
Thank you, Your Honor. May it please the court.
Yes, sir.
Ladies and gentlemen.
Yeah, he won't go top 10, Dave. Not yet, anyway.
We are endowed by our Creator with certain unalienable rights, and that among those are life, liberty, and the pursuit of happiness. We are a nation of laws. Thomas Jefferson wrote those words in 1776. He was in an upstairs bedroom at the corner of Market and 7th Streets in Philadelphia, Pennsylvania. Those words are so powerful. It's the foundational principle of what this great country stands for. That foundational principle would later give us the United States Constitution. All premised on that each and every one of us have those unalienable rights. Our courts are supposed to preside over disagreements when a violation of those rights occur. Legislatures are supposed to pass laws to protect those rights. The executive branch is supposed to enforce those laws when they are broken. Those words that resonated so loudly in the Declaration of Independence still resonate today. Why? Because this foundational principle has existed forever. Since 1776, 248 years ago. All of us have a right to live. All of us have a right to liberty, to freedom. And we have them because they were endowed to us by our Creator. Have you ever chewed on the word unalienable? What that means? It means they're impossible to take away from us. They're not capable of being denied to us. They should not be denied to anyone because they're that foundational in what we all believe and stand for. The defendant stripped each and every one of those from Ayanna and from Hazel. He now forfeits his right to life as he knew it. He now forfeits his right to pursue happiness. He now forfeits his liberty. But what should his sentence be? Should it be life in prison without the possibility of parole? Or should it be death? The defendant took the freedom of a 16-year-old young girl and an unborn baby. He took their pursuit of happiness. He stripped them of their ability to ever pursue happiness again. He took away IS's motherhood.
I can't listen to him.
He took away that unborn baby's daughterhood. IS lived the last seconds, minutes, or hours of her life at some point as her life was about to draw to a close with something that was about to happen to her that was atrocious, and it was cruel, and it was heinous. Even the defendant said he couldn't stomach it. IS would never go to school again. She'd never read that book again, any book. She'd never work at Chick-fil-A again.
Let's focus.
She'd never visit a neighbor across the
Johnathan.
street again. And the list goes on.
It's a nice dog, Johnathan.
Why? Because the defendant snuffed out her life Because he himself, with his selfish interest, that even his own doctor said, he's self-centered. He chose to kill 2 humans because he may wind up in jail sitting right next to those people he was talking to on the wire. He carried out a heightened premeditated plan. We'll talk about CCP in a bit. He did everything he could to get away with it. He tried to stay off cameras. He worked really hard to dump that body using bags or blanket, doesn't matter which. He somehow got her in that dumpster. He got rid of her book bag and her other bag and her underwear, and he got rid of her. He turned off his geolocation data. All this is going to go to what's called the cold, calculated, and premeditated aggravating factor. He deleted stuff off of his phone. He takes a gun with him to work. He went and got it out of wherever he had it in his home, and he put it in his red minivan, and he drove it to work that day. Cold, calculated, premeditated. And he goes and shoots at the gun range that afternoon on the 20th to blow off steam. All while IS and her unborn baby lay in a landfill somewhere. And then 22 days later, he's laughing it up in jail with 2 guys saying she's cooking out there. Cold, calculated, premeditated. Even he himself on that wire says this is a premeditated murder. Well, all that, ladies and gentlemen, begs the question, what is justice? This case is about to be yours, or the people, the most powerful entity in this great republic that we have. The people get to make the decision. Now you get to decide what to recommend to Judge Salem and hand him your recommendation. You get to do that. Now, you heard all the aggravating factors. If you notice in the penalty phase, you read the penalty facts because you heard them all. And I'm going to walk through them in just a few minutes, but aggravating factors, quite frankly, ladies and gentlemen, think about the definition of them. The court's going to read the exact definition by Florida law of an aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim that's inherent in all first-degree murder cases. It's higher than all other first-degree murder cases when those factors exist. There are 6 of them in this case, 5 of which apply to each respective victim. As we walk through those, I'll explain that. The defense, as you now have seen, presented mitigating circumstances to you. And when you go through this process, you get to weigh those, so long as we prove it at least 1. That's all it takes for you to move on to step 2. There are 2 major steps here. Did the state prove 1 aggravating factor to you beyond a reasonable doubt? And did they do so where you voted unanimously? We argue to you that all 6 have been proven to you beyond a reasonable doubt. Some based on your verdict. We'll talk about that. And then once you make that determination, you move on to the second step, which is, are the aggravating factors that you determine to be proven sufficient in of themselves to warrant the imposition of the death penalty? And once you answer yes and that answer affirmative to that question, you move on to that weighing that we spent a lot of time in jury selection talking about. And we ask you, can you meaningfully consider the mitigating circumstances that the defense presents to you? And you have to. You have to. That's why you're here. You went through an enduring process of questioning, and you will follow the law because you've taken an oath that you will. We are a nation of laws.
This is the prosecutor, yes. I just can't listen to him. I've got him volume down.
And
Sorry.
you'll make this decision not because it's easy. It's not. It's hard. But because it's right. And it's just. And it is justice. And we'll talk about why in my argument to you. When you go back and deliberate this decision, base your decision on the law. Base your decision on the aggravating factors. Don't pull anything else in it. That victim impact testimony was extremely difficult, and we know that for you to listen to. Please, as the court made very clear, you cannot call that an aggravating factor. The law doesn't permit it. So please take only the 6 that we articulate for you and conduct your weighing with only those aggravating factors. If we are going to uphold the principle that Thomas Jefferson spoke about, that we all have those unalienable rights, they've been given to us by our Creator, what do we do when someone else, the defendant, takes those away? That is your question. What does justice look like? And the answer, quite frankly, ladies and gentlemen, is this: the defendant must be held accountable for his actions. He must be. We are a nation of laws. No matter whether you agree with who sits in the presidential office, some powerful words have come out of that office for the last 248 years. A modern-day president said this: "We must reject the idea that every time a law is broken, that society is guilty rather than the lawbreaker. It is time to restore the American precept that each individual is accountable for his actions." The question is, will you hold him fully accountable? Not partially accountable, fully accountable. While the 3 branches of government have done their job, ultimately we are handing this case to you as the executive branch and handing it to you and saying, hold the defendant accountable for taking away IS's rights and their liberties, and her unborn baby's rights and her liberties. The real power does lie with you. When someone's life is taken, when someone's liberty is taken, when someone's pursuit of happiness is taken, we must address it and we must respond accordingly. Please note that the court will also instruct you when he gives the final instructions in just a little while. He's going to say to you, this is not a numbers game. It's a weighing process. So while it's easy to say, well, you're going to look at their list of mitigating circumstances, they'll talk to you about them. There's upwards of 20-something, upper 20s. It's not, well, who has more? Okay, so please make sure that is not part of your process. The court will talk to you about that. It'll talk to you about the weighing, the deliberative process that you must engage in. And it's simply this: did we prove to you at least one aggravating factor beyond a reasonable doubt? And you have to find that unanimously. Now, if you believe that of the 6 that we're going to present to you, that 4 of you were proven unanimously by you, that's the 4 you take with you and conduct that weighing process. It's the proven ones. We believe we've proven all 6 to you. We'll talk about them in a minute. You take what you believe has been proven unanimously. This is your decision. The power is with the people now to follow the law. Why? Why must you follow the law? Because we are a nation of laws. Ladies and gentlemen, I argue to you this is the very definition of aggravated murder. It is. You convicted him of first-degree murder with premeditation when you found with your verdicts on count 1 and 2. Now your role in accomplishing justice is about to be completed with your recommendation that you're going to hand to the court. Well, what are these aggravators? Here's the first one. Let's take a look at your screens. The defendant was previously convicted of another capital felony or a felony involving the use or threat of violence to another person. Note right underneath that, the crime of sexual battery is a felony involving the use or threat of violence to another person. You found that. You found that unanimously on Friday in count 3. That was previously, and that counts for purposes of this aggravating factor. There's the law in front of you. That's aggravating factor number 1. That's already been proven to you unanimously. That you've already found beyond a reasonable doubt. Now you just tally up your aggravating factors and go on to that second phase. That alone, with your verdict, in that verdict form, when you check the box for count 3, accomplished that aggravating factor. It's proven. Not because I say so, because you said so. That was your verdict. And the state thanks you for that verdict. But that alone gives you aggravating factor number 1. Now, you can view that aggravating factor as to both counts. As to count 1, you can look at counts 2 and 3 and say not only did you convict him of first-degree murder, but you convicted him of first-degree murder of the unborn baby, and take either one of those, count 2 or 3, and apply it to this aggravator, and it becomes more weighty. That's key here. It becomes more weighty. As to count 2, first-degree murder of the unborn child, you can take counts 1 and 3 and bring them into your calculus with respect to this aggravating factor. And that also becomes weighty. As to both counts, you'll make a decision as to both. The imposition of life in prison without possibility of parole or the imposition of the death penalty. You'll do that for both counts, count 1 and count 2. The question that you have is, how heavy are those? In the previous a felony involving the use or threat of violence to another person, you already found it twice. And that's a weighty aggravator. The second aggravating factor is that the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest or effecting an escape from custody. Obviously, this is with respect to a lawful arrest. Ladies and gentlemen, that was what the entire trial was about. When little IS at age 15 became pregnant on July 7, 2018, confirmed on December 13, 2018, by Dr. Atchu, you saw those series of painful Snapchats of what he was putting her through. The mental twisting about having this baby. I don't even know how I got you pregnant. I've been kicked down there so much. You remember that one? He did this for one selfish reason. He didn't want to go to jail for it. That's eerily similar to what we just heard today from a doctor. He's egotistical. He's self-centered. He's narcissistic, she said. And this aggravating factor heightens it. It increases the gravity of this crime or the harm to a victim because he's choosing something selfish to stay out of jail in exchange for taking away human life times 2. It's the whole motive. Quite frankly, with your verdicts, you found him guilty of premeditated murder. This is inherent in that. How? It's the whole entire motive of the case, which we showed you repeatedly, not only with those Snapchats, but that wire. If that baby had been born, I'd be in here sitting right next to y'all. It was a chilling statement, ladies and gentlemen.
Oh,
That was a
get
chilling
on with
statement.
it, man.
In essence, if I kill them, he's saying, I won't be arrested. And that's why this aggravating factor is weighty. That's why you will find it beyond a reasonable doubt. And that's why you'll use it also in your weighing process. Now, this aggravating factor applies to both counts 1 and 2. Why? Baby Hazel is who he wanted to die, so he wouldn't be arrested. If that baby's born, I'll be sitting right here with y'all. He had to kill IS because she was going to have the baby. So the aggravating factor applies to both. And it's weighty. And you get to weigh them. You know, listen, when you get to the mitigating circumstances to kind of conduct that weighing, you can call them wafer thin and light as you can tag them. You heard some mitigation today. I'm not going to spend a lot of time walking through that, but you heard a lot of mitigation. Well, he didn't really get along with his father. You can attach very little weight to that when you pile these up. You can stack those mitigating circumstances to the moon. And they do not outweigh these aggravating factors. And we're only at 2 of 6. Now, third, this one has a lot of instruction to it. This is called the especially heinous, atrocious, and cruel aggravating factor. And Judge Salem will define it in detail for you. You're going to hear the words. Now, this aggravating factor only applies to IS. Why? Because this is who he said he strangled. You can't strangle the unborn baby, so we're not going to argue before you that this aggravating factor applies to Hazel, but it certainly applies to IS. Why? He chose to strangle her first. Listen very, very carefully here, ladies. Listen to the definition of this. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, and cruel is one accompanied by additional acts that show the crime was conscienceless or pitiless or was unnecessarily torturous to IS. Think about this, ladies and gentlemen. He somehow gets a 15, now 16-year-old girl to lure her to his work. He gets her in an area where nobody can see them, off camera, with a gun in tow.
Jesus. See you later, Johnathan.
And he reaches
Thanks,
up
Johnathan.
and starts to strangle her. While she's alive. His own brother on the witness stand said, well, yeah, he called me back and said, you know, he was frantic, he was panicked, he didn't know what to do. Called me back and says, it's been taken care of. What that tells us makes this aggravating factor proven. Why? Because she's alive when he placed his hands around her, and as he described it, he couldn't stomach it. Is it shockingly evil and extremely wicked to strangle a teenage child and then shoot her to death? Yes. Is it outrageously wicked and vile to treat a human being who's carrying what he thought was his baby like this and attack her like this in an industrial lot in the middle of the day when she should be at school carrying his child? Yes. Pretending like he wanted to take her out of town or run off with her. The poor little girl had underwear packed. And when she gets there off to the side, his hands or whatever he tries to strangle her goes around her neck. That's what he said. I'm not even arguing that to you. That's what he said. And oh, by the way, has his gun with him, knowing full well that she can't be gone long. Not in that family. Not with those 5 hands who are wonderful people. And all they do is just, everybody knows everybody else what's going on. There's no way she's going to run off for any period of time, not be missed. We had to do it quickly. planned it a while. That's the next aggravator, CCP. We'll talk about that in a minute. But as to heinous, atrocious, and cruel, it was clear from the brother that he strangled her first. Do you think he did these things to her with utter indifference?
Hi, Chrissy. My darling, hope you're well.
Well, I'll say
Feeling
this.
better.
When he referenced to his brother, he couldn't stomach it. He sure is laughing about it in
fucking
jail
nightmare.
22, 23, 24 days later. Indifference? You bet.
You should have seen his closing.
I'm
not joking you. You should have seen his closing argument during the trial. I couldn't. I had to go like this. He was just absolutely. It's too much, man.
A man capable of killing who he believes is carrying his child, and he couldn't stomach it.
No. I agree, Anne. I agree. You can swear.
To strangle and then bring a gun to work, or there's.
Chrissy, why are you saying why the F? You know you can swear in this chat. Come on, Chrissy.
One purpose for a firearm, especially at that job on that day, and that was to kill her. And he tried a certain way, and it didn't work. Shot her. And that's what he said.
You know, John.
Could have pulled his gun out and just shot her.
Chrissy, I hope you join us on Wednesdays now. We've got Matt coming back. I saw you. There were so many chats going the other night. I just couldn't keep up with them. But I did see you in there. Thanks for joining us for his interview. He's back on Wednesday. Not for all the stream, but he'll be back for bits of it anyway. And he'll be joining us on a weekly basis. Hopefully, we see you, Chrissy.
That's not what he did. That's why that aggravating factor is before you. Pitiless and simply cruel. Now, the next one, that's 3 aggravating factors, folks, and we argue those have been proven to you beyond a reasonable doubt. Here's the 4th one. Cold, calculated, and premeditated manner. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. Drop to that second paragraph. You know the first paragraph. You remember that from your guilt phase instruction. Look at the second paragraph. In order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required.
Sorry to hear that, Chrissy. Shit.
He lures her away from school. He coordinates a ride somehow for her. He gets his gun in advance. He takes his gun from his home and puts it in his pants or truck or his minivan. He drives it to work. He has a plan to get rid of her clothes, her books, her belongings, to get rid of her body, somehow to lure her from Terry Parker High School. He has the dumpster picked out because it normally gets picked up on Tuesdays or Wednesday. Much of this he's saying on the tape. He picks an area where it can't be seen on camera. He picks an area where his wife won't see that he's somewhere unusual, like way out in the woods on the north side or the west side. He picks an area that is off camera. He tells IS something, we're going to run away, or whatever it is he told her, to get her phone turned off, to hide that from the family. He turns off his geolocation data and then blends right in after he does his deed at work. That's why this is cold. It's calculated. It's premeditated. Listen to what he says on the tape. Man, were y'all fixing to run away? Yeah. Were you faking it? And the defendant goes, yeah. That's a plan. As his brother said, he told me he'd been planning it for months. If you read that second paragraph, that's all you need, folks. This aggravating factor
4 of them have been proven beyond reasonable doubt. This is heightened, calculated premeditation. Heightened premeditation. On the wire, you knew it was your baby. Well, I wasn't 100%, but you don't want to take that chance, said the inmate. Here's the defendant's response. Yeah.
Jeez,
it's all about the baby. He wanted her and the baby dead.
Bloody hell, Chris, he be through it.
On the wire. I won't say the word. You've been effing her for how long? About a year, he said.
I'll stop. We need a break from him for a second. Chrissy, sorry to hear that. I didn't know it was that serious. Fuck your employer. What an ass. Jesus Christ, what's wrong with people? Do you know what I mean? What's wrong? Where's compassion with people? Where's, fucking hell. I'm so sorry to hear that. We're here for you, even though you haven't been here for ages, but, you can pop in anytime you want, Chrissy. You know that. Try and take your mind away from anything. I hope you're recovering from the brain tumor, at least. Jesus. Zach is doing okay, I think. Just that he's piling on, he's just going through it. He's writing letters quite consistently. Letters are all up on the website for you to look at. I've not read them for a while, so I don't know if he's updated on there. But Saul, I think, says he's doing okay. I mean, as best you can do, really. It's tough in prison, he said, but yeah, it's far away, do you know what I mean? So, sucks. Yeah, praise for you from Sarah and us as well. That's lovely. Thank you, guys. Chrissy is someone that's been with me from day one. She's a fantastic woman. She disappeared for a while, but hopefully, she came back Wednesday. Hopefully, she comes back a bit more. She definitely has a potty mouth. She's got an aggressive mouth, but she's a very funny woman. Brings a lot. I've missed her when she left. But people got other things to do. Do you know what I mean? So, I always appreciate, obviously, with life, what she's going through now. But Chrissy, welcome back. Sorry it's under these circumstances, though. But you're more than welcome here anytime you want. You know that. But yeah, she's awesome. I'd say she was day one. She's literally from my first ever stream, I believe she was here. So, and she's very sexual innuendos are through the roof when she's around, in a good way.
We know when she got pregnant. Even the defendant, they ask, "Oh, what do you think will happen? You think you'll get the needle?" You know what he says? Yeah, this is premeditated. That's what he said. The only conclusion from the evidence in this case is that he wanted them both dead. This aggravating factor applies to both. Count 1 and count 2. You can take this aggravating factor, you can pack it up and bring it to step 2 of your analysis because it's been proven beyond and to the exclusion of every reasonable doubt, and you should find so unanimously so that you can weigh it. This is the very definition. This fact is the very definition of heightened level of premeditation. The fifth, this is real simple. The unborn child of IS, Hazel, that is her name, was a person less than 12 years of age. I don't even insult your intelligence. That's been proven beyond a reasonable doubt. That you should find unanimously. Now we're up to 5 that you can put in the hopper and weigh against that mitigating circumstances that were presented to you today. And the last aggravating factor. IS, Ayana, and the unborn child, Hazel, were particularly vulnerable because the defendant stood in a position of familial or custodial authority over IS or the baby. Folks, that's her uncle. He believed to be the father of that baby. He believed the baby was his. It's why we're even here. IS is over at the aunt's house, his wife's house a lot. She's over there sometimes alone. Naomi took the witness in and said, oh yeah, once a month or a couple times a month. It's kind of an as-needed thing, but she came over a lot, and the nieces did a lot. Did they come alone? Yes. He made everybody dinner, and then he would give IS her own special dinner, as we heard.
No, I agree.
Making them food. She'd be
it.
gone. Naomi would be gone out in her trucking job until like 2 in the morning. The defendant taught IS how to drive. He took her to the beach. He taught her how to swim against the current. He picked them up and dropped them off at school. There is no question he is in a custodial. He's 33 years old. Over this 15-year-old girl's life in his home. Carrying a secret that that's what he believes to be his child. This most certainly is custodial authority. Not only as to IS, but that baby, he believes it's his. If anything on earth he should be protected over is who he thinks is his baby. That's why this is also an aggravating factor. And it should be weighty to you. Now, once you go through these aggravating factors, if you believe not all 6 have been proven, you can take 4 or 5 of them, still stick them on the hopper. Now, some, as you just heard, one of those does not apply to IS, one of those does not apply to unborn babies. So technically 5 you're weighing against each particular count. You have 6 in total, and that's what you're going to use in your calculus. Think about it this way, ladies and gentlemen. As you evaluate these, and as you weigh these, and as you attach weight to them, think about this. The defendant lured her to her death. The cold, calculated, premeditated plan. He lured her away. She had packed up underwear, and he packed up his gun. When she strolled out of Terry Parker High School on the phone, as you saw with your own eyes, he's in a few minutes going to turn his geolocation data off. Goes right to cold, calculated, and premeditated. Somehow she makes her way out to Ace. What's he doing? Getting bags or a blanket ready. It's cold. It's calculated. It's premeditated. While this little girl is living a confused life, trying to decide whether to have the baby, she eventually did decide whether to have the baby. They were going to have the baby. He, for months, is planning to kill her. That's cold. That's calculated. That's premeditated. In a heightened manner. He had so much time to reflect and just say, no, I'm not going to do it. But he did. But he did. While she made her way to him from Terry Parker High School to Ace that day, he's making plans how to get rid of everything. Cold, calculated, premeditated. As that all-American garbage truck carried her off to her grave, he's calling his brother, telling him he took care of it. That's cold. That's calculated. And 22 days later, as she's cooking in that landfill, he's laughing it up on the wire, confessing with his own mouth. Still trying to figure out a way to keep the authorities from finding her, planning in the jail. Hey, maybe I got someone on the outside. Go over there and move her. Remember that? Now, that's cold.
No, Chrissy.
And that's calculated.
Especially with you.
Meditated. And that's heightened.
Fucking hell, you do all the shop.
Will you hold them accountable fully? Or will you hold them partially accountable?
Oh, dude, just sit the fuck
Now, you
down.
heard a lot about mitigation today. I'm not going to spend any time talking to you about it. But ladies and gentlemen, whether he fixes cars or helps a cousin, whether he makes go-karts for nephews, whether he encourages somebody to go to school, that does not outweigh. You can stack them all up. And you only have to find those by a greater weight of the evidence. Not on the state standard, and it should be. We have to prove these beyond a reasonable doubt. You only have to find those by a greater weight of the evidence. You can, just presuming for a minute, you find every one of those. You can stack them up on one side. They don't even come close to the weight of these six. Not even close. 6. 5, that's each victim. Paul Johnson, one of the most famous authors, great historian too, he wrote this about America, quote, "This is the greatest of all human adventures," end quote. And he said that, and he's right because of our government structure. And our government structure is so right, and everything works. We have these 3 branches of government because all the way back to when Thomas Jefferson said those words and made us a nation of laws is one of the reasons why we're sitting here today. You must be held accountable when you break those laws. Freedom comes with responsibility. The defendant had his unalienable rights. He's forfeited them. You found him guilty. One of those many responsibilities that we have as Americans, from paying those dadgum taxes to getting our licenses or paying your property tax bill, one of those responsibilities is don't hurt anyone else. Well, the defendant killed 2 people. He didn't just kill 2 people, he killed a niece. He killed a niece that he impregnated, he thought. And when you do these kind of things, you must be held accountable. That's what the criminal justice system is for. That's why we've done what we've done these last 2 weeks and a day, and we're handing this over to you. Now it is your turn to hold him fully accountable. Partial justice is partial accountability. Full, complete justice.
Oh, just sit down, counsel.
And if you really think, as I close, think about this. Justice is everywhere. We all strive for that. These systems that we sit in today, that you're getting to watch the judiciary and the executive branch and the law with the legislative branch, you've watched it at work. And think about this. Justice is mentioned everywhere you go. I visited New York City recently, and in Theodore Roosevelt's childhood home, this famous quote he said is on the wall. The fundamental need in dealing with Americans, our people, whether laboring men or others, is justice. Right off the National Mall, Washington, D.C., you can go walk up and look at a Dwight D. Eisenhower monument, and plastered on stone is the following quote: "We look upon this shaken earth and we declare our firm and fixed purpose, the building of peace with justice in a world where moral law prevails." You can walk just another mile and look up at the United States Supreme Court, and it says, "Equal justice under law." I started by quoting Thomas Jefferson for you. Listen to what Thomas Jefferson said about justice. Quote, "The most sacred duties of a government is to do justice to all its citizens." Will you do justice? These verdicts that you handed down on Friday, coupled with these aggravating factors, cry out for justice.
Yep, it's fucked. Justice system is fucked.
Bring the court back a recommendation to impose the death penalty for both count 1 and count 2 against the defendant. Because after reflection, after thought, you will see that these aggravating factors have been proven beyond a reasonable doubt. You will see that they outweigh every mitigating circumstances the defense is going to talk to you about, and then justice will be closer to being completed. Ayanna and Hazel are gone. Their liberty is gone. Their pursuit of their happiness ended on December 19, 2018. A justice for her and her baby continues to this day. Complete justice for Ayanna and for her unborn baby.
Oh.
Impose the death penalty on this defendant for killing these two human beings. Thank you.
It makes it sound like the death penalty is so easy to decide. Oh, it's just easy going there.
Counsel for the state and defense, can I see you at sidebar on a quick
Yes, sir.
issue real quick? Members of the jury, feel free to stand up and stretch if you would like.
I never watched the Casey Anthony one, so I got no comment on that one. But I heard Dr. Hines saying that he was literally, was it first degree only? There was no other charges to go with. So she got away with it. I find that kind of lawyer very annoying to listen to. I'm sure he thinks he's effective, and maybe he is. I mean, just not my cup of tea. Not my cup of tea. Not my cup of tea. 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 Summer loving happened so fast. Summer loving had me a blast. Marigold, cute as can be. Matter boy, something to me. I don't think he's doing the rebuttal if there is one. I don't think there should be a rebuttal, but oh no, don't say the guy in the wheelchair's doing it. Oh, for fuck's sake, please don't. Oh, please not a male attorney.
Counsel, you may give the floor after we Yes, ma'am.
Thank God for that. At least she's quite good.
Good afternoon again. Thank you so much for your time. Thank you for your attention today. Thank you for coming back after the weekend. Appreciate that. What you heard today echoed from several people about the person that Johnathan Quiles was and has been to his family. You didn't just hear today about the type of person that he has been. You heard about it throughout the last couple of weeks as well. And something that was said today a couple of times is that something redeemable there with Johnathan Quiles. You've heard about the aggravating factors from the state. I'm going to go through a few of those with you. Not all of them. Some of them we're not going to make any strong arguments to. I'm not going to insult your intelligence, as Mr. Skinner said. IS's unborn child was obviously less than 12 years. I'm not going to stand here and argue about that. But I do want to go through some of those because what you must do for each of those aggravating factors is you must unanimously find that each has been proven beyond and to the exclusion of every reasonable doubt. So I just want to bring to your attention a few things that we believe the state has failed to prove. As we talk about prior or previously convicted, we're talking about the crimes that you all just found him guilty of. We're not talking about some extensive or prior criminal history before this. We're talking about these crimes here today and only these crimes that you all found him guilty of. There's nothing previously from that. The second factor that they talked to you about had to do with the purpose of avoiding or preventing a lawful arrest. And I ask you, has that been proven beyond and to the exclusion of every reasonable doubt? That was the purpose behind what you have found him guilty of doing? If you do not feel that that is the case, if there's any doubt to that, any reasonable doubt to that for you, that is not an aggravating factor that you can put into that pile and start weighing, as Mr. Skinner used that analogy several times. The comments that were made later on are being used to inform about maybe what his mindset was at that time. But there's reasonable doubt as to those comments, what the truthfulness of those really were.
The only, Christy, the only thing about this one is in Florida, it's obviously now 8 out of the 12. It's only 8 yeses for the death penalty they need. So that's a change. They don't need the 12 now, just 8. So that might change something, you know. We'll see.
I want to move on to the heinous, atrocious, and cruel, HAC as we sometimes call it. And it's kind of coupled with the cold, calculated, and premeditated aggravating factor as well. It's hard to have both. Can't have it both ways. And by that I mean, you can't say, oh, I couldn't stomach strangulating someone, and it's cold and calculated. You can't say that that at the same time goes in the same bucket. Those contradict each other, and the facts and the things that you all found, the testimony and the things that you heard on the wire, contradict some of this. So I want to go through a few things with you. On the wire, the thing that you heard was him confessing to shooting IS. That's what you heard. He never once in that wire talked about strangulation. A shooting death generally is not included in that heinous, atrocious, and cruel aggravating factor category. Doesn't mean that shooting death is not a terrible thing, so don't get me wrong. That's not typically what they're talking about. We're talking about something worse than that, something where that victim was in a torturous type of circumstance. And a shooting death is typically not that type. The thing that you heard is actually from Damian Hatch. That's the person who said that there was a strangulation and he couldn't stomach it. And that testimony, we believe, has been proven to not be the truth. So if you're thinking back to what was said and what was brought up, I would stress to you all to think back to that testimony and what you actually heard. Reasonable doubt exists as to that aggravating factor. You talk about the statement of couldn't stomach it. That's not consciousless. That means there was some conscious there. There was something there that said, that's not right. I can't do that. And it's such a crazy thing to stand up here and argue and talk about strangulation versus shooting death, which one was worser, and that type of which one's worse or not. Such a strange thing to stand up here and say. But the strangulation part is the part that would rise this particular crime to the level of heinous, atrocious, or cruel. And so when you're thinking through that, if there's doubt there, if there's reasonable doubt there, that is not an aggravating factor that you can bring on to that next section. We're not arguing that there isn't at least one. I'm not making that argument. So, when I'm talking to you about these factors, it has to go to what you're weighing in the end as you learn or think about these aggravating factors versus those mitigating circumstances. Let me talk to you about the CCP, cold, calculated, and premeditated. Cold, calculated, and premeditated. Ms. French told you in her opening, that's the one they have to prove all of those. It's not or. You must be convinced beyond a reasonable doubt that each of those existed. And what will we submit to you provides reasonable doubt for that particular factor? What did you hear from his brother? His brother told you that he called him in a panic, that he called him frantically, not knowing what to do. This is the day that this murder is alleged to have happened. That's not evidence of a months-long plan. That's someone who didn't know what they were doing. And specifically for the cold, that particular definition that you're going to be read from the judge talks about cool and calm reflection. And specifically, it's not an act that's prompted by emotional frenzy, panic, or fit of rage. We would submit to you that the evidence you've heard is that he was in a panic, that he was frenzied. That negates the cold portion of that aggravating factor. And if you don't have each of those, you cannot bring that aggravating factor into your weighing process. The sixth one, the fifth one has to do with the unborn child being less than 12. So I'm not going to talk about that one. The sixth factor that they talk to you about has to do with being in the familial or custodial relationship. You've already found that Mr. Quiles was in a familial or custodial relationship as it relates to IS. That was found within your sexual battery finding. I'm not arguing that. What hasn't been found, nor has it been proven beyond a reasonable doubt, beyond and to the exclusion of every reasonable doubt, is that he was the father of IS's unborn child. He didn't even know. If you take every word that he said it was a possibility, but he didn't even know that. So has that been proven, that he's in a familial or custodial authority over the unborn child? If there's doubt to that, which I would submit to you, that will be doubt, then you can't bring that into your weighing as it relates to the unborn child. Mr. Skinner talked to you a lot about being held accountable for your actions. I want you to think back to jury selection. Seems like a lifetime ago. It's 2 whole weeks ago. 2 weeks ago we started. I asked each and every one of you if you believed that life without the possibility of parole, in the worst case you could imagine, if that was a sufficient punishment. I asked each and every one of you that. You all agreed to that you did believe that life without the possibility of parole was a sufficient punishment in the worst of cases that you could possibly think of. So when we talk about fully or partially accountable, life without possibility of parole is being held accountable fully for your actions. There's no partial there. I asked you during jury selection if you'd be able to meaningfully consider the mitigating circumstances that will be presented to you. I told you that those mitigating circumstances could come from anything. It could be something that we presented like we did today, witnesses that you heard from. It could be something that you heard throughout the trial. It could even be something that the state has said. It could be anything that you've heard, anything that you've observed. And if you recall, when we were talking about those mitigating circumstances, I told you all that it was a very individual assessment, a moral judgment by each of you that you would have to make as to each mitigating circumstance that you find any weight to. And we have to prove those to you by a greater weight of the evidence, and I would submit to you that we've done that for each of the mitigating circumstances that I'm going to go through with you all. I want to talk to you about some of the things that we didn't present here today and just remind you of them from what you heard throughout the trial. You heard from Johnathan Lindros, and you heard from Gary Lindros. They talked to you about the type of worker, type of employee that Mr. Quiles was during his time with them. He wasn't with them for very long, only a few months. But he excelled. He did his job well. They said he did his excellence. He went above and beyond. He was a model employee. That has been proven by a greater weight of the evidence. You've heard that from multiple people. You've heard several other witnesses say the same thing about him, not just in his as an employee, but just in general of how he is and the type of person that he's always been. He's a hard worker. He's someone who will go out of his way to help people. You heard anecdotal evidence of him building stuff at church, a sound booth, or the band area. You heard other people talk about him helping them out with several projects and things like that around the house, coming up with things. If he didn't know how to do it, he'd figure out how to do it to help out. But that was the type of person he always has been. You heard from Ulysses Dixon.
Controversial, Chrissy.
He was the gentleman who came in, who led the Bible study. He told you about the things that he's observed of Mr. Quiles since he's been incarcerated for these last almost 5 years. He talked about how I think he said he clipped toenails for some of the elderly, that he helps out other people. You heard that echoed by Dr. Rohrer today. That's been reported by several people, that he was helping the elderly, helping those who are more vulnerable. The other things that you've heard about his background since he's been incarcerated, that he's been a model inmate. He's got no disciplinary reports whatsoever in nearly 5 years. And not only that, Dr. Rohrer told you that she was shocked to find out, surprised to learn, that he was allowed to be an alternate trustee, to go and clean the jail, and did that to excellence. He didn't have any issues, was entrusted with that. Why is that so important? Why would we be bringing that up to you? Why is clipping toenails for the elderly something that you would care about? Because it demonstrates that there's something redeemable there. There's something good that he could still do, even after what you all have found him guilty of doing. There's something that's worth saving. You all get to decide what weight to assign to each mitigating factor that I'm about to go through with you. That's a decision for each of you to do. Each of you get to decide how much weight. We don't get to tell you that. We don't get to tell you that if you stack these up, there's no way they could overcome it. Only you can decide that. It's an individual decision that each of you have to make. Now, collectively, you all do need to find unanimously that each aggravating factor has been proven beyond a reasonable doubt. When it comes time to making that weighing, that's to you. That's to each of you. And the other thing I talked to you all about during jury selection, which is so critically important, was that individual decision and that individual moral assessment that each of you are going to make. We asked you all to treat each other with respect. We asked if you all would all agree to respect the decisions of your fellow jurors, and especially if they happen to disagree with your individual assessment. This is what we were talking about. That's the weight that we've put on you all. That's the job that you've been tasked with. So we're asking you to do that. We're asking you to look to each of those mitigating circumstances and weigh them against the aggravating factors that you find beyond a reasonable doubt. You heard from Mr. Quiles' family members and friends as well. You heard from a neighbor, someone who he worked on cars with, someone who he just happened upon. You heard him talk about the type of help he provided to him. Mr. Hale, Curtis Hale, gave you that information. You heard from a best friend of his aunt who was kind of like his mom. You heard the encouragement that he was to her during hard times. You heard from nieces. You've heard from cousins, nephews. You've heard from someone who was just like his mom, stepped in after his mom passed, became that aunt/mom, as she would describe. You heard her talk to you, and several of them talk to you about their love for Mr. Quiles. They've been here. They know the outcome. They know your verdict. And they were still willing to come here and testify to their support for a family member. To ask you to consider that when you're weighing these most important factors and circumstances. They asked you to save Mr. Quiles' life. Now, you're the trier of fact. We've been saying this from the beginning. You're the ones who get to decide, moving forward, what will be the recommendation. Let me talk to you about one last thing. We brought this up during jury selection as well. Actually, hold on one second. Let me grab. All right. Just want to go through these mitigating factors a little bit more in detail.
Oh, geez,
And
here
then
we
I'll
go.
wrap up with the last thing. One of the first mitigating circumstances that you're going to hear read from the court when you're read those instructions shortly will be that Mr. Quiles has no significant criminal history. Uncontroverted. No one has said that. That has not been disputed. That we have proven by a greater weight of the evidence. He doesn't have a criminal history outside of what you all have found him guilty of. He was 33 at the time of the crime. You've heard that he was raised by his mother. You've heard about his father being absent from his life and the effect that that had on him. You've heard about the loss of his mother and the effect that that had on him as well. You've heard about their special bond, their
What must
relationship,
he be thinking?
and how that bond has transferred over to his aunt. You've heard about from his aunt how she sees her sister through her nephew/son. You also heard about some of the challenges that he had. You heard about him using marijuana and alcohol and that being something that was normative, meaning maybe that's just the culture of the family and the effects that that has had on him as well. Dr. Rohr talked to you a little bit about, very briefly, but she talked to you a little bit about him suffering some abuse growing up. You heard from his aunt about some conflictual relationships that he's had with his brother, and that being a very difficult relationship. You also heard about his education. He dropped out of school in the 7th grade, didn't complete the 7th grade. He's self-taught, but for the most part, that was it as far as schooling goes. He did that because he became a father very young, at just 15 years old. 15 years old, he left school, started working. He's worked ever since, supports his kids. You heard that he has and has had a good relationship with those kids. He's got five children. 5 children that he still maintains a relationship with. You heard about the area that he grew up in. Even growing up in a high crime, poverty-stricken area in Brooklyn, New York, you still heard that he stayed out of trouble. He at one point went into a drug rehab facility to get away, according to him. Get away from what was going on around him. You also heard from Dr. Rohr about personality disorder, what that means for his relationships, what that means for him acting on impulse, doing things without thinking things through. He doesn't have any sort of severe mental illness. He's of average intelligence, which I would say is probably higher than what you would think of someone with that, with a less than a 7th grade education. He doesn't have any known neuropsychological issues or anything along those lines. Pretty average in general. No cognitive deficits or anything along those lines that you have to consider. But he did have a bit of a dysfunctional background, dysfunctional upbringing. Now, just to kind of go through, and I've gone through a lot of the other ones already, just to kind of go through that last thing, I talked to you guys about this during jury selection. If you can recall what I said to you, I told you all that you may get to this point. We talked about the process that you all have to go through. There has to be at least one aggravating factor. If you find one aggravating factor, then you move on to the next step. That next step, where we kind of do this weighing, and I'm skipping some of it, but you're going to do that weighing process. You found mitigating factors. I believe there are mitigating factors that have been proven by a greater weight of the evidence that you have. There's going to be aggravating factors that have been proven beyond a reasonable doubt. We're not disputing that by any means. When you go back and you do that weighing process, even if you find that those aggravating factors outweigh the mitigating circumstances that we've presented, that you've heard, that you've observed, that you believe, that you, in your individual assessment, determined to be true, even if then you find that those aggravating factors outweigh, life is still an option. You all still have the ability, even after all of that, to say life without the possibility of parole is the appropriate punishment here. And I'm sure you remember, we went through this painstakingly because I asked so many of you that question. I asked so many of you, if even after weighing, and even if you find that this is the worst case scenario, even if you find that those aggravating factors significantly outweigh, life is still an option. There's something redeemable here. There's something here that you can latch onto and say life without the possibility of parole is what's appropriate in this circumstance. And that's what we're asking you to do. We're asking you to save his life. Does he deserve it? You probably don't think so. But is there something there worth saving? Is there something there that would make you all come back and say life without the possibility of parole is appropriate? It is a sufficient punishment. That's not letting somebody off. That's not letting accountability go by. That's holding someone accountable. That's making sure that this person does not have the possibility of ever doing anything like this again. So we would ask you today, as you go back, as you look at everything, when you come to that final decision within yourself of what is the right thing to do in this case, remember that life is still an option. And we ask that you would come back with that recommendation of life without the possibility of parole. Thank you.
I think that's it. I don't think
the jury, you
get
now
a
heard all the
rebuttal.
evidence and the argument of the
So the difference here is they don't get a rebuttal because obviously the defense going to finish off because this is a death penalty, you know. So they should be able to defend and have the last word on it. So that's why they finish off, and there's no rebuttal.
counsel. It is now your duty to make a decision as to the appropriate sentence that should be imposed upon the defendant for the crime of first-degree murder. There are two possible punishments. One, life imprisonment without the possibility of parole, or two, death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim. No facts other than proven aggravating factors may be considered in support of a death sentence. The aggravating factors alleged by the state are as follows. Please note that the following aggravating factors apply to both counts 1 and 2 unless otherwise noted. 1. Johnathan Quiles was previously convicted of another capital felony or a felony involving the use of threat of violence to another person. First-degree murder is a capital felony. The crime of sexual battery is a felony involving the use or threat of violence to another person. 2. The first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. 3. The first-degree murder was especially heinous, atrocious, or cruel. This applies only to count 1. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to, or even enjoyment of, the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to IS. 4. The first-degree murder was committed in a cold, calculated, and premeditated manner, without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. 5. The unborn child of IS was a person less than 12 years of age. This applies only to count 2. 6. IS was particularly vulnerable because Johnathan Quiles stood in a position of familial or custodial authority over IS. This applies to count 1. The unborn child of IS was particularly vulnerable because Johnathan Quiles stood in a position of familial or custodial authority over the unborn child of IS. This applies to count 2. The state has the burden of proving an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt, and you must not consider it in providing a verdict. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, in conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. You will be provided with a form to make this finding as to each alleged aggravating factor, and you should indicate whether or not you find each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty, and your verdict must be for a sentence of life imprisonment without the possibility of parole. At such point, your deliberations are complete. If, however, you unanimously find that one or more aggravating factors have been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must next determine whether the appropriate sentence to be imposed is life imprisonment without the possibility of parole or death. First, each of you must determine whether any mitigating circumstances exist. A mitigating circumstance is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, life, or any circumstance of the offense that may indicate the death penalty is not appropriate in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, the defendant need only establish a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it established and give that evidence such weight as you determine it should receive in reaching your verdict about the appropriate sentence to be imposed. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are as follows. 1. Johnathan Quiles has no significant history of prior criminal activity. 2. Johnathan Quiles' age at the time of the crime. 3. Johnathan Quiles was raised by his mother while his father was absent from his life. 4. Johnathan Quiles was 33 years old at the time of the offense. 5. Johnathan Quiles began using marijuana at the age of 12. 6. Johnathan Quiles lived with his mother, but she was never present in his life and always worked. 7. Johnathan Quiles' mother's boyfriend abused him. 8. Johnathan Quiles was forced to drop out of school at a young age to take care of his child. 9. Johnathan Quiles went to drug rehab at the age of 15. 10. Johnathan Quiles began to work at age 15 to care for and contribute to his family and was unable to finish school. 11. There were no men in Mr. Quiles' mother's life on a regular basis. She had short relationships with men, and her boyfriend abused him. 12. Johnathan Quiles' brother regularly bullied him. 13. Johnathan Quiles' mother is deceased, and his only relatable family is his aunt and cousin. 14. Johnathan Quiles was raised by his mother in a high crime area. 15. Johnathan Quiles fathered a child at the age of 15 and had to work to provide for his child. 16. Johnathan Quiles had a poor relationship with his father, and he was absent from his life. 17. Johnathan Quiles' father was absent from his life, and his mother used corporal punishment. 18. Johnathan Quiles' IQ test is above average intelligence despite dropping out of school at a young age. 19. Johnathan Quiles does not have any known cognitive or neuropsychological deficits. 20. Johnathan Quiles has a history of alcohol and cannabis abuse. 21. Johnathan Quiles has a dysfunctional family background. 22. Johnathan Quiles has one brother. 23. Johnathan Quiles has a close relationship with his aunt and cousin. 24. Johnathan Quiles has a loving relationship with his 5 children. 25. After Johnathan Quiles dropped out of school, he had to take care of himself and his children. While his mother lent support, he had to take care of responsibilities, causing him to leave the family home. 26. Johnathan Quiles was a hard and dedicated worker. 27. Johnathan Quiles has no disciplinary reports while in jail since his arrest. 28. Johnathan Quiles worked as a trustee in the jail. The final step in the process is for each of you to determine whether the defendant should be sentenced to life without the possibility of parole or death. In making your decision about whether the defendant should be sentenced to life without the possibility of parole or death, you must weigh the following factors. 1. Whether sufficient aggravating factors exist. And 2. Whether the proven aggravating factors outweigh the proven mitigating circumstances. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular aggravating factor or mitigating circumstance. Regardless of the results of each juror's individual weighing process, even if you conclude that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to recommend that the defendant should be sentenced to death. If fewer than 8 jurors vote to the death penalty, your recommendation must be for life in prison without the possibility of parole. If 8 or more jurors vote for the death penalty, your recommendation must be for the death penalty. You will be provided with a form to reflect your decisions. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your decisions.
I agree, Christy. I agree.
Considering the aggravating factors and mitigating circumstances, it is up to you to decide which evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in making your decision as to what sentence should be imposed. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence in these instructions. The case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your decisions should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. The verdict must be in writing, and for your convenience, the necessary forms have been prepared for you. They are as follows. There's 2 forms. Each form is 3 pages, one form for count 1, one form for count 3. It's slightly different than the last one you had last week, but although very similar. The one I'm holding right now is one for count 1. As you can see at the top, it has the aggravating factors, and it goes through each aggravating factor for that count alleged by the state. And it says, we the jury unanimously find that the state has proven the following aggravating factors beyond a reasonable doubt as to the defendant, Johnathan Quiles, in this case. And then you go down each aggravating factor and you check yes or no. That has to be a unanimous decision by all 12 of you on the jury panel. And remember, there's 5 per count, 6 total. If you check, and then on the next page, it tells you if you, the jury, answered no to every aggravating factor listed, you've completed your deliberations. The foreperson should sign and date the form at the end of the form. If you, the jury, answered yes to any aggravating factor listed, then you go to section B, which is on page 3. And section B is on the last page. It goes through the instructions that you are supposed to go through, that weighing process that was talked about. And then at the very bottom, it tells you how to return your verdict in that regard. And then the foreperson signs and dates it. And that's the same process for count 2 as well. In just a few moments, you'll be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about this case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through telephone, writing, electronic communication, blogging, Twitter, email, texting, etc. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, other devices here in the courtroom. The rules do not allow you to bring those phones or devices with you into the jury room. Mr. Gray will take custody of them just like last week, and you'll be given back to them at the conclusion of your deliberations or if we break for the day and come back tomorrow. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in that note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. I cannot participate in your deliberations in any way. Please disregard anything I may have said or done that made you think I preferred one decision over another. In closing, let me remind you that it is important that you follow the law spelled out in these instructions. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. So, fortunately, we had all 16 of you for the past 11 days. Do the 4 alternates from last week, do you guys have any personal effects in the jury room? Okay, well, Mr. Gray will take you there to get your personal effects. I'll bring you back in here, and then I'll dismiss the other 12 to the jury room.
Oh, more people are going for life without parole. In the poll. Take part in the poll, see where your vote is. Most people are so far going life without parole you'd give him. I think they'll deliberate for a while. It depends on the makeup of it, Chrissy. I don't know what the makeup of the jury is.
My left, your right. So, members of the panel, just like last week on Thursday, it's about 4:20. We'll be here until you guys tell us otherwise. If you guys want to break for the day and come back tomorrow morning, that's perfectly fine. Just let us know, and we'll bring you back tomorrow morning. When you guys let us know you want to break for the day. If you guys want us to order you dinner by a certain point, let us know. We can certainly accommodate that as well. We need to know by 6 if that's your preference. If you don't want to break for the day and you want to go for a couple more hours, it's up to you. There is no rush. You take whatever time you guys need. We will wait to hear from you as to what you want us to do in that regard. We will be here as long as you want. And if you want to break or order dinner, we will do that. And if you want to break, we'll come back tomorrow morning and just continue your deliberations. It's up to you guys. You can let Mr. Gray know immediately, or you can wait a while and slip him a note, and we can go from there. And I'll let the attorneys know what your preference is in that regard as to how we move forward. But until then, all the evidence and the instructions will be provided to you in the jury room, and we will wait to hear back from you guys. You guys may have a seat. So to the 4 of you, this officially ends your jury service with us. You are officially dismissed. I'm sorry we had to bring you back, not knowing, you just never know what's going to happen with a member of the jury, so we wanted to make every effort. We brought this to conclusion this week.
Yeah, I'm
even
so
though
sorry.
you couldn't serve and be in the deliberation room, please don't think that your service is any less that we are less grateful for your service. It is to be here for 11 days is a monumental task. To be away from your family and friends, your work, personal lives, essentially put it on pause 2.5 weeks ago, is a monumental task. I am fully aware that when you got that summons in the mail about 2 months ago now, and when you came here that Monday morning, this is not what you thought your life would go for in September. I am extremely grateful for your service. We can't do our jobs in this courthouse without people like you willing to serve and step up. And I gave this what I thought was a profound speech a couple weeks ago regarding jury service and what it means.
I hate
I am
it.
incredibly grateful for your service.
I'd hate it.
But with that said, I'm sure you don't want to hear me talk anymore. You guys are officially dismissed.
I'd be pissed off right now.
And I feel like I know you guys already, but I don't know you at all. So you guys have a good day. Just so you guys know, the cameras never showed you guys. No one knows your identity. That's why I use juror numbers. That's my practice. And so just feel some solace in that. That said, you guys, security walk you guys out, and you guys are free to go.
I would be pissed right now.
All right, so the jury is officially outside our presence. I wanted to make a couple grammatical changes to the jury instructions. I read it as if the grammatical changes were fixed, but I want to give them a clean copy. So other than that, is there any exception or objection to the instructions as read to the jury from the state?
Your Honor.
Defense.
Judge, we raise our previous objections that we had stated before, having to do with elevators and
The familiar or custodial issue?
Yes, sir, Your Honor.
Okay. Anything else?
No, sir, Your Honor.
Okay, well, we'll be in recess. I'll fix this up. I'll sign them and get them off to the jury panel, and we'll just notify you guys when we hear something. So we'll be in recess.
Oh, okay. Okay, so right, let's take this off. So we don't know how long they're going to be. What I'll do is I'll stay online till 6. After that, though, I can't. Because that'll be 11 o'clock at night here. So that's my only promise. I'll stay on till 6, or until we know what they want to do as a jury. I don't think it's going to be as quick as what the result was. If it is as quick, that means I believe it's going to be a what do you call it? It's going to be life without parole if it's that quick. Because a death penalty. Oh, I'm the same as Sarah. I'd want to be there deliberating and everything. Christy, and they don't get paid enough to cover the cost of gas back and forth. It's ridiculous as jurors. Look, I get it. You're offering a service. You're doing and it's a good thing. Don't get me wrong, it is a good thing. But you Americans, you don't get paid. If you lose work, you don't get paid, do you? So for 2 weeks, they've not been paid, or have they? At least here in the UK, you get paid for it. I mean, your work-wise, there's a special thing going. Well, after take a couple of weeks off, then you'll still get paid for it. Do you know what I mean? So in most places, then not every place, I don't think, but in most places. So I would vote life without parole. Life without parole. I mean, it wouldn't have to be make decisions, but $6 a day is nothing when you're missing. Yeah, that's what I was saying. That's what I was saying, sorry. You don't get paid. $6 a day, you can't live with that. In the UK, we get paid for it, so it's fine. Go to bed, catch that. Oh, I'm not going to bed, and it's all good. It's only 9:30 here, so I'm going to be up till midnight anyway. I've only got to go to bed a little bit earlier because I've got gym in the morning, so it's a class and I can't miss it. Well, I can't miss it, but I don't want to miss it. So, well, I do want to miss it. Do you know what I mean? I don't want to go, but I should go. It's one of those. Um, do they get food and stuff though? I know in some of the jury deliberations they get food given to them. But is that true for all? I don't think that's true for all of them. Because I remember Judge Boyd saying, but thank you anyway. And thanks, Anne, you're the only one that cares about me. Everyone else is like, stay up, monkey. Stay up, you monkey. We'll make you work. Anne's very kind. Oh, shut down, go to bed. Thank you, Anne. Very nice of you. See, everyone else can learn something from Anne. Be nice to me sometimes. So essentially, they don't provide food then. So no wonder people go there and try to make anything up not to be a juror then. Ah, and you, Mary. Of course you care, Mary. I know you care, Mary. It's more about Sarah and Chrissy and all them, do you know what I mean? I'm just having a laugh. Oh crap. Did I just take everything off? I clicked the button. Where you from? Do you speak Welsh? Welshie, do you speak Welsh and where you from? Well, I'm not going to sleep yet. I'm still up for a bit. I thought so, Sarah. I thought so. Great name, innit? Welshie. I thought so, Chrissy. Sorry, not Sarah. Chrissy. No, I'm staying up for another hour and a half max. If they come back and say, "Oh no, there's no court," we come back tomorrow, then obviously close down. Ah, well, so do you know? Oh, well, you don't know her. We got another one here, Emma. Emma. She's from Newport. She was here. Are you still here, Emma? She may have popped out. Emma, Evolve. Emma. She's from Newport. Goldie looking chain, Newport. Something in Newport, Newport, Newport. So we got a Newport resident already. We got Anthony from Brecon. He's lurking here somewhere. I'm from West Wales, more the other side of Swansea, Carmarthen way as well. So, and we've had a few from North Wales popping in and out. So, Welsh, are you male, female? Because most people here are women. And with the name of Welshie, I don't know what you are. Not that I care, but it's always nice to know who we got here. My demographics are normally women. Newgale Beach, yeah, it's nice. Newgale Beach is nice. I'd never go there, but it is nice. It is nice. You're right. Oh, you're female. Happy days. More fucking women to give me shit. Do you know what I mean? I'm only joking. No, I'm not, because literally nearly everyone here is a woman, and they all give me grief. No, they don't all give me grief. Anne and Mary are very kind to me. They're nice to me. No, they're all lovely to me. But you know, literally, I don't know what it, all. I think the women just love to see me topless, my tits out or something. I don't know what's going on. Um, Chrissy, you've been missing those streams, Chrissy. I've been doing a lot of topless streams recently. Oh, we could do a wheel. Let's do a wheel, shall we? I owe two wheels. I owe one from yesterday and today. If it says end stream, then we're not ending stream, but um, right, I need to find the wheel first. Let's see if I can find. If I could find the wheel. If here it is, Merry Christmas. I got it. Everybody's having fun. Do, 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 do. If you're new here, you don't know about the wheel. The wheel is a nightmare. But the wheel is always just, so I have to take part in it. Put myself up there. Right, window capture, is it? Which one is it? This is the one. Right, I need to go in there. Take Law and Crime out. No, wrong one. No, wrong one. No, wrong one. Jesus. Oh, here we go. I got it. I got it. You see, fucking, I've probably done about 5 different streams now, topless. I got to do a members one Thursday, topless as well. Fuck my life. But like the regulars starting to get bit had enough of it now. They've seen my tits now. And my man boobs, they've seen it too many times. They've used the vibrator quite a bit on it. So here we go. Oh, spins already happening. Remember, 2 spins. Please land on something nice for me, bad for Sarah. Don't be a Cowboys jersey because I just put it in the bloody wash. What? Oh, where's my phone? Quick. Damn you. Let me take a photo of this quick before it goes. Yes! Eric Hack! Let's fucking go! Let's fucking go! Right. Let me take this, send this to Erin. She won't believe me. The wheel is just. She's going nuts. I know. Rigged wheel. She's not. I just sent it to her. She got an anniversary today as well. So the bunny will be out tonight. She'll be shagging tonight. And she'll realise this Erin Hack plus one. But she has got time whenever she wants to do it. She can choose who she wants to do it with, and it's up to her. I remove it now. This is fantastic. Remove that one and spin again. This is fantastic news for me. That was. Oh, I love that. Next wheel. Ooh. Don't be drinking anything. Can't be asked to drink. Oh, if there's milk, I'm taking it off because I. Stop, stop. Let's go! Let's go! Let's fucking go! Yes! Let's go, Sarah P! Sarah P's doing a. She's gonna be doing a stream. Sarah P and Josie gonna be doing a stream with me. Yes! This is this is fantastic. How is that? How did that happen? How did that happen? Removed it now. No, don't start us rigged. There's no ways it's rigged. That's that's unbelievable though. That's unbelievable. You can't rig it. I can't rig it. That's great though. This has made my day. Genuinely made my day, people. Because they got away from doing one, be the last one. So they have to do it this time. This is fantastic. It's made my day. Made my day. Made my day more than you'll ever know. Oh, that is fantastic, Sarah and Josie. Yes, going from Newport. So, well, it's okay. You and Josie can do it on Niners. We'll do it on Sunday before the Niners play. 'Cause I know during the week you can't do it during the week, you work. But Um, Josie, by the way, Josie's off. She's a little bit ill. That's why she's not here today. But she'll be back Wednesday, I think. So that'll be good news for her when she sees that. I'm not going to tell her now because, you know. Um, but I can't believe it. Got Erin Hack on one stream with whoever she chooses, and I got Sarah P coming on with Josie. Ladies, this is great. This is great. So we'll do a stream about 40, NFL 49ers. We'll do, you two take the lead on it. So whatever subjects you want to talk about, you could even do it just the two of you. I'll be in the back. I'll just control it. Whatever you want. Do you know what I mean? Sarah P's on the vape now. She's going mental now. Telling everyone in the office to go fuck themselves. Because she's gonna have to do a live stream. Oh, this is what I love. So, Welshie, welcome. This is what we do here. We do a little bit of a wheel. So, I'll say Emma's here, but she's not here at the minute. She's going to be gutted when she finds out that you popped in. Because she's always here, but for whatever reason, she must have had to pop out or is busy working or something. Um, so, yeah, I don't know. How did you find us, Welshie? How did you find the channel? Because we've never seen you here before, so how did you come across this? Randomly, or what was it? Someone tell you about us? I'm always intrigued to see how people find us. People tend to find us and they tend to fuck off then. Because they don't like our swearing and stuff, or some of our stances. Oh, I love it. That's woke me up. I'm feeling good now. I've had to wear a fucking crown today, so and I've got to wear a tutu, Sarah P. So let's not forget some of the things that I have. I've had to down a pint of milk. I've had to fucking uh, drink two cans of beer. So let's not forget, guys, how much I've had to do as well. So there's no rigging here. This is great. This is people that don't know. People knew, like, well, she won't know, but to get Sarah P on here and to get Josie on here, and to get Erin on here, the bunny herself, or the taco as we call her, or the bunny we found out was another nickname. So I'm happy. I'm happy. Wales won last night in rugby, and now this happened, so I'm happy. But I got gym tomorrow, so I'm not happy. I'm not happy. Um, I'll say I'll stay on for a little bit longer, especially now I'm in a good mood. I'm not going to show anything. I'm just going to chat to you if people want to chat. If not, there's no point me staying on. Um, let's have a look to see what. Let's have a look here. Where are we at here? What's the score on the doors? So most people are life without parole. Fair? I think that's a consensus. Life without parole. How are you feeling, Sarah? Erin Hack has not come back to me at all. Happy anniversary, Erin. Mm, just super. I think you'd be going to be excited. Do you know what I mean? Can you imagine if it's a topless wheel? Oh, you'll be fine. You'll be fine. We'll get your tits out. It's all good. Joking, joking before you go nuts again. Joking. Um, no, I'm happy. I'm happy. There's no rush to do it either. Do you know what I mean? It's when you and Josie want to do it, and when Erin wants to do it. No, Erin's pretty busy at the minute, so I'm not gonna be like, oh, it has to be tomorrow. Or no, it's when you can do it, when the kids and stuff allow you to do it. So whenever you and Josie can do it. But we're not gonna put her off all the time. You're gonna have to do it because there comes a point I'll stop spinning the wheel until you do it. Oh, I'm happy. I wonder who Erin will get on with it. Not sure who Erin will choose. Don't know. We'll have to see. We'll have to see. But I've sent her that she can enjoy your anniversary. Do you know what? I don't think they're bringing the results back tonight. I got a feeling. I got a feeling. Tonight's gonna be a good night. Tonight's gonna be a good night. Tonight's gonna be a good night. I got a feeling. Ooh. Right. Do you know what? Chat's gone all quiet now, so there's no point streaming. Um, it's all good. I do understand people are working and people have got stuff on, so it's not a. I'm not blaming the chat for being quiet. So what I'm going to do is I'm not going to watch this any further. I will stream it tomorrow, 2 o'clock UK time, 9 o'clock Eastern time, 8 o'clock Central. So if a verdict does come back tonight, I'll just play that. I'm not going to watch it beforehand. I'll just, because they'll be back at 9 o'clock if they are going to deliberate tomorrow. And yeah, and if there's no verdict tonight, and if they back tomorrow, we'll just have verdict watch tomorrow. We'll watch some other videos as well. We'll watch some, I don't know, car chases and stuff. So yeah, that's what the plan is, rather than staying up. But you're actually right. Anna and Mary are right. Why do I just sit here? Do you know what I mean? Everyone's busy, so there we are. Well, that's what we'll do. We will come back tomorrow. If you know the verdict, please don't say what the verdict is in chat tomorrow morning. That's happened. If Gio used to do that a few times, say the verdict. It's like, okay, thanks, but now everyone knows. So we'll just come on and stream anyway. We'll put in verdict watch and just go from there. And Welshie, hope you come back, Welshie. Hope you come back and hope Emma's back here as well. So people are starting to leave. That's good. Thank you very much again. And with that, I'm gonna put my end screen on and close down. Thank you, people. Love you all. Thank you for all your work. Thank you, Sarah P. Take care, Chrissy. Look after yourself, my darling. I'll see you hopefully tomorrow. Everyone, take care. Love you all. Ta-ra.